Mr Hodge.
Commissioner, the witness for the first case study is Mr Regan.
Mr Regan in the room. If you'd come into the witness box, please, Mr Regan. If you go back. Mr Regan, would you prefer to be sworn or to make an affirmation? Take an oath or an affirmation? Which?
Affirmation's fine.
Affirmation.
Thank you.
Thank you.
I solemnly and sincerely
I solemnly and sincerely
declare and affirm that the evidence I shall give
will
be the truth,
the truth,
the whole truth, and nothing but the truth.
and nothing but the truth.
Do sit down. Thank you, Mr Regan. Yes, Mr Crutchfield.
Commissioner pleases. Now, Mr Regan, do you have an original of your witness statement with
We'd
you?
better have name, rank and serial number and all the Geneva Convention details first, Mr Crutchfield.
We'll do that, sir. Do you have it there, Mr
Yes,
Regan?
I do.
Yes.
Well, can we have his name?
Is your full name...
Yes.
could you tell the Commissioner your full name, please?
Anthony George Regan
And your business address?
is 33 Alfred Street, Sydney.
And your current occupation?
Group Executive for Advice in New Zealand for AMP.
Now, do you have with you the summons that you were issued by the Royal Commission to give evidence today?
So I do.
Do you have an original of that document with you?
Yes.
That's the summons?
Yes, I do.
That's the summons you were given, is that right, Mr Regan?
Yes, it is.
Commissioner, I tender the summons.
Exhibit 2.12, summons to Mr Regan.
And Mr Regan, you have your statement there, you've already said, I think.
Yes, I have.
Have you read your statement recently?
Yes.
I understand there's one matter that you want to update, and Commissioner, it's paragraph 335.
Yes.
Do you have that there, Mr Regan? If you go to paragraph 335 of your statement.
Yes. I have the paragraph.
Now, could you look, please, at paragraph 335B,
Yes.
and there's a statement in that paragraph, the charging of OSFs prior to certain customers going into the buyback pool, delete the brackets, or ignore the brackets for the moment, to date approximately, and you see that number there, 10,000,
685.
yes, is that number correct?
I believe it's been updated.
Yes, and what's your belief as to the updated number?
I don't believe I've been provided with that.
If you don't...
1,000 to 1,500.
About 1,000 to
I believe is the
1,500.
correct number.
And if you go over the page, you see the last sentence in that subparagraph. AMP estimates that approximately 1.06 million will be paid.
Mm-hmm.
Is that figure correct?
I believe that's been updated to 200 to 300,000.
All right. And look at paragraph C, please. You see the reference to the customers there, 3,108.
Yes.
Has that figure been updated?
Not that I'm aware of.
And what about the monetary sum in the second last line, 1.2 million?
Not that I'm aware of.
Are there any other amendments that you wish to make to your statement?
No.
Are you otherwise satisfied the contents of your statement are true and correct, Mr Regan?
Yes.
Commissioner, I tender the statement.
Exhibit 2.13, statement of Mr Regan.
And
just to
the
be
exhibits.
And its exhibits, just to be clear about this, Mr Crutchfield, do you propose to have the witness change what appears in 335B, or simply have his evidence amended in the fashion or amplified in the fashion you've indicated?
The latter, it's an update, yes.
Very well. Exhibit 2.13 will be the statement of Mr Regan.
Commissioner pleases.
Yes, yes, Mr. Hodge.
Thank you, Commissioner.
No, I need that one, yeah.
Mr. Regan, you're the Group Executive for AMP in relation to Advice and New Zealand, is that right?
I am indeed.
And you've been put forward by AMP as its witness to give evidence in response to a series of questions that the Commission has asked in relation to misconduct concerning fees for no service.
I have.
And you've only been in your present role since 1 January 2017,
That's correct.
but you were already a Group Executive of AMP at that time.
Yes, I was.
And as at 1 January 2017, the change was that Advice was added to your portfolio of responsibilities.
Broadly speaking, yes.
You were already the Group Executive for New Zealand?
Yes, I was the Managing Director for New Zealand and in that role part of the group leadership team.
I see.
But the title wasn't formally Group Executive.
I understand. And the group leadership team is also referred to as the GLT, is that
It is.
right? And the GLT reports to Mr. Mellor.
That's correct.
Mr. Mellor is the CEO of AMP.
That is correct.
And your immediate predecessor as Group Executive for Advice was Robert Caprioli.
That's correct.
But as you've indicated, you were already the Managing Director of AMP New Zealand, and in fact you've been at AMP for about 20 years, is that right?
Since the 30th of June 1999, I believe.
I see, almost 19 years. And the GLT, that also includes Brian Salter,
It does?
and Mr. Salter is the General Counsel for AMP,
Yes, he is.
and he's been in that role since about 2008.
That would be approximately correct.
And Mr. Mellor, in addition to being the CEO, is also the Managing Director of AMP,
That's correct.
and he was appointed as CEO in January of 2014.
I believe so.
And ultimately, the GLT is responsible for implementing the policies and strategies that are set by the AMP board.
Yes, they are.
And Mr. Mellor, as Managing Director, is a member of the board.
Yes, he is.
And the current chairman of the board is Catherine Brenner,
Yes, she is.
and she's held that position as chairman since June of 2016.
I couldn't recall that off the top of my head, but it would be very close.
All right. Now, I want to ask you some questions about AMP's advice business, just to lay out the structure of it. The advice business of AMP is comprised of how many licensees?
There are 4 main licensees, and there's a further, I'll say approximately 10 or so, but I'd have to go to the list to double check the absolute number.
Right, so are the 4 main licensees AMP Financial Planning Proprietary Limited,
Yes,
Charter Financial Planning Limited,
yes,
Hillross Financial Services
Yes.
Limited? You were the previous Managing Director of Hillross, is that right?
I was up until 2000 and the end of 2006.
The 4th is AMP Direct, is that right?
No, so the other main licensee would be what was IPAC, still partly trades as IPAC, but now part of a business we called AMP Advice.
I see.
You're going to have to keep your voice up, Mr. Regan.
So AMP Direct is a separate licensee?
Yes, it is.
And what is the function of AMP Direct?
AMP Direct, or what is otherwise known as AMP Assist, is essentially a contact centre style environment where we deliver responsive services to clients and provide other financial services, but typically a telephone-based environment primarily.
And how long has AMP Direct been in operation?
I'm not certain.
Was it in operation when you commenced with the business?
Yes.
Sorry, when you commenced as Group Executive
Yes.
for Advice?
Yes, it was.
Now, AMP has about 2,800 financial planners operating within its network,
Approximately.
and most of those planners are not employed by AMP or an AMP subsidiary.
No, about 90% are authorised representatives.
I see. And the other 10% are employed by, is it principally IPAC?
Yes, that's correct.
does any other licensee within the AMP group employ planners?
AMP Direct does have some employed planners, I believe.
Okay. And as you say, the vast majority then of AMP's planners are authorised representatives. Can you just explain what does that mean about the nature of their relationship with AMP?
So an authorised representative is typically a self-employed advisor as distinct from an employed advisor or representative. And so where someone is directly employed in an employment relationship with the institution, it's not anything other than an employment relationship, whereas in the case of the authorised representatives, they're licensed by the licensee. In our case, the ones that you've mentioned predominantly cover the range of authorised representatives, and they typically then have their own businesses. They're self-employed, but it's the case that they will also employ advisors themselves, but those people will also be known as authorised representatives.
Can we just break that down a little bit? There are authorised representatives that are companies.
There are corporate authorised representatives, so
Yes.
they are entities, yes, corporate entities.
And they might be an authorised representative of an AMP subsidiary, like AMP Financial Planning.
That's correct.
And in turn, that corporate authorised representative might employ representatives.
That's correct.
And the number of approximately 2,800, does that include representatives who are employed by a corporate authorised representative?
Yes.
Okay. So the 2,800 financial planners might be self-employed authorised representatives. That's one possibility.
Mm-hmm.
So you just need to say yes or no.
Yes.
They might be employed directly by an AMP licensee in limited circumstances.
Yes.
And they might be representatives who are employed by a corporate authorised representative.
That's correct.
And are authorised representatives commonly referred to as ARs within the AMP business?
That's correct. They would.
And the authorised representatives or the representative of a corporate authorised representative will enter into an agreement to provide financial services to a client.
Yes.
And the services that are going to be provided by the authorised representative are a matter for negotiation between the authorised representative and the client.
Yes, that's correct.
And also then the price that's going to be charged for the services is a matter of negotiation between the authorised representative and the client.
That's correct.
And that would include whether or not the services are to be provided on a one-off basis or an ongoing basis.
Yes.
And if the services are to be provided on an ongoing basis, then there are specific legislative requirements that apply.
Yes, that's correct.
And one legislative requirement is that the authorised representative must provide a fee disclosure statement.
That's correct.
And another legislative requirement is that the authorised representative must provide a fee renewal notice every 2 years to the client.
That's correct.
And if the client doesn't opt in to continue the services and continue paying the fee, then the fee has to stop.
That's correct.
And a very common way in which ongoing fees are paid to an authorised representative is by an automatic payment from a particular product.
Yes, that would be a typical method.
It's unusual for an authorised representative to be directly invoicing a client for fees for service.
I don't have any data to sustain the proportionality, but it would be far more common for it to be drawn in the manner that you outlined.
And so one way, as an example, that might happen is that the financial planner might suggest to the client who wants to invest some money that that money should be invested through a platform.
Yes.
And the client's money would be effectively transferred onto the platform or into the platform.
Yes.
And then the advisor would cause that money to then be dispersed or invested into various, for example, a managed fund or some other investment product through the platform.
Yes.
And the platform would automatically deduct an amount from the client's cash balance on a regular basis and pay it to the authorised representative.
The payment would be through to the licensee, so all monies paid to the advisor must go through the licensee in the first instance.
I see. So the platform would deduct the money from the cash balance, pay it to whichever is the relevant AMP licensee, is that right?
That's correct.
And then the AMP licensee would then on-pay it to the relevant authorised representative?
That's correct.
And can you just explain to the Commissioner what is the process by which AMP checks whether its authorised representatives are issuing fee disclosure statements?
So the fee disclosure statements are issued to the clients. They're generated through business process. The authorised representative will then just ensure that they're passed on to the client. It's then up to the authorised representative, I believe, to ensure that those fee disclosure statements are then returned to the authorised representative within 30 days of the end of the disclosure period.
And I'm sorry, does this vary depending upon whether it's a fee disclosure statement or the opt-in notice, or is the process the same?
I'm not entirely certain of the detailed process around the opt-in notice, but the opt-in notice has a similar process in that it is a 2-year period, and then there is it has to be dispatched, I think, within 60 days of the opt-in date. I'd need to verify that, but it then needs to be returned within 30 days. There is a 30-day grace period after which, or during which time, all fees must be turned off if it hasn't been returned within that 30 days.
Does AMP have any process for checking whether its authorised representatives are sending out fee disclosure statements, sending out opt-in notices, receiving opt-in notices back?
Significantly through the audit program, we would test for that.
Okay, and could you just explain then what is the audit program that AMP is operating at the moment?
So we have a audit program which addresses the audit requirements across all of the authorised representatives, and that process is effectively risk weighted. So those advisors that are deemed higher risk are audited more frequently than those that are deemed lower risk, but typically advisors will be audited somewhere between 3 and 24 months on a rolling cycle.
Does AMP have any automatic process for checking whether an opt-in notice has been returned by a client?
I don't know the answer to that.
Right. Are you aware of any discussion within AMP about the possibility of automating the process of checking for the return of opt-in notices?
I know that we are looking at a number of projects to improve a lot of those business tasks, but I'm not entirely sure of the detail of your question.
All right. Now, I'd like to now ask you some questions about the buyer of last resort policy. Is that, it's often abbreviated as BOLR, is that typically pronounced as BOLR within the business?
Yes, it is.
All right. And you've exhibited a BOLR policy, which is tab 20 of your statement, or tab 20 of the exhibits to your statement, and the reference is AMP.6000.0007.0658.
Would you like me to go to that?
Yes, I think if you have that open,
Yes.
Mr. Regan. There is a screen next to you, Mr. Regan, if you wanted to look at it on the screen. It's up to you.
Oh, thank you.
I don't think you can flick. It's not an
not
iPad.
touchpad.
It's you only get to see what I want you to see, Mr. Regan.
Sometimes.
Yes. Well, we'll see. Sometimes we don't get to see anything that any of us want to see. Can I just ask you to explain in a very general way how the BOLR process works?
So the buyer of last resort is a facility offered, and if we talk perhaps specifically about AMP financial planning, because that's the relevant policy that you've got there, noting that there are various other buyback arrangements, but the AMP-FP BOLR arrangement effectively enables an advisor to have sale-back rights to AMP under certain conditions. Those conditions vary based on the tenure of the advisors. So, for example, generally speaking, you have to be with the business for at least 4 years before you have an entitlement to sell back. That will vary for those advisors who, I believe, have more than 15 years' worth of service, in that the notice period for those people will be shorter compared to the people that are only serving or have served 4 years. It's the case then that AMP will, based on various conditions that attach to the sale-back process, and that will go to, for example, the quality of files and a range of other indicators that AMP will then undertake to buy those clients back or that register back. It'll be for, generally speaking, an agreed value of approximately 4 times the recurring or ongoing revenue of the business, regardless of whether that is made up of commissions, as in grandfathered style commissions, or payments that relate to mortgages or indeed fees. And then typically the BOLR is then subject to some notifications. So the notification, I think, has to go in initially at 6 months, and then the application has to be made around 6 to 8 months from the date of expected departure.
Let me break down some elements of that with you. Is it fair to say that within the AMP network, it's an intention of AMP that it be possible to effectively sell books of clients?
That's correct.
And the books of clients might be sold by one authorised representative to another authorised representative of AMP. But if an authorised representative is unable to sell a book of clients to another authorised representative, then subject to satisfying certain conditions, AMP will buy that book of clients.
Correct.
And the BOLR policy sets out a particular method by which that book of clients is valued.
Yes.
And as you've said, typically it's valued on 4 times revenue.
That's correct.
And there's some adjustments, and we'll come to that
Yes.
in a moment. Now, the policy that's up on the screen is one that was effective as at the 1st of July 2012.
Yes.
And that continued to be the current BOLR policy of AMP financial planning until a new policy was brought in June of 2017.
I'm not entirely certain of that.
Well, if you look at tab 21 of the exhibits to your statement, that's the new policy.
I believe so. I just don't know whether there were any in between the two, that's all. I wasn't in the business at that time. I don't have first-hand knowledge. I'm not suggesting it's not. I'm just not certain that it is, that's all.
All right, well, we might come back to that. But there's been a relatively significant change between the 2012 policy and the 2017
Yes.
policy. And in a sense, one of the things that the 2017 policy tries to address is the problem of orphan clients and the charging of fees to orphan clients. Do you agree with that?
Certainly an updated policy, and it certainly looks to improve the arrangements for ongoing fee clients. Yes, I would agree with that.
Okay. Now, if we go back to this idea then of AMP buying the book of clients, is it fair to say a significant problem with that until very recently was that AMP had no capacity to be able to provide any service to those clients that it bought?
Yes, that's correct, where they are fee-paying clients.
Sorry, speak up. What did you say?
Where they're fee-paying clients.
Sorry, Is that suggesting you did have capacity to service clients who weren't fee-paying clients?
Commission-based clients.
You could provide services to commission-based clients.
In a limited sense, yes, because commission-based clients don't require the same degree of servicing.
I see, they don't really require any servicing, therefore it's possible to service them.
So the servicing is more reactive.
And is what that means that AMP had a telephone call centre that you could
Yes.
call into?
That's correct.
And that telephone call centre wasn't staffed by financial planners,
Generally, no.
so they couldn't actually provide financial advice.
That's correct.
It was a purely administrative call centre.
Service-based.
I'm sorry, I'm not sure what that means.
Well, providing services to those clients, so for example, checking balances or undertaking transactions, notifications of changes of address, things of that nature.
Yes. Administrative services rather than providing any advice at all.
That's correct.
And so when you say it was possible to service commission clients, that just means so long as they didn't require any advice, then AMP didn't have a problem.
That's correct.
The problem was all of the clients that were paying fees for advice.
That's correct.
And I just want to delve a little bit into the detail of the bowler policy. Can we go to page 9 of the policy, which is .0666?
So this is the July 12 or June 17
I'm sorry,
policy.
this is the July 12. I think we've got
AMP 6000 007 0658 at.
0666.
Thank you.
I think we've got the wrong document up on the screen. Thank you.
That was page 9?
Yes. That should be headed Approved Product and Services List.
That's correct.
And what this is explaining is that one aspect of the bowler policy as it applied under this policy was that you would only be paid the multiplier on revenue, or indeed paid anything for a client, if that client's products were on the approved products list.
I'm not sure I know the answer to that.
Well, if we pop out the paragraph that comes after the dashes that begins, bowler is not applicable to products that are not on the
Thank you, yes.
APSL. Do you agree with that?
Yes. Thank you.
And what's also explained is where a product is on the APSL, but the related platform is not an AMP financial planning approved platform provider, the combination is considered not to be on the APSL. Is that your understanding of how the policy worked? Or do you not have any understanding of how the policy worked?
I don't have a detailed understanding. I'm familiar with the policy itself, but in terms of operationalising the policy, I've never had any material role in operationalising the bowler policy per se.
All right. Well, you understand in any event the mechanics that we've talked about already of the idea of a platform and investment in a managed fund.
Yes, I have, yes.
And what this appears to mean is that if a client is invested through a platform into a particular managed fund, even if the managed fund is on AMP's approved products and services list, if the platform isn't, then bowler does not apply.
I believe that's what it says, yes.
And that means, for example, if a Platinum International fund is on the approved products list, but the client has been invested in that fund through Macquarie's platform, bowler won't be applicable.
I believe that's the case.
And that's because the platforms that are available on the approved product list of AMP are primarily limited to its own brand platforms.
As it was at that time, yes.
And can I suggest that creates a very strong incentive for the advisor or the planner to place the client onto a platform on the approved product list?
Yes, noting that that was 2012.
Well, it was you're not accepting, are you, that this remained the policy up until 2017?
I'd have to check the policy to be able to confirm that.
Well, if you go to paragraph 100, or if we bring up paragraph 155 of your statement.
The question didn't make it clear when he was talking.
And can we pop that out? See, this version of the bowler policy was current until it was superseded by a revised bowler policy dated 1 June 2017.
Yes.
That was your evidence. Is that still your evidence?
Yes, it is, but does that not say that it was superseded by the revised policy on 1 June?
On 1 June 2017. So we agreed
Yes.
this is the policy that applied from July 2012 until the end of May 2017?
Yes.
Okay.
Sorry, it might have been at cross purposes.
No, that's
You
fine.
earlier said to me that you weren't sure whether there was any intervening policy. Are you now sure that there's no intervening policy?
I'm not sure, Your Honour, no.
Well, you see, you've said that what's in your statement is true. I read your statement as telling me there was a policy as at 1 July 2012, and then there was a change of policy at 1 June 2017, and I read it as saying there was nothing in the middle.
And I agree with you on having reread it.
Do go on.
Thank you, Commissioner. And are you aware, Mr. Regan, of what proportion of the platforms available on the AMP approved product list are own brand platforms?
Certainly the vast proportion.
All right. Can we go back to the 2012 bowler policy? That's tab 20 of Mr. Regan's, of the exhibits to Mr. Regan's statement. And can we go to page 28, which is the page ending .0685. Now this sets out the method of valuation that was used in order to determine the value of a book of clients. Do you have any familiarity with this method, Mr. Regan?
Not particularly, no.
Okay.
So I'm familiar with the policy, I've read through it, but as I said earlier,
All right. Well, your general understanding is that 4 times revenue is paid.
yes, that's correct.
You see in the formula that the way in which that seems to be broken down principally is that there's 4 times base ongoing commission,
Yes,
and then there's 1 times fee for service.
yes.
And perhaps a little confusingly, base ongoing commission also includes fee for service. Are you aware of that?
Fee for service is in the other part of the calculation.
Well, you recall we talked about the 2 ways in which fee for service could be charged to a client. One is by the advisor or planner directly invoicing the client, and the other is by the fees for service being automatically deducted from a product.
Yes,
And if we go to page 29 of the policy, which is the page ending .0686, and first we blow up the section or the row which begins 1 times fee for service. You see a 1 times multiple will be applied to regular invoiced fee for service revenue earned by the practice in the past 12 months.
Yes.
And then if we blow up the row beginning 4 times base ongoing commission, and you see their actual ongoing commission rate for all policies classified as new book, the AOC rate will reflect the actual advice fee deducted against the policy in the 12 months prior to the valuation.
Yes.
So you understand, looking at this now, as I pointed out to you, that base ongoing commission in this formula actually includes fees for service that are automatically deducted from a product.
Yes, I think that's the case.
And if we go over to page 30, which is the page ending .0687, and blow up the second paragraph from the top beginning actual ongoing commission, and that also accords with what we're talking about, that actual ongoing commission includes ongoing planner service fees, ongoing member advice fees and plan service fees from the product.
Yes.
And so, for example, if a client is invested in a platform and the platform is automatically deducting the fee for service and paying it first to the licensee and then the licensee is paying that to the authorised representative, that automatic deduction is part of actual ongoing commission.
I believe that's the case based on that, yes.
Now, one of the things that you've said in your statement is that the intention when a client was moved into the bowler pool was that the ongoing fees that they were paying would be dialed down to just product commission.
That's correct.
That's your evidence and what you understand was the intention with respect to the policy.
Yes.
As we've seen, though, in the bowler policy, at least as it applied up until 1 June 2017, ongoing commission was defined to include fees that are being automatically deducted from a product.
Yes.
Do you know whether when the fees are being dialed down, they are dialed down to just strict commission or to what is product commission as defined by the bowler policy?
I understand it would be dialed down to just commission.
Right, are you certain about that?
No, I'm not entirely certain.
Okay. And one of the issues, if that was to occur, one of the issues that would create is that AMP would buy the book of clients from an authorised representative at 4 times the product commission, including the ongoing fees. So that's the first part. You agree with that?
Yes.
But then those fees would all disappear, and when AMP came to sell the book, it would no longer be able to sell a capitalised version of those ongoing fees.
That's correct.
So that effectively every time AMP bought back a book of clients under the bowler policy, it would lose money.
That's correct.
And because, well, I'm sorry, I'll withdraw that and break this down. From 2010, AMP tried to get ahead of the game and switch its authorised representatives over to ongoing fees rather than product commissions. Is that right?
I believe so, yes.
And so even by the time we reached 2013, a substantial amount of the revenue stream that was coming from clients of AMP authorised representatives was coming in the form of fees for service rather than commission on products? Or you're not sure?
Not substantial.
Certainly then, let's do it another way, by 2016, the substantial or a substantial amount of the fees being received in respect of clients of authorised representatives of AMP was fees for service rather than commission.
It only really turns on what you mean by substantial, but I would gather it was certainly around 30%.
Okay.
if we were to try and approximate.
And that's by 2016, is
Yes.
that right?
Yes,
And so the other 70%, that's still grandfathered commission, is that right?
that's correct.
Okay. And so when you do the dial down, you would only be dialing down the 30%, you wouldn't dial down the 70% of grandfathered commission.
That's
that right?
correct.
Okay. But in any event, there is a disparity that is created by the bowler policy if you can't keep the fees for service going on.
That's correct.
And if we then move to the next topic, which is a summary of the types of fees for no service issues that have arisen for AMP, you've identified in your statement 2 types of fees for no service issues that AMP has.
Yes,
One of those, well, the first type is a fees for no service issue at the advice licensee issue.
that's correct.
And the second type is a fees for no service issue at the advisor level.
Yes,
And the charging of fees for no service by advice licensees arises in relation to what are sometimes referred to as orphan clients.
that's correct.
And in AMP's case, every client that goes into the bowler policy is an orphan client,
Typically, yes.
because an orphan client is one that doesn't have a financial planner
That's correct.
allocated. And in addition, orphan clients have arisen in other ways for AMP. One is AMP terminated some advisors for cause,
That's correct.
and the problem was that AMP provided no services to the clients of those advisors but continued to collect fees from those clients.
That's correct.
And that was the subject of a breach report by AMP to ASIC on the 3rd of May 2017.
I think that's correct.
And that was actually, well, you can satisfy yourself based on your own evidence if you want, Mr. Regan. You refer to this at paragraph 136.
I'm
of your
aware of the
statement.
breach, just the
The
connection
date.
with that, the date, yes.
I say, and you might be confused too, because in fact, AMP gave 2 breach notices on that day to ASIC about fees for no service. You're
Yes,
aware
that's
of that?
correct.
And the second of those breach notices was in relation to ring fencing.
That's correct.
And ring fencing is another variation on how orphan clients could arise for AMP,
Yes,
which is AMP would be buying back the register of clients, but not actually putting those or that register of clients into the bowler pool.
typically with ring fencing, it was expected that there would be a sale from an exiting to an acquiring advisor, and the register was essentially held under those terms to enable that transaction to take effect.
Can we just break that down a little bit? What you're talking about is, at the time that the sale of the clients to AMP occurred, it was in some cases hoped, in some cases expected, that it would be possible to very quickly on-sell those clients to another authorised representative,
Yes,
and that the desire was to sell that entire book or register of clients in whole to that other authorised representative.
generally, yes.
But the authorised representative wasn't in a position to buy those clients on the day that the transaction took place, or the purchase by AMP
Yes.
took place. And it might be that AMP anticipated that in a few weeks' time it would be able to sell the clients. It might be that it just had a hope that at some time, some unknown time in the future, it would be able to sell the clients.
Typically with ring fencing, there was an expected transaction to occur.
Okay. But not necessarily a date of that transaction.
That's correct.
And so the clients would be ring-fenced, meaning they don't go into the bowler pool, but they keep paying fees,
That's correct.
even though nobody is providing them with any services.
That's correct.
All right. And that was the second breach notice that AMP gave to ASIC on the 3rd of May 2017.
Yes.
Now, on the other hand, the charging of fees for no service by advisors is simply that the advisor doesn't provide any services to the client, even though the advisor is contracted with the client to provide the services.
Yes, they will be receiving a payment, but haven't provided the services in those instances where that occurs.
Or AMP is probably receiving the payment, isn't it?
That's correct.
And then remitting that
That's
payment
correct.
to the planner. But the planner isn't actually providing the services.
That's correct.
Right. And the only way that AMP would pick that up is by doing an audit of the advisor's practice.
Generally, yes.
What's the other way that it could pick it up?
It may be as a result of a complaint from a client, for example, but generally speaking, we didn't have systems in place to monitor those payments.
Okay. Now, I want to then move to another topic, which is your recognition of problems in the business on your appointment. Upon your appointment as the group executive for advice, it became apparent to you that there were significant problems with the governance and oversight of AMP's advice business.
Yes.
And one of the things that alerted you to this was that ASIC had issued 112 notices to the AMP group in 2016 seeking production of documents.
That's correct.
And of those, 85 notices went to AMP Financial Planning,
Yes, that's correct.
just the one licensee.
That's correct.
And ASIC had also required 18 current and former AMP employees and AMP Financial Planning planners to attend compulsory examinations in 2016.
I haven't got the number in front of me, but that sounds correct.
And do you know, were all of those people connected with the advice business?
I couldn't be certain. They would be in some form or another related to the advice business, yes.
Okay. And that was apparent to you as at 1 January 2017 when you took over?
Not immediately, but I mean, progressively
Pretty soon.
through, yes. Yes.
And as we're going to see, the scale of the problem got worse.
Yes.
Now, one of the things that you've said in your statement at paragraphs 31 and 32 is that, and I'll break this down. First, ASIC issued a notice to AMP Financial Planning dated the 3rd of April 2017 requiring AMP Financial Planning to produce certain documents.
Yes.
Second, those documents were located over a period up until about the 20th of May 2017.
Yes.
Third, those documents were then brought to the attention of the AMP General Counsel of Dispute Resolution.
That's correct.
And what is her name?
Larissa Baker-Cook.
Thank you. And fourth, she in turn brought those documents to the attention of Mr. Salter,
That's correct.
the General Counsel of AMP.
That's correct.
And then together they informed you of the documents sometime before the 19th of May 2017.
I think it was perhaps, but we met on the 19th of May to discuss the documents.
And you met and discussed them on the 19th. And did Clayton Utz also attend that meeting?
Yes, I believe they did.
And we'll come in a moment to what happens after that. But what were the documents that had caused this issue to be elevated up to you?
There was a series of emails that were concerning in relation to the knowledge of approving the continuation of fees and comments that people had made about the appropriateness of that. Secondly, there was a document related, as I recall, to a particular project that was linked to the FOFA program of change. and there were emails related to specific legal advices suggesting or outlining particular advices in respect to the ability to charge fees under circumstances where the services weren't being provided. I can't recall if there are others, but they're examples of what we discussed.
All right, and I'll just ask you a few questions about that, and then no doubt we will come to some of these documents. The project document that you're talking about, was that a document that was prepared by Brian Magellan?
Yes, that's the document I'm referring to. And I think that was shown to us on the day.
I see. And the specific legal advices, are they internal legal advices from internal lawyers at AMP?
Yes.
Saying if you bring a client into Bowler, you have to turn off the fees for them?
The legal advices were related to particular instances where inquiries had been made of legal, for example, in relation to the ability to retain the fees without services being provided on an exceptions type basis.
Perhaps we'll do this by reference to some documents, but I just want to understand, was there some novel thing that you became alerted to as a result of seeing those legal advices? Some novel proposition?
The issue that was being canvassed was what's become known as the 90-day exception,
Yes.
if that's what you were getting at in terms of the novel.
I understand. Is it, was it and what you're referring to then is there were emails you saw which were effectively making clear there is no lawful basis for implementing what's referred to as the 90-day exception?
That is consistent with the advice, yes.
And when you saw that, were you already aware of the 90-day exception at that time?
The 90-day exception had been raised as an issue in relation to a matter that had been reported to ASIC.
Yes, it had already been reported at
That's
the end
correct.
of the previous year.
Yeah.
And the 90-day exception, as you've explained it, was an exception where fees would be left on in the bowler pool for up to 90 days after the client had been moved into the bowler pool. Is that right? Sorry, again, just because it's being recorded.
Could you repeat the question?
Yes, that the fees would be left on for a client for up to 90 days after the client went into the bowler pool. Is that right?
Yes.
Okay. And the legal advisors, internal legal advisors, said there's no lawful basis for doing that.
That's correct.
Did that come as a surprise to you, that there was no lawful basis for doing that?
No, it's not a surprise that it's not lawful.
It's just obvious, isn't it, that you
Yes.
can't charge somebody for 90 days for providing services that you're not going to provide. You agree with that?
That's correct.
All right. And so then, whatever the particular matter is, was something you then felt you needed to bring to the attention of the CEO?
Well, this is in the context of the meeting that Larissa, Mr Mavrakis, Mr Salter and I had on that day,
Yes.
where we became aware of these.
And what is it then that you are going to meet with the CEO to inform the CEO about?
To make him aware of those advices, to make him aware of the circumstances that we'd come across in relation to the legal advices, the other documents that I referred to, and so on.
Right, so you see in the middle of paragraph 32, you say the Group General Counsel and I then raised the matter immediately with the CEO.
Yes.
So just, if you can, just tell the Commissioner, what is the matter that you're referring to there?
This is the issue of being made aware of the legal advices along with the other documents that I referred to,
And,
and that there had been legal advice provided in that regard.
okay. So is the issue, I'm not trying to trick you here, Mr. Regan. I'm just trying to understand what it is that was so novel that struck you and Mr. Salter on the 19th of May. Was it that employees lower down the chain than you had been specifically advised that it was not lawful to continue fees for 90 days?
No, that matter had been dealt with previously, so the 90-day exception, as it was known, and in fact there was a direction to cease that in November of 2016.
Yes. So what was the novel point that had arisen that you felt you needed to immediately inform the CEO of?
That there was specific legal advice showing that people had approved some of these things against legal advice.
Oh, I see. That is, they'd been specifically advised it's not lawful to implement this 90-day exception, and they just went ahead and implemented the 90-day exception. And that was the point of particular concern.
That's correct. It had previously been described as an administrative oversight. What was different is that we became aware that it was a conscious business practice.
Now, that can't be right, because you already knew, as at the end of 2016, that it was a conscious business practice, didn't you? That was why you'd given another notice to ASIC.
It was identified as a commercial practice.
Yes. But that had already occurred as at the end of 2016.
Yes, that's correct.
Right. So was the novelty just to discover that this commercial practice had been, which you already knew about, had been implemented in the face of legal advice?
Yes, that's correct, I think, in part, yes.
Well, I'm not, again, I just want to understand, when you say the Group General Counsel and I then raised the matter immediately with the CEO, what is the matter that you are raising with the CEO?
So there was the specific issues in relation to the exceptions that had been approved without, what we understood to be against legal advice. But there was also as I recall, the practice proposition stream document which indicated that it might have been formally approved through a process.
I see.
And yes.
Okay.
So I did have something else, but I've forgotten.
That's all right. Do you need to think about it?
No, it's fine.
Okay. And then, in turn, that was raised with the board of AMP?
That's correct.
And ultimately then AMP commissioned Clayton Utz to provide a report?
That's correct.
And Clayton Utz was asked to investigate what was occurring in relation to the bowler policy and ring fencing?
Yes.
And also, I'm sorry?
Yes.
And also to investigate the reporting of these matters to ASIC?
Yes.
All right. Now, at paragraph 46 of your statement, we just bring that up. You make an apology on behalf of AMP?
I do.
And you say, I apologise unreservedly for the failings in respect of advice and service delivery to our clients and for the regulatory breaches which are discussed below. What are the regulatory breaches that you, on behalf of AMP, are apologising for?
The various breaches of the Corporations Act that have been incurred as a result of these practices.
Or do you know what specific breaches they are?
I don't have them to hand.
Okay.
Yeah.
Do you know whether before this moment, when you've said that AMP is apologising for specific breaches of the Corporations Act, AMP has acknowledged that it has actually breached the Corporations Act in relation to this conduct?
Yes, I think we accept that we have.
You think you have accepted that you have? I'll just show you your submissions on behalf of AMP. Can we bring up RCD.0001.003.0003? Have you read the submissions made by AMP to the Royal Commission?
I've read the witness statement and I've been through the various exhibits.
I see. Perhaps what we might do it by reference to is RCD.0001.0033.0041. Have you seen this document before, Mr. Regan?
Possible to make it larger.
Can we...
Thank
you.
I can't recall it from the attachment itself.
All right. Well, if we go to page 3 of that document, page 3 of 6. If you zoom in on there, you see this is the fees for no service, the licensees issue that you referred to.
Yes.
And you see what's said on behalf of AMP is the conduct involves possible contraventions of various provisions of the Corporations Act and provisions of the ASIC Act. Do I understand that you are now saying we should, or the Commissioner should ignore the word possible, that AMP acknowledges that there were contraventions of the Corporations Act by AMP?
No,
No. So,
I don't believe we've acknowledged that, we've admitted those as yet.
okay. So when you say you're apologising for regulatory breaches, what are you apologising for? What breaches?
Well, for example, we know that we have committed breaches in relation to retaining fees on client accounts where fees have been charged where they shouldn't, and we know that that is a breach. So that is a breach of our licence condition, and that's what I'm apologising for.
I see, you're apologising for breaching your licence
That's
condition?
correct.
And what is the particular condition that you're apologising for breaching?
That which relates to our inability to charge those fees where otherwise the services aren't being provided.
Well, that's not a licence condition of your licence, is it?
I believe we have to act honestly, efficiently and fairly.
All right, so are you acknowledging, is AMP acknowledging that it has failed to act honestly, fairly and efficiently in relation to the charging of fees for no service?
Yes, we have.
Okay. Sorry, when you say yes, we have, are you aware of ever having done it before now, this very moment when you've done it?
Yes, I'm uncertain.
All right. If you look at, I'm sorry, do you know what the statutory source is of the obligation to act honestly, fairly and efficiently?
Corporations Act.
You know it's section 912 capital A 1A of the Corporations Act?
Not exactly, but Sounds right.
Take my word for it.
Yeah.
And you see, if you go back to the submission that it's in front of you, what's said is the conduct involves possible contravention of, and then one of the sections is 912 capital A 1A.
Yes.
So I just want to be fair to you. The submission that has been made by AMP to the Royal Commission is that it's possible that it might have contravened this section.
Yes.
Are you changing that position? No. Okay. So we can eliminate then that you're apologising for a breach of the requirement to act honestly, efficiently and fairly. What else are you apologising or not apologising for?
So we did issue a breach notice, which is acknowledged as part of what we laid out earlier. So you go back to the breach notices, the 5 breach notices that relate to the charging of fees under circumstances where that wasn't permissible.
Sorry, you've issued a breach notice. Is it your understanding that by issuing a breach notice you're admitting a breach of the statutory obligation?
I'm uncertain of that.
Okay.
Yeah.
You know, and we're going to come in some detail to the fact that AMP did not notify ASIC in relation to these potential breaches. You know that there was a significant delay in giving notification to ASIC and that a number of the communications given to ASIC were false or misleading.
That's correct.
And are you apologising for some misconduct in relation to that?
Yes.
Okay.
Yes, we are.
Again, if we go then to page 4 of 6 of that table, and can we blow up the last row? You'll see what was said in that submission was there was possible misconduct in relation to the extent and nature of AMP's reporting to ASIC in relation to fees for no service licensees. Can the Commissioner now take it that the word possible no longer applies, that you are acknowledging on behalf of AMP that there was actual misconduct?
I'm uncertain.
All right. Doing the best you can, when you say in paragraph 46 of your statement, on behalf of AMP, I apologise unreservedly for the failings in respect of advice and service delivery to our customers and for the regulatory breaches which are discussed below, what is it that you are apologising for?
For the failure to deliver those services to those clients.
Okay, so that's the first part of the statement. And in relation to the regulatory breaches which are discussed below, do you know what it is that you're apologising for?
Well, does my friend mean the facts or the legal conclusions? Because there's a significant difference, and this gentleman's not a lawyer, so I think it's leading to some confusion with respect.
Well, Mr Crutchfield, what am I to do about the fact that this is his statement, paragraph 46? What am I to make of it? I thought that's what counsel was exploring.
Yes, sure, but Mr Regan's already said he had nothing to do with the preparation of the submission to the Commission, and that document contains legal conclusions, and it's manifest this witness is not in a position to do
Mr Hodge was examining the witness about the content of paragraph 46 of his statement. Is there any difficulty about that?
Absolutely not.
No, do go on, Mr Hodge.
Thank you, Commissioner. When you say, Mr Regan, on behalf of AMP, I apologise unreservedly, relevantly, for the regulatory breaches which are discussed below, what are you apologising for?
I'll have to take that on notice.
Afraid that's not really how it works. Is the answer you just don't know?
Yes, I'm uncertain.
Was this apology agreed to by the board of AMP?
This is my witness statement.
Did the board of AMP, as far as you're aware, resolve to make an apology?
No, I didn't seek their approval to make the apology.
All right, and they didn't authorise you to do so?
Well, I'm authorised to give the witness statement.
Was the apology something that was, to your knowledge, discussed by any committee of AMP?
Not that I'm aware of.
Was there anybody else employed by AMP who was involved in the drafting of your statement?
Yes.
And who was that?
Our legal team.
Okay. Was Mr. Salter involved in the drafting of your statement?
He would have been, he certainly was familiar with the statement. Yes, he was involved with the statement.
Right. Was Mr. Mellor involved in the drafting of your statement?
Mr. Mellor has seen a draft version of the statement, I believe.
Right. Did he provide any comments on your statement?
Yes, I believe he would have.
Was Ms. Brenner involved in the drafting of your statement?
I'm not aware that she was.
I'd like to move now to a different topic, Mr. Regan, and as you know, Clayton Utz reviewed many documents for the purposes of preparing a report for AMP.
Yes.
Have you looked at the documents that Clayton Utz reviewed?
Not all of the documents, I don't believe, no.
But some of them?
Yes.
Okay. Now, the first time AMP gave a significant breach notice to ASIC in relation to orphan clients was in 2009. It's not a trick. We'll bring up the document. It's AMP.9000.0001.1460.
I believe that's
Sorry,
correct.
what was the number, Mr. Hodge?
I'm sorry, it's
9000,001.
.1460.
Thank you.
And it's actually an exhibit to your statement, Mr. Regan. It's tab 33 to your statement.
Thank you.
So this is a notification given pursuant to section 912D on the 15th of January 2009.
Yes.
And you're familiar with it, obviously? You've looked at it, you've exhibited
Yes,
it to your
I have
statement?
had a look at it, yes.
And it gives notification that clients were being charged an additional fee for service where what they were paying was dialed up above base commission,
That's correct.
and that when they were then, when the advisor or planner left and the client was transferred either to another planner or alternatively into the bowler pool, that they continued to be charged this dialed up commission but no services were provided to them.
Yes, I understand that's the basis of the breach.
All right. Well, that was the notification that was given
Yes.
in 2009.
Yep.
And what's explained as to the reasons for this was that there was an absence of adequate monitoring arrangements. We see that on page 2, which is 1460_0001. You see there was an absence of monitoring arrangements in place to ensure that this activity was followed.
What was that number again?
Now, if you just look about 2/3 of the way down the page, do you see the sentence, there was an absence of monitoring arrangements in place to ensure that this
Yes.
activity was followed?
Yes.
And what AMP said it was going to do, and we go to page 4, which is _003, was to put in place detailed processes relating to the adjustment of additional fees when a client's servicing rights are surrendered back to AMP-FP under a bowler arrangement. You see that?
Yes.
And ensure relevant staff receive training on the new procedures. Again, just because it's being recorded, you'll need
Yes.
to say yes or no. And then you see the third thing was to put into place monitoring controls in our risk and control system covering compliance with the above mentioned process.
Yes.
And you're obviously aware of this document, you've looked at it, you've exhibited it to your statement. Have you gone back to try to understand why since 2000, or whether and to what extent since 2009 any of those three things occurred?
I wasn't obviously in the business for a lot of that period of time, but that said, we've obviously had other similar breaches since then. I believe in 2013 and 2015, so this has occurred on a number of occasions. What we have done in more recent times is implemented a number of reviews to try and investigate, to put improvements into place in relation to these types of controls.
We should be clear about this. This problem has been occurring continuously at AMP since 2009, hasn't it?
Yes, that's correct.
And my question was, have you gone back to look at the extent to which there was an attempt to do any of these three things?
No,
Okay.
not specifically on those, no.
All right. Now, you agreed with me that the problem had been occurring continuously since 2009. To make good that proposition, can we, I'm sorry, Commissioner, no, I don't need to tender that document. To make good that proposition, can we go to document AMP.00094.4475? And you'll see this is a chain of emails from 2011, Mr. Regan.
Yes.
It's 2 pages long. Can we bring both pages up on the screen? Thank you. Is this a document that you've looked at before now?
Yes.
Okay. And so you know, if we go to the first email in time, which is one sent by Anne Singh on the 7th of January 2011, that she has raised an issue, which is when we buy back a partial or full book from a financial planner, which is Bowler, one of our processes is to request the removal of any fees that were dialed up by the previous planner above the standard fee. In 2008, we identified that this had not occurred and lodged a compliance breach. And then it goes down and says, under the heading issue, we have now identified that there are gaps in the process. So that was how this kicked off.
Yes, that's correct.
And then over the page, an email is then sent by Ms. Snedden to Mr. Guggenheimer and Mr. Helmick, saying, just wanted to give you a heads up on this issue. And a draft ASIC letter has been prepared by Group Risk and Compliance, and this is currently being reviewed by legal. You see that? And oddly, the response from Mr. Guggenheimer is, Deb, I'd like to challenge the notion of this being a breach. It's not an AFSL requirement, it's a business rule. Happy to chat about it if you need any context to help discussions with legal.
Yes.
And as it turned out, no breach notice was ever given to ASIC in 2011 in relation to this.
That's correct.
Do you know why no breach notice was given to ASIC in 2011?
As I understand it, there was a decision taken based on legal advice not to issue the breach notice.
Who made that decision?
I'm uncertain of that.
What is the basis for your belief that somebody made that decision?
I've been advised of that.
By whom?
Miss Baker Cook, I believe.
Okay. Was she in the legal department at that time?
No,
I see. So she's been told by somebody else?
that's correct.
Is there any record kept within AMP as to the decision making or the making of decisions about whether or not to give a breach notice?
There is, yes. I don't know the history of it, but certainly there's a breach committee process which is documented today.
What was Mr. Helmick's role at that time?
Mr Helmich, I believe, would have been in a role responsible for all of the advice licensees at that time. I can't recall the title, but it would be a role of that nature.
Is it the practice now of AMP to document a decision as to whether a breach notification is or is not given to ASIC?
I'm not familiar firsthand with the process. I'm not part of the breach committee process.
And it's fair to say, isn't it, the problem of charging fees to clients sitting in the bowler pool continued to be an issue in 2013?
Yes, that's correct.
And I'm sorry, Commissioner, I should tender that document.
Exhibit 2.14 will be emails January 2011 concerning approval of dial-up fees for bar of last resort AMP 0001 0094 4475.
Thank you. Now, Commissioner, Mr Regan, I'll show you now a document which is AMP.0001.0092.7314. Now you'll see this is a program steering committee pack from the 6th of May 2013. Are you familiar with exactly what the structural arrangement was in 2013 in relation to this program steering committee?
I believe Mr Mellor was the chair of that committee, and a number of the attendees would have been members of that steering committee.
And was the aim of the committee, or was the purpose of the committee, to get AMP ready for the changes that were about to come under the Future of Financial Advice amendments?
I believe so.
All right. And as you said, Mr Mellor, who is now the CEO, is the chair of the committee, and you're saying you think the attendees listed there were the other members of the committee?
I'm not entirely sure of the composition of the committee, but I'm sure it would be from amongst those attendees.
All right. But in any event, we can see there that Mr Caprioli, your predecessor, was an attendee at that meeting.
Yes.
And if we go to page 7326 of that document, you'll see this is a memorandum to the committee from Mr Himmelhock. What was Mr Himmelhock's role at that time?
I'm uncertain of his title, but I'm sure it's in one of the documents there.
All right. Well, in any event, if we bring up, can we bring up next to that page 7330? And can we blow up the paragraph about 2/3 of the way down the page, beginning with respect to our orphan books? So this is a report to that committee explaining that, as at that time, our initial analysis indicates that there are quite a number of accounts with dial-ups and other ongoing fee arrangements in place. And then it goes on to say, once data accuracy in this area is confirmed, we will be making a recommendation to the PPSC, that's the steering committee, in relation to options. For example, either dial all fees back to the base level commission or establish a servicing arrangement with the client.
It's a different committee though. So the recommendation is to the Practice Proposition Steering Committee, not the one that's referred to in this document, or that this document's a subject of.
Well, this is a report to the Program Steering Committee, isn't it?
That's correct.
And the Program Steering Committee is the one chaired by Mr Mellor.
Program Committee is, that's correct.
So the report at this time that's being made to the program steering committee is, part of it is, we've identified that we're still charging fees to orphan clients sitting in the bowler pool. And they'll be making a recommendation to, as you say, the PPSC, which is a different steering committee.
That's correct. It's a subgroup.
And that's a subcommittee under this overarching committee
Yes.
chaired by Mr. Mellor,
Yes.
as to what exactly it is that's going to happen or how this should be dealt with.
Yes.
All right. Can I tender that document, Commissioner?
Exhibit 2.15 will be Future of Financial Advice Program Steering Committee, PAC 6 May 2013, AMP 0001 0092 7314.
Now, I think we've agreed about this already, but I'll just confirm this with you, Mr. Regan. The obvious problem with charging fees to clients that are sitting in the bowler is that they're not receiving any services.
Yes.
And certainly from your perspective, there's no dispute that there was no capacity of AMP to provide services to the client sitting in the bowler pool.
That's correct.
That's something that very recently AMP has attempted to address.
There have been attempts to do servicing of clients for that purpose in the past, as I understand, but we are undertaking a program now.
Now, there was a lot of internal legal advice, which I think you've already referred to as being concerning, that charging clients in the bowler pool for services that they could not possibly be receiving was unlawful.
Mm-hmm.
Again, just because it's been...
Yes.
And I think you've agreed with me that advice, when you saw it, didn't come as a surprise to you.
That's correct.
It's obvious that it's not lawful to be charging somebody for services you're not providing.
That's correct.
All right. Can we just, to understand the extent of this advice, can I show you first AMP.0001.0016.7990? Now, this is an email from Tom Galetta, who was a solicitor at AMP at the time the email was sent.
Yes.
And the email's not dated, but Clayton Utz have identified it as being sent in approximately 2010, which is at paragraph 71B of their report. Can I just ask that the middle section of the email be blown up, which begins, if you want to maintain the plan of service fee?
Mm-hmm.
Where what Mr. Galetta says is, if you want to maintain the plan of service fee, you need to provide the client with the services that the former planner agreed to provide and the client agreed to pay for, which you and I have already agreed is an unsurprising proposition. Can we just agree on the reasons for that? The first is, obviously, as a matter of contract, that's what's been agreed between the planner and the client.
Yes.
That this is what will be provided and what will be charged for it. The second is, you understand that as a matter of statutory obligation, a licensee cannot be charging for financial services that it either intends not to provide or knows are not to be provided.
That's correct.
And the third is, can I suggest, just a matter of basic ethics and morality, that you would not be charging for something that you know you're not going to provide.
I agree.
You agree? And then Mr. Galetta suggests as an alternative in the next paragraph to be upfront with the client and to effectively say to the client, we're now going to provide something different to you. That alternative, being upfront with the client, wasn't a plan that was taken up by AMP.
Mm-hmm. Yes.
Do you agree? I tender that document, Commissioner.
Exhibit 2.16, email letter to Steinthal. Could I date it approximately 2010?
Yes, Commissioner.
AMP 0001 0016790.
Thank you, Commissioner. So that's legal advice dating all the way back to 2010. What happens in 2015 is that AMP begins an internal investigation into the charging of fees for no service to the client sitting in the bowler pool. Is that right? In 2015?
This is in relation to the breach notice lodged?
Yes, before the breach notice
Yes.
is given, an investigation
As
is
I
commenced.
understand it, yes, that's the case.
And the reason that an investigation commences is because there was public reporting of ANZ having charged fees for no service.
I understand that was the trigger, yes.
Now, when that internal investigation begins, there are a lot of emails that pass between various people, in particular Mr. Morgan, Mr. Caprioli, Mr. Paff and Ms. Turner.
Yes,
And you're familiar with those documents?
yes, I'm familiar with documents, yes.
Can we bring up AMP.0001.0043.4407? Now, this is an email from Ms. Turner, who is the legal manager for advice. Is that
Yes,
right?
that's correct. Well, was that at that time?
And it's being sent to Wayne Marsh. What was Mr. Marsh's role?
I believe he was in a role that was involved with the buyback arrangements. His title, I'm not exactly sure.
Okay. And it's copied to Mr. Morgan, and it has an attachment, which is a document titled Ongoing Services Fees. Sorry, Ongoing Service Fees.
Mm-hmm.
Again, Mr. Regan, because it's being
Yes.
recorded, you need to say yes or no. Thank you. And Ms. Turner on the 19th of May is raising a concern, which is we have well past the 10-day reporting period, so I want to expedite the breach reporting decision.
Yes,
And if we go to the attachment, which begins at AMP.0001.0043.4408, so this is the document that Ms. Turner was attaching, and can we bring up on the screen 2 pages? The first is .4409, the second is .4410. And can we blow up the last paragraph of 4409 and put below it the first paragraph on 4410? So what's set out in the memorandum is that until 12 months ago, the business practice of AMP licensees was to leave ongoing advice fees in place in the expectation that advised customers would be placed with a new advisor. 12 months ago, AMP brought together all its licensee support infrastructure into single centres of excellence. An early commercial focus was to ensure that ongoing service fees on advised customers were immediately cancelled and the customer needed to renegotiate the ongoing fee arrangement with their new financial advisor. Are you aware of what the basis is for the statement that things changed 12 months before the date of this document?
no,
And you haven't seen anything that would suggest that there was some change in the middle of 2014?
I wasn't involved, but around the middle of 2014 was the implementation of FOFA.
No, that was the middle of 2013.
That's correct, that was the legislation effective date, yes. I thought there was a facilitative period, but
All right.
yep.
But in any event, as part of the investigations that have been carried out at your request and by people under you, you haven't seen anything to indicate some change in mid-2014?
Not
at
that I
AMP?
can recall.
All right. And what Ms. If we then go to page 4415, and can we blow up the line beginning when plans are required and include the comment next to it? So what seems to have happened is this paper was originally prepared by Mr. Morgan. Is that your understanding?
I'm not sure.
All right, but in any event, there was a paper prepared and then a comment made on it by Ms. Turner. You know that that comment is by Ms. Turner?
I don't know that it is.
All right. Well, in any event, what's set out is when plans are required under a licensee buyback, the current business rule is that advice and servicing fees be turned off within 3 months. And the comment is, this is a rule that has been set arbitrarily. There is no legal basis for the period of 3 months. This rule will probably need to be revised.
Yes.
Now, I realise I repeated this a number of times. That doesn't surprise you, the idea that there'd be no legal basis for 3 months.
That's correct.
And you wouldn't expect that to come as a surprise to any other senior executive in the business, would you?
I don't know whether I can speak for their mind, but, and it would depend, I imagine, on whether they've received legal advice.
You didn't need to receive legal advice to know that you can't charge somebody for services that you're not providing. You agree with that?
Yes, I agree with that.
And for example, you would expect your predecessor, Mr. Caprioli, to have the same understanding?
I can't speak for Mr. Caprioli.
All right. You're aware that the Clayton Utz report is at great pains to say that there is no evidence that Ms. Turner's email was provided to Mr. Caprioli? This email with the attachment?
Sorry, what was the question?
You're aware that the Clayton Utz report is at great pains to say that there is no evidence that Ms. Turner's email was provided to Mr. Caprioli?
Yes, I understand that's what it says.
And do you know why such an emphasis is placed upon the proposition that there's no evidence that this email was provided to Mr. Caprioli?
I don't know whether there was particular emphasis.
Do you know why? I'll withdraw that. Are you aware of any reason for Clayton Utz to make a particular point that there was no evidence that this email was provided to Mr. Caprioli?
I know that was part of the work that Clayton Utz did to establish who was given that legal advice. So I assume it's because of that.
Right. I tender that document, Commissioner.
Yep.
Exhibit 2.17, email Turner to Marsh and Morgan, 19 May 15, with attachment concerning ongoing service fees, BOLR and orphans.
Thank you.
AMP 0001 0043 4407.
And then there was a chain of emails between Mr. Morgan and Mr. Caprioli copied to Mr. Paff and Mr. Guggenheimer, which I'll ask be brought up. It's AMP.0001.0016.7288. You've seen this document before.
Yes.
And Mr. Morgan is emailing Mr. Caprioli, and he says that he understands Mr. Paff has already provided a high-level overview of the issue in relation to ongoing advice fees.
Yes.
And I'd like to blow up the dot points at the top of the second page if we can. Now, the first full point there, which is our historic business rule around retaining fees for 3 months since amended and allowing client registers to be ring-fenced for future sale, carries with it an inherent risk of the fees not being removed. Are you, or do you have any understanding as to what the supposed amendment was to the business rule that's referred to there?
Not in the specific, no.
Okay. But do you agree with me, what must be known to every recipient of this email is that there was a business rule around retaining fees for 3 months? That's the first thing.
Yes.
And also that there was some process in which registers were ring-fenced for future sales.
Yes.
And also that each of those things, the business rule and the ring fencing of registers, carried with it or with them an inherent risk of the fees not being removed.
Yes.
And that must be obvious, you would agree, to anyone receiving that email.
Yes.
I tender that document, Commissioner.
Exhibit 2.18, email 20 May 2015, Morgan to Caprioli and others, AMP 000100167288.
Now, Clayton Utz were asked to investigate 2 specific misrepresentations that AMP had identified that had been made to ASIC. You agree with that?
Yes.
And in addition, Clayton Utz identified a further 5 what they termed mistaken representations to ASIC by AMP.
Yes.
I want to take you through the false and misleading statements that AMP made to ASIC. Can we bring up first AMP.6000.0001.1469, which is tab 24 of Mr. Regan's statement? So this is the initial breach notice that was given by AMP to ASIC on the 27th of May 2015.
Yes.
And you're familiar with it, you've exhibited it to your statement.
Yes.
Right. And if we go to page 2, if we blow up first the first paragraph, you see the last sentence says, in the situation of this breach report, the services did not include the provision of personal advice by way of a review or any other scenario of personal advice.
Yes.
And that was untrue, wasn't it?
Yes, I believe it was.
Because, in fact, for at least some of these clients, their service that they were paying for did include personal advice.
Yes, reviews.
And then if we blow up the section headed protocols and the paragraph beneath it, and this says that internal protocols had been in place to turn off fees when a financial planning register had been purchased by an advice licensee. And then if we take that down and bring up the section under the issues, it says the processes between the advice licensees and the product administrators have failed in some instances. And that was the second false or misleading statement made in this notice to ASIC. the processes didn't fail, did they, Mr. Regan? There was a deliberate decision made by AMP to retain fees on some of these clients.
As I recall, I think it's both.
In some cases, there was a failure of process, but in other cases, it was a deliberate decision by
That's correct.
AMP. And AMP didn't tell ASIC that they had made this deliberate decision.
That's correct.
And then if we bring up the third page of the notice and blow up the last paragraph under timing of this notice, it says the issue was initially identified in AMP Financial Planning and Hill Ross about 1 month ago, and they are therefore reporting outside of the 10 business day requirement, as it has taken some time to identify if there actually was an issue. And that statement is completely false, isn't it?
Yes, I think it is.
So those are the first three false or misleading statements that AMP made to ASIC. Can we now bring up AMP.0001.044.2936? Now, this is a letter from AMP to ASIC dated the 19th of June 2017. So you'll need to say yes or no.
Oh, yes, sorry, I was waiting for... I thought the question was still going.
I'm just confirming this is,
Right.
that's what this document is. Have you seen this document before?
Yes.
And under the heading summary, you see it says, we are in the process of reviewing about 29,000 client files dating back to July 2010, where we have cause to believe our processes may have failed and fees not turned off. You see
Yes.
that? And do you agree with me that statement was also misleading because there was no reference or explanation that, in fact, in some cases, it wasn't a failure of process, it was a deliberate decision that had been made by AMP?
I have in fact asked for that matter to be investigated. I became aware of that wording and then I have asked the Chief Risk Officer to investigate the circumstances behind that wording and whether or not we have in fact taken that to ASIC and clarified that situation. I'm not aware of the status of that today.
No, but if you just listen to my question.
The answer to your question is yes.
Thank you. And then if we bring up page .2938, and can we blow up the section under number 3, fix the processes that failed? You'll see it says interim processes have been put in place to ensure no new clients are added during this remediation period.
Yes.
Can I suggest that was also misleading because, in fact, AMP was continuing with the 90-day exception and ring fencing at this time?
That's correct.
I tender that document, Commissioner.
It will be letter AMP to ASIC dated, Mr Hodge,
19th of June.
19 June 17, 0001 0044 2936.
Sorry, Commissioner, I think that's an error. I think it should be 15. We agree that should be
15 June?
19 June 2015.
Sorry, what?
19 June 2015.
15.
Thank you.
Sorry, 19 June 15, I know I'm innumerate. Exhibit 2.19.
Thank you. And then if we can bring up AMP.1.000.001.8517. This is a letter from AMP to ASIC dated the 31st of August 2015.
Yes.
And can we bring up page 2, which ends in .8518? And can we blow up the section under the heading Advised Customers? And you see in the second paragraph, from July 2010 to December 2013, the licensees allowed fees to continue for up to 3 months for a transition to complete. And then 2 paragraphs down, since January 2014, the commercial practice changed and fee arrangements have been cancelled immediately the licensee acquires the account.
Yes.
And that was just false, wasn't it?
Yes.
So that was the 6th false or misleading statement that ASIC had made up until this point in time.
But AMP had made to ASIC.
AMP, sorry, had made to ASIC. I tender that document.
Exhibit 2.20, letter AMP to ASIC 31 August 2015, AMP 1000-001-6517.
Thank you. Now, can I suggest to you the fact that this process, or the fact that the 3-month rule was still in application was, it's now turned out well known within the company?
Yes.
And I want to just understand, as you understand it at the moment, how high up that knowledge went. It certainly extended up to Mr. Guggenheimer.
Yes.
And Mr. Guggenheimer at the time was the managing director of AMP Financial Planning Proprietary Limited.
Yes.
And who did Mr. Guggenheimer report to?
Mr. Caprioli.
And Mr. Caprioli was the group executive for advice and banking at the time.
That's correct.
And is it your understanding that Mr. Caprioli was aware of the 3-month rule?
I'm not certain of that, no.
All right, well, we've seen already an email that Mr. Morgan sent that referred to this rule, although he does refer to it as a historic rule. Are you aware of any other document that might have alerted Mr. Caprioli to the existence of the rule?
Not that I'm aware of.
Are you aware of any document that might have alerted Mr. Mellor to the existence of the rule?
No.
Have you looked at the internal audit report in 2014 for
Yes, I
AMP?
have.
All right. Could we bring up AMP.6000.0006.4372? And that's tab 26, I believe, Mr. Regan, of your statement.
Yep.
You've obviously looked at it before.
Yeah.
And can we go to page 8 of that internal audit report, which is the page ending .4379? And blow up the section under the underlined heading ongoing fee arrangements.
Mm.
And you see there's an explanation that the introduction of the FOFA fee disclosure statement obligations has created additional considerations during the purchase and sale of client registers. selling planners are now required to submit an OFA, which is an ongoing fee agreement, listing which provides their clients' fee disclosure information and last fee disclosure statement issue date. Planners are also required to provide fee disclosure statements to clients where appropriate for a period of up to 3 months post the intended bowler execution date. This provides a grace period for AMP financial planning to dial down any ongoing client fees following a bowler transaction. Now that's a reference, isn't it, to the 90-day rule?
I'm not sure. I have inquired about that document. I am uncertain as to why that 3-month grace period is there.
Is it still there?
No, as in reflected in that document. So I don't understand the purpose of that reference. So the linkage of the 3-month grace period to the FDSs.
Sorry, you don't understand why the FDSs are linked to the 3-month grace period.
Yes.
But the audit report explains why that is, which is that by implication, so that you don't need to issue another FDS within the first 3 months of the client register hitting the bowler pool, that the selling advisor will have given an FDS that extends out. That's what it's saying, isn't it?
I'm not entirely certain.
Well, do you agree that this is plainly a reference to the continued existence of the 90-day grace period?
I'm not sure that it is.
What else could it mean?
I'm uncertain. I have inquired as to whether or not there is any linkage to that 3-month rule with the FDSs.
I'm sorry, what is it that you've inquired into?
The linkage between the 3-month grace period and the issuance of the FDS. So the question is whether or not that was to enable fees to remain on or not.
Well, let's break it down. It refers to a period of up to 3 months post the intended bowler execution date. You see that?
Yes.
And then it says, this provides a grace period for AMP financial planning to dial down any ongoing client fees following a bowler transaction.
Yes.
It's explicitly referring to the fact that fees might not be dialed down for up to 3 months after a client register hits the bowler pool, isn't it?
It could mean that, yes.
What else could it mean?
As it was explained to me when I asked the question, it could be to just set processes up, but it certainly could mean to dial those for that to be a grace period. Yes, I agree.
Who did you, when you say when it was explained to you, who explained it to you?
Just in terms of asking questions in respect of this with our legal team.
Your legal team explained it to you?
Yes.
That it might... Yes, go on.
So I agree that it could well be what you're suggesting it is, but I'm not entirely certain. And
you're aware of who the internal audit report was distributed to?
Yes, I am.
And one of those people is Mr. Caprioli, your predecessor?
Yes.
Another of those people is Mr. Mellor, the Chief Executive Officer?
Yes.
And have you asked Mr. Caprioli what he made of this statement in the audit report?
No.
Have you asked Mr. Mellor what he made of this statement in the audit report?
No.
Why not?
I don't believe we've discussed it.
Commissioner, what time did you propose to sit to?
Just teasing me, isn't it, Mr. Hodge? I had intended to go through till 4:15, but what do you want to do?
I'm happy to keep going.
I think, well, how are you going for time is the real question.
We'll be back tomorrow in any event, there's no doubt about that.
Oh, let's go on for another 10 minutes at least.
Thank you. Now, I think by my count, we just finished with the 6th false or misleading statement that AMP made to ASIC. Can we now bring up the document which is AMP.0001.0049.0708? We've skipped over one, Mr. Regan, out of order. This is a letter of the 17th of August 2015 from AMP to ASIC.
Yes.
And just give me one moment. And can we bring up page 0716? And you see, or if we blow up the the last lengthy paragraph on that page, beginning the breach dated 27 May 2015. And you see the sentence, requests were made to product issuers by the licensees to have service fees turned off. Through errors on the part of both the licensee and the product issuers, fees continued to be deducted after the servicing arrangement had come to an end. That was also a misleading statement, wasn't it,
Yes.
Mr. Regan? Because it excluded references to the intentional decisions by AMP
That's
to keep
correct.
the fees on. Thank you. I tender that, Commissioner.
That will be Exhibit 2.21, letter AMP to ASIC 17 August 2015, AMP 000100490708.
And then can we bring up AMP.0001.0017.3286? Now, this is a set of PowerPoint slides that was prepared for the purposes of a meeting with ASIC.
Yes.
And if we go to page 6 of that document, you'll see this is a template letter that ASIC was informed had been sent to customers.
Yes.
And about halfway down the page, it says, when we set up your financial products, we negotiated a plan of service fee in return for certain additional financial services to be provided to you. As AMP will no longer be able to provide you with all those additional services, the plan of service fee will be removed.
Yes.
Now, had those letters been sent to all clients, then that would have been a misleading statement to the clients. Do you agree?
Yes.
But in fact, even though ASIC was told that these letters had been sent to the clients, in fact, they weren't sent to the clients, or they weren't sent to all clients.
I understand that to be the case.
All right. So the further misrepresentation made by these slides was that AMP had been informing clients that it would turn off the fees. We go back to page 3, which is .3288. And you see the opening sentence says, various AMP entities self-reported the discovery of an administrative error where ongoing services were not turned off. And then under the heading background, the third point, when licensees purchase register rights, the normal process is for the ongoing service agreements to be terminated and the ongoing service fees to be turned off. Do you agree that that statement was misleading?
Yes.
Thank you. I tend to that, Commissioner.
Exhibit 2.22 PowerPoint. Is this the PowerPoint presentation?
Yes,
Yeah,
Commissioner.
PowerPoint presentation, AMP to ASIC, 17 September 2015, ongoing service fee remediation, AMP 0001 0017 3286.
And then can we bring up AMP.1000.0001.4754? And this is a letter from AMP to ASIC in response to a notice of direction under section 412 capital C. You see that, Mr.
Yes.
Regan? And if we go to page 3 of the document and we blow up the top half of the page, you see the administrative processes that failed are, and there's then various explanations about the failure of administrative processes.
Yes.
And again, you agree that was misleading?
Yes.
And that, by my count, is the 10th false or misleading statement that was made to ASIC. Now, it also says that the agreements were terminated and the clients were not entitled to receive fees.
Where are you reading from, Mr. Hodge?
I think it needs to go,
Might have to come out from the...
yes. I'll come back to that.
Yes.
Oh, I'm sorry, it's actually at the top. You see, therefore, the responses below relate only to the 6,963 formally advised customers of AMPFP whose service arrangement had been terminated before they were affected by the reported breach.
I'm lost.
I'm sorry, it's page 4758. Beg your pardon, it's page 5. If we go to page 5, got 4758.
Second paragraph.
I think I'm being told I should have stopped at 4 o'clock by this course of events, Mr. Hodge.
Well, Commissioner,
Let's get to the end of it and then we'll stop.
that's right. I'll tender that document, Commissioner, and
Well,
I'll
can we just
return to it.
find where this passage is? It's page 5, do you say?
Yes. Do you see the statement, Mr. Regan? Therefore, the responses below relate only to the 6,963 formally advised customers of AMPFP whose service arrangement had been terminated before they were affected by the reported breach. And that was incorrect, wasn't it? Because in fact, in many cases, their service arrangement hadn't been terminated.
Sorry, Mr. Hodge, I'm just not quite understanding it.
That's right. I'll tender the document, Commissioner.
Perhaps come back to it in the morning if we need to. Letter AMP to ASIC dated.
It doesn't have a date on the document, Commissioner.
Letter AMP to ASIC
It's
AMP 1000 0001 4754 will be Exhibit 2.23,
Thank you, Commissioner.
and we'll resume at 9:45 tomorrow.
Thank you.
I'm sorry, we're a little delayed, ladies and gentlemen. It's not only retailers that have IT issues. Mr. Regan, could you come back into the witness box, please? Do sit down, Mr. Regan.
Thank you.
Yes, Mr. Hodge.
Thank you, Commissioner. Could we bring up document AMP.1000.0001.4754? This is now Exhibit 2.23. Thank you. You'll recall this document, Mr. Regan. It was the one I was fumbling with late yesterday afternoon. Can we go to page 4 of the document, which is .4756? And, sorry, page 4 of the document. Thank you. And can we blow up the section beginning 6,963 formally advised clients together with the following 3 paragraphs? Now, you see, Mr. Regan, that this says no affected client during the period of the breach to which this notice relates had an entitlement to receive ongoing services. All arrangements in place before any client became an affected client had been terminated.
Yes.
And that was incorrect, wasn't it?
Could you just point me to the document, Mr. Hodge? Is that document a part of the...
You understand, Mr. Regan, that at the time that this correspondence was being sent by AMP to ASIC, a position that was being adopted by AMP was that the service arrangements with all clients were terminated upon them coming into the bowler pool. Are you aware of that?
Yes, where the fees were involved, that's correct.
Yes, and if we bring up page 5 of the document, which is .4759. Sorry, I beg your pardon, page 6 of the document, which is .4759. And you see the paragraph, if we blow up, which is under the bowler arrangements. Thank you. Under the bowler arrangements, once customer register rights are acquired, the AMP Advice Back Office team issues instructions to the AMP product issuer to terminate the fee arrangement. For fees collected on products issued by external product providers, clients were asked to notify the that provider to terminate the fee deduction. And then if you take that paragraph back down and blow up the paragraph beginning selling advisors of AMPFP. Selling advisors of AMPFP were required as part of the bowler process to issue to customers a letter informing the customer of the planned exit of the advisor, that the licensee would cancel fee arrangements on AMP-issued products, and that the customer was to contact external providers and instruct them to turn off ongoing fees. And so if we break this down, the position that was being taken at this time by AMP and its correspondence to ASIC was that when the planners sold their books of clients to AMP under bowler, the ongoing fee arrangements would terminate.
Yes.
This is, I'm sorry, this is as at the second half of 2015.
Yes, that's what I was just wanting to know. Is this a document as part of the exhibits?
Yes, it was tendered. This is the document you were looking at yesterday afternoon, Mr. Regan.
Yeah, is it in the exhibits, is my question?
In your exhibits?
Yes.
No, Mr. Regan.
Thank you. Thank you.
Perhaps we can, if you bring that back down and go to the
Yep.
first page, we can see what the document is.
Thank you.
Again. It's a letter sent in response to a Section 912C notice by ASIC on September 2015 with a due date of 17 September 2015, and that was then adjusted for a response time. And for whatever reason, this letter is not dated, but it's in response to the
Yeah.
September 2015 notice.
Could it be made a little larger?
Sure.
Thank you.
Which part would you like larger?
Oh, that's just fine. So has the date been redacted, or is it just not there?
It appears to not be there, but it
Right.
must have been sent on the 15th of, or about the 15th of October 2015.
I'll take the document on its face.
Well, you know it's referred to in the Clayton Utz report.
Yes, I don't have that to hand as we look at it, no.
All right, well, let's put the document aside for one moment. Are you aware that in the second half of 2015, AMP was taking the position with ASIC that when clients were sold to the bowler pool, their ongoing fee arrangements were terminated?
Yes, I think that's correct, Mr. Hodge.
And this document, as we've seen, makes that representation. You agree?
Yes, I agree.
And that representation was false.
Yes, I think that's correct.
Thank you. And this, in our count, is the 11th false or misleading statement by AMP to ASIC in respect of fees for no service. Do you agree?
Yes.
Can we take that document down and now bring up AMP.6000.0010.0008, which is also tab 35 to Mr. Regan's
Thank you, Mr. Hodge.
statement? And this is a letter of the 12th of June 2015. It's a letter from ASIC to Mr. Caprioli, and we've spoken already about what the position was of Mr. Caprioli. Can we blow up the section in the middle of that first page, which is examples of misconduct currently being investigated? And you'll see, Mr. Regan, that the first type of example listed is licensees charging clients for financial advice services such as annual advice reviews, generally under the client's service agreements with their financial advisors where the advice was not provided. You see that?
Yes.
And then we take that down, and can we bring up the next page, which ends in .0009? And you see what Mr. Caprioli was asked to do by ASIC, this is in the second paragraph, was provide ASIC with a comprehensive statement that sets out whether the conduct referred to in paragraph 1 above or conduct which had a similar client impact exists or has existed within AFS licences currently part of the AMP group that provide personal advice to retail clients. So that was what he was asked to do. You've seen this letter before, obviously,
Yes, I have.
because it was exhibited to your
Yes.
statement.
Yes.
Can we take that down and now bring up AMP.6000.0003.8310? So this is an external audit undertaken by PwC for AMP. You've seen this before?
Yes, I have.
And you'll see it's dated March 2015.
Yes, it is.
Thank you. Now, there's a few parts of this document that I want to ask you about. The first is if we go to page 8312, which is the second page of the document.
And I think it's in this fold. Could you tell me which tab? This
I
one, is
wasn't
it?
aware that it was in your folder, Mr.
Not in this
Regan,
one.
but if it
Apologies.
is, somebody will tell me.
Thank you.
you'll see that the external audit report was provided to Mr. Salter, the Group General Counsel.
Yes.
And the external audit report raises a number of issues about effectively compliance and monitoring of risks in AMP. Do you agree?
Yes.
And one of the issues that it raises is if we blow up the second bullet point, this is even just part of the summary, which begins process, that it explains that there are some key risk management frameworks and processes that are either not operating as designed or require updating to ensure that they meet ASIC's expectations and industry better practice. Examples of these include the 3 lines of defence framework, breach reporting and complaints management processes, as well as the techniques that are being used to monitor advisor network. Are you aware of what steps were taken in response to this report to address these issues?
Obviously, I wasn't involved in the business at that time. I know there was some work done, but I can't give you the detail of that, Mr. Hodge.
Right. And then can we bring up page Roman numeral 4 of the executive summary? It ends in .8319. Thank you. And can we blow up the second last and third last bullet points on that page? So the third last begins, incidents at AMP tend to be self-reported. All right, thank you. So one of the issues raised by the external auditors specifically was that, and I quote, incidents at AMP tend to be self-reported or identified serendipitously. The licensees are not taking proactive steps to identify trends and indicators that point to potential breaches. Furthermore, root cause analysis of incidents and breaches that are identified is not conducted, which means that potential systemic issues are not identified and similar issues are likely to reoccur as rectification is not fed into continuous improvement of processes, training and behaviour. Better industry practice incorporates both of these elements into their incident and breach frameworks.
Yes.
You've obviously looked at this before. Have you turned your mind to what steps, if any, were taken by AMP following this report to address the lack of any root cause analysis?
I'm not familiar with the work that was done before my arrival, but certainly, as I indicated to you yesterday, there's a program afoot to deal with a lot of this type of analysis.
All right. And then if we go back a page to the page ending .8318 and blow up the last dot point on that page, one of the specific issues raised by the external auditors was the 3LOD, which is 3 lines of defence model, is considered by ASIC to be the key governance, risk and control framework for effectively managing risk. However, it does not appear to be operating consistently and in the manner we would expect within AMP. Are you aware of what steps were taken immediately following that report to address the inadequacies in the 3 lines of defence model?
No, I'm not.
All right. And then can we go to page 38 of that document, which is the page ending .8353? And can we blow up point number 3 of the recommendations? Which begins conduct, thank you. So that the third recommendation made by the external auditors to AMP was to conduct root cause analysis of all incidents and breaches to determine whether they are indicative of systemic issues and so that lessons learned can be used for continuous business improvement. Mm-hmm. Are you aware of what steps, if any, were taken to conduct root cause analysis of all incidents?
I'm not first-hand, Mr. Hodge.
All right. Do you agree with me that on no view of this report could it be said that PwC was were saying that there were no systemic issues?
Not on my reading of that.
Thank you. Can I tender that document, Commissioner?
Exhibit 2.24 will be PwC AMP Financial Advice Review 30 March 2015, AMP 6000-003-8310.
Can we bring up AMP.1000.0001.0921? This is a letter dated the 23rd of June 2015 from AMP to ASIC. You've seen this document before?
Yes, I have.
And this document is in response to that letter that we looked at 2 documents ago, the letter of the 12th of June 2015 from ASIC to AMP asking, or to Mr Caprioli of AMP asking for information.
That's correct.
Now, can we blow up the last 2 paragraphs? And you see the last sentence says, we confirm that the audit I'm sorry, I should go back a step. You see that the second last paragraph refers to a recent audit conducted by PwC.
Yes.
And the last sentence says, we confirm that the audit program has not identified any systemic issues regarding the provision of ongoing services by AMP advisors.
Yes.
And you agree that statement is false?
Yes, and I think that's the finding in the Clayton Utz report as well.
Do you understand, or have you made any investigations to understand why this was said?
What? I don't know firsthand why it was said, no.
Do you think it reflects a failure on the part of the senior management at AMP at the time to understand the audit report by PwC?
I'm not sure what they turned their minds to. I mean, I can't know that, but I do appreciate the point that you're making and the finding.
You see, in a strict way, of course, this is true, that they haven't themselves identified any systemic issues because that wasn't what they were undertaking at all.
PwC is
Yes.
What you're referring to, yeah?
They weren't themselves undertaking the systemic audit. They were saying you need to undertake, or you don't undertake any root cause analysis in order to determine whether there are systemic issues.
Yes, could you go back to that section of the document? I think that's my recollection, but I'd just like to reread it if that's
Yes,
okay.
can we put that up on one side and on the other side bring up
Yeah, thank you.
AMP.6000.0003.8312 at page 8353? I'm sorry, I'll repeat that. It's AMP.6000.0003.8310 at 8353. And thank you. And then if we go to page 8353. You see what PwC says is root cause analysis of incidents and breaches that are identified is not conducted, which means that potential systemic issues are not identified, and similar issues are likely to reoccur as rectification is not fed into continuous improvement of processes.
Yep.
And they recommend conduct root cause analysis of all incidents and breaches to determine whether they are indicative of systemic issues. And what seems to have been drawn from that by the author of the letter to ASIC is, well, PwC hasn't found any systemic issues. You agree?
I agree.
And my question is, have you turned your mind to the question of whether this reflects a complete failure to understand what it is that PwC was saying, or whether it reflects a deliberate attempt to mislead ASIC?
I'm not certain of that, Mr Hodge. Obviously, I wasn't involved in it at the time. I have asked some questions in relation to that letter, and as I understand it, Mr Caprioli wasn't the author of the letter, and it was, as I understand it, authored by somebody else and then signed by him.
I see. And does that mean, from the perspective of AMP, that if a member of the GLT signs a letter but somebody else has written it for them, that they're not responsible for the content of it?
No, it just means that there's a process there where more than one person are often involved in the creation of these documents.
Yes, but surely the person who signs the document at AMP is expected to be satisfied that whatever it is that they're saying is true.
That's correct. They're certainly responsible for the letter.
All right. I tender that letter, Commissioner.
Will be Exhibit 2.25, letter AMP to ASIC 23 June 2015, AMP 100000010921.
Actually, can we go to the second page of that letter, which is 0922? The first page of the letter, Mr Caprioli was addressing the issue of fees for no services, where it's the advisor who's effectively caused the fee to be paid to the licensee but not provided the service. Do you understand that?
I believe so.
And the second part of the letter then is addressing the licensee buyback arrangements, the bowler problem. And can we blow up the paragraph under the heading? And you see in the middle of the paragraph it says, unlike the ANZ issue, these fees did not relate to providing personal advice or annual advice reviews, but to services such as retainer services and other support services to clients.
Yes.
And again, that was false.
Yes, I think that's correct.
Because there had been no determination that the fees did not relate to providing personal advice.
And I think that's what Clayton Utz found.
So this letter seems to contain then the, again by my count, the 12th and 13th false or misleading statement by AMP to ASIC. Do you agree?
Yes.
Now, if we take that document down and bring up PMA.001.005.4909.
Sorry, AMP?
I'm sorry, it's PMA.
PMA,
It is
is it?
PMA.
Right.
It might have been loaded at 3 a.m. Commissioner.
Don't go there, Mr Crutchfield, don't go there. That might have been for a reason.
The sigh of relief. This is a chain of emails between a number of employees within AMP.
Yes.
And you've seen this document before?
Yes, I have.
All right. Is this one of the documents that caused such consternation in May of 2017?
I couldn't recall that, Mr Hodge.
Can we go to page 4910? So if we put this in some contextual context, these are emails being sent in June of 2015. By this time, AMP has already given its first notice of breach to ASIC about the bowler issues,
Yes, that's correct.
but is representing to ASIC falsely that it is an administrative error.
At the time of
At
that
the
breach
time.
report? Yes, that's correct.
Now, if we blow up the email at the bottom of the page from Ms. Wolfe to various people, Ms. Wolfe was the registers and transfers manager at AMP at the time.
I'm not aware of her exact position, but something like that I believe was a role.
All right. She was being asked about approval to ring fence a register that was being sold into the bowler pool.
Yes.
And she explains that maintaining these registers in ring-fenced IDs presents several issues for AMP, and we are unable to continue to do this for registers. We need to transfer them and dial down the ongoing fees so that we do not breach ASIC requirements. And then goes on to say, please ensure that when seeking approval from MG, who is Mr. Guggenheimer, is that right?
That's correct.
He acknowledges that by ring fencing the registers and not having the ongoing fees dialed down, that we are in breach of our licence. And I'm sorry, I may have asked this already. You have seen this document before, haven't you?
Yes.
This doesn't come as any surprise
No.
to you. And then, if we then go to the next email in time at the top of the page, the relevant employee at AMP then sends an email to Mr. Guggenheimer explaining that they're trying to sell top-end fees for service clients in a register, and they need approval to hold the register in a ring-fence sales code. And then it says, it must be noted that this is in breach of our licence as fees are not dialed down. However, this is required to enable the analysis to be completed for on sale. You see that?
Yes.
And then if we go to page 4909, and blow up the email at the bottom of the page, Mr. Guggenheimer's response is, I am okay for the clients to be quarantined for 3 weeks to resolve what is being purchased so we do not lose the value of the service fees. Have you, before we see what comes after this, have you personally discussed with Mr. Guggenheimer why it was that he was continuing to approve ring fencing even when he was being told by more junior staffers that this was a breach of the licence conditions?
No, that was a matter that was dealt with through Mr. Guggenheimer with the Clayton Utz review.
All right. And then what follows on from that, if we take that down and blow up the email in the middle of the page, to Mr. Guggenheimer having given approval to ring fence this particular register, then sends an email to Mr. Morgan. What was Mr. Morgan's role at the time?
I can't quite recall. His role was in relation to what's known as licensee value management.
Right.
So the head of that function, in effect.
Was he a more junior employee than Mr. Guggenheimer?
Yes, but reporting through a different line, I believe, at the time.
Right. And who did Mr. Morgan, as the head of licensee value management, report to?
I believe that would have been Mr. Paff at the time, but I can't be entirely certain.
Right. And what Mr. Guggenheimer emailed Mr. Morgan about was to say, can you advise what is the revised policy terms relating to explicit service fees and bowler? It seems from the note below we are writing them down on day one, which is simply going to exacerbate the P&L issues and risks we are trying to manage.
Yes.
And then if we look at what the response was from Mr. Morgan, his response is, that is not the case. I believe Sarah's email is more of a result of our existing issue, and she has been directed by Wayne to drive awareness whilst we are still reviewing the end-to-end process to be in more robust processes for how we can ring fence and ensure that it is earmarked for on-sell and or AMP servicing. So as I understand it then, undoubtedly on the face of these emails, as at mid-June 2015, Mr. Guggenheimer, the Managing Director of AMP Financial Planning, and Mr. Morgan, the Head of Licensee Value Management, but also every employee who is copied in on one of these chains of emails, is aware that AMP is continuing to ring-fence registers and keep ongoing fees going, notwithstanding that they know it's in breach of the licence. Is that a fair summary?
Well, to the extent that they're copied on the emails, I accept your point. I don't know, obviously, the degree to which people read those emails.
All right, I tender that document, Commissioner.
Exhibit 2.26, emails of 12 June 2015 between Morgan, Guggenheimer and others, PMA 001 005 4909.
Have you personally considered the question, Mr. Regan, of to what extent these emails that we've been looking at reflect the culture of the advice section of AMP?
Yes, I have.
And what is the view that you've formed?
I think there are reasons to be concerned. I think they show a culture that's not as robust as it should be.
When you say not as robust as it should be, that really understates it, doesn't it?
I think that the culture certainly needs to be reviewed and analysed, and we are doing that. In fact, there was a review of the culture done in 2015. But I think the concerns there are obvious.
I just want to understand the way in which you perceive it. When you say not as robust as it should be, what we seem to be seeing is that a conscious decision is made to protect the profitability of AMP at the expense of complying with AMP's licence. Do you agree?
Yes, I believe that's what that shows, yes.
And is that type of behaviour what you mean when you say a culture that is not as robust as it should be?
Well, it's clear that we preference the interests of shareholders in that exchange at the expense of clients. And so that is a concern, but I think there are other elements there that are concerning as well. I think there is clearly a lack of clarity in terms of the way in which directions have been given, but also there's a concern about the degree to which things should have been escalated as a result of the issues being identified further down. So that would be three instances, I think, that relate to the cultural question.
But it's also at the expense of complying with the law.
Absolutely, absolutely.
And although you say it's preferencing the interests of shareholders, by that I take it you mean, at least in the short term, of maintaining the profitability of the company at the expense of complying with the law.
Yes, that's correct.
Is it in the long-term interests of AMP's shareholders for AMP to be maintaining its profitability at the expense of complying with the law?
It is not.
Has there been any consideration, as far as you are aware, at the board level, of whether this reflects the policies or approach of the board?
I'm not aware. To the extent that I've been involved in board discussions, the board has reflected a view that is consistent with appropriately treating clients and not preferencing shareholders at client expense, or more particularly, not being in breach of the law in that regard.
What about at the GLT level? Has there been a discussion that you've participated in as to whether this conduct reflects the policies or attitudes of the GLT at the time?
As of that time, as in...
Well, you've only been, let's break it down. You've been a member of the GLT for several years.
Yes.
You've been a member of the GLT as the member responsible for advice since the 1st of January 2017. Yes. Most of the conduct that we're concerned with predated you becoming responsible for advice.
Mm-hmm.
You
Yes.
agree? But not all of it? Not all of the conduct predated you becoming the group executive in relation to advice?
I believe it did.
Didn't ring fencing continue into 2017?
My understanding was that practice stopped before 2017. In
All
fact,
right.
I thought it... I can't be certain of that, but I thought it had.
All right.
Yeah.
Well, in any event, has there been any discussion that you have participated in at the GLT level, and we'll break this down into time periods. First, a discussion pre you becoming the head of advice, becoming the group executive in relation to advice, as to whether this conduct reflected the culture and priorities being communicated down by the GLT.
Mr Hodge, I can't bring to mind a specific discussion, but certainly the GLT discussed elements of this matter with the furnishing of the Clayton Utz report. I couldn't give you a specific narrative from that, but certainly having appropriate regard to the law and ensuring that we protect clients' interests were features of those sorts of discussions.
All right, well, I think you're now talking about a period after you became the group executive for advice, but let's just then focus on that.
Yeah.
After you became the group executive in relation to advice, have you participated in any discussion at GLT level as to whether this conduct in relation to ring fencing, the 90-day exception, the communications to ASIC, reflected the priorities and policies and approach being communicated down by the GLT to the employees that reported to them?
So can I just be clear with your question, Mr Hodge?
Yes.
You're asking, was there anything communicated down that would encourage staff to preference interests of shareholders or breaching the law in support of increasing shareholder return? Is that your question?
Well, let's start with that.
Absolutely not, as far as I'm aware.
But more generally, you agree this conduct reflects an approach which is of preferencing the interests of the short-term shareholders in terms of profitability over complying with the law or looking after the interests of clients. Do you agree with that?
Yes.
And that's just in relation to the 90-day exception and ring fencing.
Is that your...
That applies with respect to the 90-day exception and ring fencing. You agree? You agree.
Yes, I think I'm trying to just understand your question.
You agree in relation to the 90-day exception and ring fencing that what that conduct reflects is preferencing short-term profitability over complying with the law or acting in the interests of clients.
Yeah, I think the point I was making before is indeed a general point as well, and that is that at no time would we condone preferencing shareholder interests over the law or the interests of clients.
So this is the type of conduct that the GLT, at least now, disapproves of?
Yes, absolutely.
Perhaps if we attempt to examine this in a different way, have you participated in any discussion at the GLT level as to whether the GLT had sufficiently communicated down to its employees and those that reported to them that this type of conduct, preferencing short-term profitability over complying with the law in the interests of clients, was frowned upon?
At this time, can we just clarify the time period?
Since you became the group executive
Yes.
of advice on the 1st of January 2017, have you participated in any discussion at all at the GLT level as to whether at any time the GLT has adequately communicated down to those that report to it that conduct that preferences short-term profitability over complying with the law and acting in the interests of clients is inappropriate?
I can't recall specific discussions, but certainly we've had discussions about understanding what are the relevant cultural issues that arise out of this report, and I think one example in that regard is the risk culture survey and review that's currently being done to understand these issues more fulsomely. And
the discussions that you've had about the risk culture, when have they taken place, so far as you can recall?
In relation to this matter, or?
Yes.
There's been a number of discussions, particularly through what's reflected as the GLT subcommittee in relation to this matter, which is responsible for sponsoring that culture survey that I alluded to earlier.
And has the GLT come to a conclusion about the risk culture at AMP?
That work is best being finalised, I believe. I don't think it's complete as yet.
Have you personally come to a conclusion about the risk culture at AMP?
I have views about elements of the risk culture, yes.
All right. What are your views about the risk culture at AMP?
Well, Mr Hodge, I have to say I think there's a number of areas where we need to improve significantly. I think for mine, if you'll indulge me, thank you. I think the way I contemplate organisations, I think it starts with culture, it goes to governance, it goes to capability, control, systems, processes. But culture is the invisible hand that ensures that people are making the right decisions. And I think it's evident from some of the things that have flowed through here that that hasn't happened in all cases. I don't think it's consistent across all of AMP. I don't think it's the case in all matters, but certainly there's areas where the risk culture needs to be improved, and I think that will emerge out of the study that I alluded to earlier.
It's one aspect of the risk culture how AMP communicates with the regulator.
Absolutely.
And whether AMP communicates truthfully and frankly with the regulator.
Yes.
And have you participated in any discussion as to what the culture is at GLT level in relation to communicating honestly and frankly with the regulator?
Yes.
Recently?
I couldn't bring dates to mind, Mr Hodge, but certainly it's certainly arisen in different conversations.
And what is the view of the GLT about communicating honestly and frankly with the regulator?
Just as you've described it, honestly and frankly.
And what about discussions at a board level? Have you participated in any discussions at a board level about
Yes, I
that?
have. Yes, and a similar view, and most notably through the board committee that's referred to in terms of being the overseeing body in relation to not only this matter, but also the Advice Business Review Program that is alluded to, where we're looking to deal with the remediation of a lot of these matters.
Is that the Culture and Compliance Committee?
Yes.
We'll
I didn't want to use the acronym.
I don't think the ACCC would like it at all.
I'm with you on that,
Mr. Regan. Can we bring up the Clayton Utz report, AMP.6000.00038.001? This should be tab 3 of Mr. Regan's statement.
Should be AMP 600000380001, I think, is it?
That's right, Commissioner.
Yeah, I think you might have injected a new zero.
I apologise. And if we go to page 60, I'm sorry, go to page ending .0062, should be page 62. Now, Clayton Utz have a document that we don't, or appear to have had a document that we don't seem to have a copy of, but we can go off what Clayton Utz has quoted. If we blow up paragraph 167, subparagraph A, It's probably easier to do it off your screen.
Yes,
Mr. Regan.
unfortunately, the ring binder's suffered an injury, I'm afraid, so I'm having trouble.
I always do, Mr. Regan.
We'll go with your screen, Mr. Hodge.
Thank you. You'll see this is an email from Ms. Turner, who's an employee of AMP, to ASIC, dated the 9th of September 2015.
Yes.
And the part of that email highlighted by Clayton Utz is, the breach therefore relates to an administrative error in not turning off the fees on terminated arrangements.
Yes.
And again, that statement was either false or misleading, because the breach also related to the 90-day exception, which was a deliberate decision. You agree?
Yes, I think as we've agreed previously, yes.
And so by my count, this was the 14th false or misleading statement by AMP to ASIC. You're losing count.
I'm in your hands in that regard, Mr. Hodge.
I know. There's so many, you'll have to rely on my count, I'm afraid, Mr. Regan. Can we bring that document down and bring up amp.1000.0001.4844? This is a letter of 26 November 2015 from AMP to ASIC. Have you seen this document before?
Could you just make it a little larger? I
Yes.
don't normally need glasses, but I'm just struggling just with that font size, if that's okay. Yes, November. Just scroll a little more, yeah. I think I have seen that, Mr. Hodge. I'm just, it's part of my exhibits?
I don't think it is part of your exhibits, Mr. Regan, but I'll have that checked. If we go to page 2 of that document, which is ending .4845, and blow up the paragraph beginning AMP can provide. You see what the letter said was, AMP can provide an assurance that a process was in place to inform customers that services would no longer be provided. Now, this is, again, part of the fiction being maintained by AMP with ASIC at this time, that they had terminated all of the ongoing fee arrangements when a client came into bowler. You agree with that? It's
I
part
agree
of that
that
fiction.
the service, I'll agree that the services were not being maintained as represented in that letter, yes.
You reject the word fiction, Mr. Regan?
It's Mr. Hodge's word, Commissioner.
And do you reject it?
No, I don't reject it.
So then, I tender that document, Commissioner.
Exhibit 2.27, letter AMP to ASIC, 26 November 2015, AMP 1000/0014844.
And again, by my count then, that brings us up to the 15th false or misleading statement by AMP to ASIC. I take it you've lost count now, Mr.
I'm
Regan.
keeping count with you, Mr. Hodge.
Thank you. And then can we bring up AMP.1000.0001.4781? This is a letter to ASIC of the 14th of December 2015 from AMP. You agree?
A little larger, if that's okay. Yes.
Have you seen this document before?
I can't be sure, and I'm not trying to be difficult, but it's just that I've seen quite a few documents, as you might appreciate.
I understand.
Is it attached to the exhibits, do I know?
I don't believe so.
Okay. It's quite possible I have seen it, but I can't bring it to mind at the moment.
All right, can we go to page 2 of that document, which is the page ending 4782? Thank you. And can we blow up the paragraph which says the administration error identified? And you'll see what was said to ASIC was the administration error identified is that in approximately 24% of cases, the AMP product issuer received the spreadsheet but did not distribute to all of the appropriate administration teams to turn their respective ongoing fees off.
Yes.
And the premise that was being maintained here was that the way in which this problem of ongoing fees arose in the bowler pool, insofar as it concerned products issued by AMP was that there was a failure to properly action spreadsheets that were sent around within AMP. Is that your understanding?
Yes, as it's reflected in that section there, yes, definitely.
And that was a misleading statement because, of course, as we know, the failure was also related to the deliberate decision by AMP to continue to charge fees. You agree?
I do agree.
All right, and by my count, that's the 16th false or misleading statement by AMP to ASIC. Can we then blow up the paragraph beginning for ongoing service fees deducted? So now this is relating to where it occurs in relation to non-AMP products. If we just break that down, what that means is a client who is on a particular register might be sold into the bowler pool, and the fees that are being received by an AMP licensee are coming from some external product issuer.
Yes.
So, for example, it might be that the client is invested in a particular managed fund, and the managed fund is paying a fee effectively to, or debiting a fee in order for that to be paid ultimately to the advisor for services. That's right?
I think I understand your point, yes.
And what this says is for ongoing service fees deducted on accounts held by external non-AMP product issuers, the licensee advised the customer by letter issued by the advisor selling the customer register that the customer was to contact the external provider to turn off fees. In circumstances the customer did not follow this request, the licensee continued to receive service fees and did not have a process to adequately check work had been completed. Now, can I suggest to you this is misleading in two respects. First, in fact, the letters hadn't been sent out to customers. You agree?
And there was a failure to send some letters, yes.
And secondly, it has the suggestion, or in fact the explicit statement, that this is effectively an error on the part of the client because they've failed to contact the external provider to turn off fees, and AMP hasn't checked that, whereas in fact, at least in some cases, it was the consequence of a deliberate decision by AMP. Do you agree with that?
I'm not sure of the detail of that. I do agree with you, though, in relation to the nature of that letter and the expectation that the client should be the one that contacts the external fund manager.
Yes, and the suggestion is first that a letter went to the client telling them that they needed to contact the external provider.
That didn't occur in all cases.
And that didn't occur. And second, that the reason then that the fees kept being paid was because the client hadn't contacted the external provider and AMP hadn't checked.
That's correct.
When in fact, because of the 90-day exception, in at least some cases, it was the product of the deliberate decision by AMP.
I wouldn't debate the point with you. It's just that without having a map to show the specific transactions, I couldn't give you absolute certainty, but I think your point's well made.
All right, I tender that document, Commissioner.
Exhibit 2.28, letter AMP to ASIC 14 December 2015, AMP 10000014781.
And I think that takes us to 17 false or misleading statements by my count, Mr. Regan.
Were you counting that as one or two?
I only counted that as one. Do you think I should count it as two?
I think in fairness, Mr. Hodge, you should.
Okay. The 18th false or misleading statement by AMP to ASIC. Can we bring up now AMP.6000.0010.0010? Now this is a letter sent by ASIC to AMP on the 10th of October 2016.
Yes.
You've seen this before, it's exhibited to your statement.
Yes, it is.
And what ASIC wrote to AMP to say was that ASIC had obtained a client file where fees were still being charged after the client goes into bowler and then the client is transferred to a different advisor.
Yes.
And so that then prompts a response, which is I'm sorry, actually, I said that was exhibited to your statement. I'm not sure it is. I'll tender that document, Commissioner.
No, I think it's there, isn't it? Isn't it one of the later documents?
I'm told it is. We don't
Yeah,
need to tender it. Thank you, Commissioner.
it.
And then if we bring up AMP.6000.0010.0013, which is tab 42 to Mr. Regan's statement. And this is the response by AMP to ASIC, where if we blow up paragraph numbered 1, and you'll see the last two sentences say, however, we are now aware that the ongoing service arrangement for the client was not terminated. This was in accordance with the business practice adopted during this period, that if the transfer to the incoming practice was scheduled within a short period of time, for example, 90 days or less, then the ongoing service arrangement was not terminated. And this was, as I understand it, the first time that AMP confessed to the 90-day business rule to ASIC. Is that your understanding?
I think it is, because it was at that stage that it was starting to be investigated.
Right. Now, the way in which this is framed is that the 90-day business practice, or the period of up to 90 days, would only apply if a transfer to another practice was scheduled. That's the way it's framed. Do you agree?
Yes, I think that's my understanding of its purpose.
Is that how you understand the practice to have worked?
Yes, I believe I do.
All right. Can we bring up AMP.1000.0001.5093? So this is an internal chain of emails of employees of AMP. Have you seen this internal chain before?
Is it one of the ones attached to the statement, Mr. Hodge?
I don't believe so, Mr. Regan.
I can't be certain I've seen that one, Mr. Hodge.
You can't be certain.
I can't be certain I've seen it, no.
All right. Well, if we blow up points 3 and 4, so this is first explaining what happened post-January 2014. That from January 2014, with the critically identified, the application of the business rule was strengthened. Michael D, that must be Michael Diamante, is that right?
Very likely.
What does this mean? This is the date we used in the comms to ASIC in August 2015. And then point 4, that post this date, there are examples where discretion was used to leave fees on when back-to-back transactions were happening. The commercial practice was intended to be up to 90 days and subject to PM. What's PM?
I think that would be practice or partnership manager?
HOF,
The head of financial planning?
recruitment, other parts of the business, instructions to R&T, is that registers and transfers?
Probably. I'm not entirely certain, but...
Right. And what this seems to suggest is that what happened after 1 January 2014 was that the 90-day rule was changed in some respect so that it would only apply where there were back-to-back transactions that were intended to occur within the next 90 days.
Not sure about the change.
All right. Well, you know that ASIC was told something had happened, something had changed as of 1 January 2014.
Where is that contained, Mr. Hodge?
You remember we looked at those documents yesterday afternoon, Mr. Regan, where ASIC was told the practice ended.
Oh, it ceased on the 1st of January
Yes.
2014. Is that what you're referring to?
Yes.
Yes, I agree, yes.
All right. And what this seems to suggest is we all agree it didn't cease, but that it was, the practice was changed as of January 2014 so that the 90-day period would apply where there were back-to-back transactions scheduled.
Yes, look, I must say I'm not quite across the detail of that, but
All right, let's blow up points 5 and 6. And then these points are explaining this separate issue, which is ring fencing as distinct from the 90-day rule. And the first point, or point 5, explains, in this period, it appears likely that there were instances where rather than enter the bowler ID, registers were retained in seller IDs to facilitate a sale of registers. And then in point 6 it says, when we formed the fee remediation team in early May 2015, logged the incident 27 May and in June, on the assumption that M&A, which is merger and acquisitions, is that right? Facilitated all bowler on sells, I discussed with mergers and acquisitions and agreed no fees would be left on unless there was joint approval of the licensee, managing director and head of LVM. This subsequently became the business rule and a formal exception process applied. And so, as I read it, and you're not sure whether you've seen this document before, what it seems to be saying is, from May 2015, the process in relation to ring fencing was that fees would be left on only if there was joint approval of both the managing director of the licensee and also the head of LVM.
that is what it appears to say.
And the licensee MD in respect of at least AMP, FP and Hillross was Mr. Guggenheimer at the relevant time. And who was the head of LVM?
I believe that was Mr. Morgan.
All right. And it appears, if we take that, the blown up section down, thank you. This is an internal email being circulated within AMP employees in November of 2016, setting out or arriving at what their common understanding is of when they continued to charge fees for no service.
Yes, it is.
And I'll tender that document, Commissioner.
Exhibit 2.29, emails 11 November 2016 between Marsh, Collins and others, AMP 100000015093.
And can we bring up AMP.6000.0061.4329? So this is an email, the start of the email is an email from Ms. Baker-Cook, who's the head of litigation and dispute resolution at AMP at the time, emailing two solicitors at Clayton Utz. You see that?
Yes.
And that's in June of 2017. And she's forwarding another version of this November email that we've seen. If you look at the bottom of the page, you can see that there's an email from Mr. Brivulus responding to that earlier email that we'd looked at. Perhaps if we bring up both pages. Mr. Brivulus was in the mergers and acquisitions team, is that right?
I can't be certain of his exact role at that time, but he's in that part of the business somewhere. He's in the administration part of the business, is my point.
All right. So his comments on this consensus understanding are in red on the second page. You see, he says in his email, notes below.
Yes.
And we can also see at the top of the second page an email back from Mr. Diamante explaining, and he's part of licensee value management, explaining what his understanding was?
Yes.
And nobody, as far as I can tell from this email, is suggesting that they have some different understanding from that which has been set out by Mr. Marsh. Have you read this email before?
I don't believe I've seen that.
All right, well, let me...
Is it in the exhibits?
No, it's not in the exhibits.
Right.
Let me suggest to you that what we can see from this email is that there was a common understanding amongst a number of different teams at AMP that there had been a separate practice of ring fencing going on throughout the period after May 2015.
Yes, I think that's correct.
All right, I tender that document, Commissioner.
Exhibit 2.30, emails Baker Cook to Mavrakis and others, 21 June 2017, AMP 600000614329.
Now can we bring up AMP.6000.0010.0015, which is tab 43 of Mr. Regan's statement. So this is the letter sent to ASIC by AMP on the 23rd of November 2016. And can we blow up the paragraph under the heading 90-day or less exception? So this confesses about the 90-day exception, and a little further on in this letter confesses the 90-day exception continued to be applied after January 2014.
Yes.
We take down the blow up. It doesn't explain any change pre and post January 2014 that was being referred to in those earlier emails between employees. You agree with that?
I can't recall.
Well, let me put it a different way.
Yeah.
This email doesn't identify that there was any change in relation to the 90-day exception before and after January 2014. You agree with that?
I believe so.
And it doesn't identify the ring fencing process or rule that AMP had?
I don't believe it does.
And therefore doesn't explain that there was another respect in which fees continued to be charged by AMP where no services were being provided apart from the 90-day rule?
I haven't read the letter.
And, well, in any event, can I suggest to you that by not identifying the existence of the ring fencing practice, that was also misleading?
Yes.
And so by my count then, this is the 19th false or misleading statement by AMP to ASIC. Now, can we bring up the Clayton Utz report, which is AMP.6000.0038.0001, or tab 3 to Mr. Regan's statement? And go to paragraph 154 at 0058. Thank you. Clayton Utz interviewed a number of employees of AMP in the process of preparing their report.
Yes, they did.
And they formed a view as to why it was that AMP sought to describe the problem as an administrative error to ASIC.
Yes, you're not referring to something on that page, you're just referring to...
Well, as a general proposition, they formed a view as to why it was that AMP sought to describe the problem as an administrative error to ASIC.
So I can't quite recall where that is in the report.
But if you look at paragraph 154 that's on the page, the desire to describe the cause as an administrative error was to justify to ASIC that the appropriate compensation for customers was a refund of ongoing fees rather than compensation based on no advice.
Yes, if that's your point, I agree.
All right. And you accept that that was the motivation of AMP in making this misleading statements to ASIC?
Yes, I do.
And then if we go to paragraph 224, subparagraph G at page 80, which is .0080. Can we blow up subparagraph G at the bottom of the page? And you'll see what Clayton Utz also concluded was that at times we observed the stance of AMP in its interactions with ASIC was to seek to negotiate a commercial outcome with ASIC on the scope of the compensation payable to customers. They're perhaps unsurprisingly critical of that. Do you accept that that was the approach that was taken by AMP in relation to trying to negotiate compensation?
I accept Clayton Utz's finding.
Thank you. Can we now bring up tab 30 of Mr. Regan's statement, which is AMP.6000.0001.1894. And this is one of the two breach notices that AMP gave to ASIC on the 3rd of May 2017. Yes. This one relates to the practice of ring fencing.
Yes.
And can we blow up the two paragraphs in the middle of the page which say, following the review into the 90-day exception? Thank you. And I'll read these out. It says, following the review into the 90-day exception for bowler transactions, which has been the subject of previous correspondence with ASIC, further work was undertaken in order to identify any other potential circumstances with respect to the breach which may require customer remediation. In undertaking this work, we identified that there may be instances where customers who are subject to a bowler or other licensee buyback transaction were never transferred to the bowler pool and or subsequently transferred to a new servicing advisor / practice. That statement suggests that AMP only discovered or realised that ring fencing was occurring after it started investigating the 90-day exception. Do you agree?
I think that's correct, yes.
And we know from that chain of emails we looked at in mid-November 2016 that that was untrue. They'd already identified ring fencing before the letter sent on the 23rd of November 2016. You agree?
Yes.
And in that respect, then, even this last breach notice was also false or misleading.
Yes, I think this is the one we discussed yesterday.
I don't think we did discuss whether it was false or misleading, but we may have referred to it.
I thought I could recall suggesting that the language in that was incorrect.
I see. Well, in any event, by my count, this is the 20th false or misleading statement made by AMP to ASIC. Thank you. Now, I want to ask you some questions now about some documents that, or some documents that weren't provided to Clayton Utz. Can we bring up paragraph 34 of the Clayton Utz report? The reference to the Clayton Utz report is 6000.0038.0001, which is tab 3 to Mr. Regan's statement. And paragraph 34 is on page 20. page ending .0020. And you see Clayton Utz conclude or observe that the 90-day exception did not emerge out of a formal recommendation or study, and go on to say it was ad hoc in the manner in which the delegation of authority was exercised. And then if we go to paragraph 103, you see it said, it is difficult to know precisely who had knowledge of all these matters and the extent of any problem. However, we observe that the material we have reviewed, although not conclusive, may have been enough to put AMP on notice as early as 2013 that these orphans were being overcharged and that the bowler process was not operating to ensure that customers were not being overcharged. Now, I understand you to say you agree with every conclusion reached by Clayton Utz in their report. That's your position, is that right?
I agree substantively with the Clayton Utz report.
Right.
I think I would contest some of the conclusions that are drawn. I think I certainly support the fact base that it provided.
What are the conclusions in the Clayton Utz report that you would contest?
There would be a number, but I'd need to go through the report, I think, with you. So one example would be the clear and consistent legal advice was always provided. In some instances, I think there was some equivocation about the legal advice. So, for example, it talks in one section about the business rule probably needing to be reviewed. In my opinion, that's equivocation. I think the business rule should have been reviewed immediately, and it should have been escalated much more significantly than it was.
I see. You think, just let me make sure I've understood this. The example you're giving is Clayton Utz has said they think the legal advice was clear that the business rule of 90 days was a problem as a matter of law. Is that right?
And in many instances, it is clear and consistent.
All right. But you're saying there are a few examples where you think the legal advice was equivocal. Is that right?
Yes, so in that example, and I haven't got it on the paper, but I think there's an example where it says this business rule should probably be reviewed. Well, in my opinion, and that was drawn from the legal advice, I think that it should have been much more dramatic in terms of its escalation.
I see. You think...
Want, Mr. Regan? You say it should have been more dramatic. What do you mean?
I believe that there should have been escalation through the legal process as much as the business process.
Thank you. We will return, I think, to that point, Mr. Regan, but can we look at a document just to understand what happened in 2013? Can we go to amp.6000.0011.7910? So you'll see, Mr. Regan, this is the papers for the Practice Proposition Project Steering Committee pack for the meeting of 24 May 2013.
Yes.
Now, you pointed out yesterday how these committees fit together. This committee, the Practice Proposition Project Steering Committee, reported to another committee, is that right?
I understand that is so.
And what was the name of that other committee?
The FOFA, well, in fact, I think it's the title at the top of that one, which is the Future Financial Advice and Stronger Super Ready Program Steering Committee.
I see. And that upper committee was one that was chaired by Mr. Mellor, is
That's
that right?
correct.
But this was a perhaps not a subcommittee, this was a committee that reported to the committee that was chaired by Mr. Mellor, is that right? And you'll recall we looked at a report that had been made to the committee chaired by Mr. Mellor, which came out of this committee. You remember yesterday we looked at
that document.
And that document said we need to make a decision about what we're going to do about orphan clients.
Yes.
And you pointed out that decision wasn't being made by Mr. Mellor's committee. It was a recommendation as to a decision was going to be made by this subcommittee.
That's as I understood it, yes.
All right. And this particular document, is this one you've seen before?
Yes, it is.
Okay. And this document wasn't provided to Clayton Utz?
Now, I know that there was some documents discovered later as a result of the change in IT process. And what I mean by that is that I believe there was a full server download at some point after the original Clayton Utz report was provided. And I believe if this is the same document, this is the one that came as a result of that search.
I see. I suspect this document predates the document that you're thinking of, but let's have a look at the document. If we see item 2 on the agenda is action items update.
Yes.
And item 5 on the agenda is FDS systems.
Yes.
And you understand FDS systems is fee disclosure systems?
Yes, I do.
I'm sorry, fee disclosure statement systems.
Yeah.
And if we go to page 5 of the document, which is .7914, so this is the action items, and you'll see the third action item is investigate which bowler BOO. What's BOO stand for?
Buyout option, I think.
I see. Customers are still being charged an ongoing fee, and that's an action in process, which is SC 10-002.
Yes.
And the owner for that is AM,
Yes.
and AM is Andrew Mensinski.
Yes.
And then if we go to page 35 of that document, which is .7944, and so you'll see at the very top of the page, this is a paper for item 5, which is FDS systems. Do you see that at the very top of the page?
Oh, yes, it is, yes.
And it's a memorandum dated the 20th of May 2013 from Mr. Mensinski to that steering committee. That is the committee that we're now considering the pack for.
Yes.
And then if we go to page 40 of the document, which is .7949, and you'll see there's a heading decision required. Can we blow up the section under decision required all the way down to the bottom of the page? From decision required down, thank you. So you'll see what's being raised here is this same issue that had been reported up to the higher committee that we looked at yesterday, which is a decision needs to be made as to what is going to happen to existing orphan policies or clients that have an OFA and fall within FOFA's FDS regime. Can I just ask one thing? Is the word client used interchangeably with policy within AMP?
They shouldn't be used interchangeably because a client may have a number of policies.
I see. And is the
client
word...
is a customer, sorry.
I see. And a policy, to take the example of an investment being made through a platform into many different funds, is that one policy or multiple policies?
I think if it goes through the platform, it would be single policy, but Mr. Hodge, I'm probably the wrong person to ask in terms of having the detail of that. But
With your group executive for advice, but you're the wrong person to ask.
only in respect to the technical detail around policies and how these things are processed.
Okay. So what's being flagged here is this decision needs to be made. Are you going to dial down, which we know what that term means, it means go down to base commission,
Yes, I think that's correct.
or switch off
Yes.
all ongoing fees, or issue a fee disclosure statement to the orphan policyholder?
Yes.
And the point or the issue under FOFA is that if you're going to keep charging fees to a client, then you need to issue a fee disclosure statement to them.
That's correct.
So that what's being accepted here as just a matter of reality is that as at May 2013, AMP has orphan clients who are paying fees, sitting in the bowler pool and paying fees. You agree with that?
Yes, that's correct.
But the legislative concern that has arisen is if they want to keep charging fees to them, they need to provide them with a fee disclosure statement.
That's correct.
And so notwithstanding that they're providing no services at all to these clients, that's not the reason why anybody is considering dialing down or switching off the fees. Do you agree?
But that seems to be so from that document.
And then 2 paragraphs down, you'll see AMP Group can easily dial down / switch off ongoing fees received via, and there's various products there and platforms because it has access to those systems. Can you see that statement? And as I understand it, what that's saying is where AMP is dealing with internal platforms or products that it owns, then it could just switch off the fees quite easily if it wished to.
Yes.
But to date, it's by implication chosen not to.
Yes.
But now it may contravene a further legislative provision. Now it may contravene a legislative provision in relation to fee disclosure statements if it doesn't switch off those fees and doesn't issue a fee disclosure statement.
That's correct.
And if we then go to page 41 of that document, and we blow up the section under recommendations paper, so you'll see what's the committee is being informed of is a recommendations paper is being prepared which provides specific policy and process recommendations which will impact existing and future orphan policies / clients. The recommendations paper also provides information on proposed plan of termination letter changes. The recommendations paper will be circulated to the appropriate stakeholders for review and action. That recommendations paper must be the paper prepared by Mr. Magellan. Do you agree?
So which paper are you referring to?
Well, can I
go to
tender that document, Commissioner?
Will be Exhibit 2.31, Practice Propositions Project Steering Committee Pack, 24 May 13, AMP 600000117910.
Thank you. And then can we bring up, I'm sorry, Commissioner, Mr. Costello is, Mr. Costello is not correcting the exhibit numbering, which will be a relief to all of us. Could we bring up ASIC.0019.001.0075? Now, you'll see this is FOFA practice proposition stream, orphan contracts, policy and process changes and recommendations, a paper prepared by Mr. Magellan.
Yes.
Perhaps even just to make the point clear, can we put that up on one side and can we put up on the other side from the document amp.6000.0011.7910, page 7950. So you see this, can I suggest to you, must be the recommendations paper being referred to in the steering pack. Do you agree?
Yes, I think I would agree.
And this version is up to version 1.2. Can we go to page 7 of that document, which ends .0081? And you'll see this is setting out various issues that have to be resolved. And the first issue is legal confirmation required on the maximum period of time and allowable scenarios that an ongoing fee arrangement can be kept active once the client/policy becomes orphaned. That is to say, unattached from a servicing advisor. And then it seems to contain an update, which is ongoing fee arrangement can be kept active for up to 3 months before being turned off.
Yes.
Now, you've seen a document with this type of update in it before, haven't you, Mr. Regan?
Yes, I have. I believe it goes to version 1.4.
Yes, that's right. It keeps getting updated. And then if we go to page 13 of the document. We can take down 7910. Thank you. So what this is setting out is proposed policy and process changes in order to deal with existing orphan policies.
Yes, that's correct.
And you've reviewed the later version of this,
yes.
Is that right? And let me summarise it as I understand it. As I understand it, the recommendation that was made to AMP by the relevant employee was to classify orphan policies, which is also orphan clients, is that right?
Yes.
As either likely or unlikely to be on-sold or transferred to a new planner.
Yes,
See it at the top
could you
of the
just
page?
make that document a little
Yes, can we
larger for
blow
me,
up
please?
at the top of the page?
Yes, thank you.
So there's going to be two categories of orphans. One are orphans where AMP thinks it will be possible to sell the orphans on to another planner. And the second category will be orphans that AMP thinks it's not possible or unlikely to be sold on to another planner.
That's correct.
And you'll see the recommendation is that for orphans falling into category 1, a fee disclosure statement be issued by whatever the applicable disclosure date is, rather than dial down the ongoing fee.
Yes.
And if we go down the page, you'll see there's a rationale explained for why that is, that because it's likely that they're going to be sold on, it's going to be possible then for the planner to just continue with the existing ongoing fee arrangement if they wish, or they could negotiate a new one.
Yes.
Whereas if no fee disclosure statement was given, AMP would need to dial the fees down immediately, and when it on-sold the planners, they would just have to negotiate a new ongoing fee arrangement.
Yes, that would have to occur within 30 days of the disclosure date.
And AMP, or the recommendation was to avoid the possibility of the purchasing planner having to negotiate a new ongoing fee arrangement, unless they wanted to.
Yes, I think that's correct.
And then the category 2 orphans are orphans where it is not likely that they will be on-sold. And the recommendation for them is that an ongoing fee be dialed down immediately rather than issue a fee disclosure statement.
Yes, that's correct.
Now, that recommendation wasn't made because these clients were being charged for services they weren't receiving. That wasn't the reason for the recommendation, was it?
Could you just repeat that?
Yes. That recommendation that ongoing fees be dialed down immediately rather than issue an FDS was not made because these clients were being charged for services they weren't receiving. Do you know what the reason was?
No, I'm not entirely clear.
Let's go to the bottom of the page. You see, the explanation is the rationale is that these clients are currently paying for a non-existent service, and issuing an FDS may trigger the client to cancel both the ongoing fee agreement and the policy, lodge a complaint with AMP and/or ASIC, and possibly request compensation on the advice fees or dialed up commission for the previous 12 months. This would be a very negative customer experience. That was the reason for that recommendation. Do you agree?
Yes.
And I tender that document, Commissioner.
That will be Exhibit 2.32, FOFA practice proposition stream, orphan contracts, document version 1.2, ASIC 0019001075. Is it a dated document, Mr. Hodge? We've got the version number, but has it got a date on it?
It should, Commissioner, if we go back to page 2 of that document. So this version is updated as of the
21 May
21st.
13, is that right?
That's right.
Version 1.2, 21 May 13. Thank you.
And Mr. Regan, that recommendation was adopted by the relevant steering committee. Are you aware of that?
I think that's at 1.4. Is it the same version? So I think what you've got here is version 1.2.
That's
is that
right.
the document we just looked at?
That's right.
And I thought it was version 1.4 that was looked at by the committee. Or am I incorrect in that regard?
Well, in fact, we'll come to this. If we bring up AMP.6000.0011.8670, which is tab 34 of the exhibits to Mr. Regan's statement. Now, this is the document that's exhibited to your statement but was not provided to Clayton Utz.
Thank you.
And
Well, do you agree it was not provided to Clayton Utz?
Yes.
And I think you may have tried to offer an explanation for this before. Why was it not provided to Clayton Utz?
So as I understand it, there was a change to the server arrangements with Clayton Utz in that we provided a file transfer that was different to the previous one that had been delivered. So it was a full FOFA file, a full FOFA file that had been provided to them post the production of the report. And that is why I believe this document was discovered later. It was discovered later by AMP as a result of a search in respect to another notice from ASIC.
I see. Again, we'll come back to that. So can we go to page 2 of that document? You'll see these are the minutes from the previous meeting of the Practice Proposition Steering Committee, and the minutes are of the meeting on the 24th of May 2013.
That's that same date, is it?
Well, no, these are minutes of a meeting on the 24th of May 2013.
Asking to blow it up for me again, if that's
Sure,
all
can we
right.
blow up the top
Thank
of
you.
it? You agree?
Yeah, yes.
And you'll recall from the version numbers that we were just looking at of that paper by Mr. Magellan that version 1.
Check, there's the minutes, are they dated? So the minutes you're referring to?
Are the minutes dated?
So this is
These are the minutes of the meeting on the 24th of May 2013.
Thank you, yes.
And they're included as part of if we go back to page 1.
Thank you, I just missed the date, that's all, it was up the top. I
No,
was
that's
looking
fine.
further down. Yeah.
But just so it's clear, they're included as part of the meeting pack for the next meeting on the 5th of June 2013.
Thank you.
And then if we go to page 3 of the document, which is part of the minutes. So you'll see this is that item 5, fee disclosure statement systems
Yes?
from the previous meeting. And can we blow up the section under the heading discussion/decisions? And you'll see the third point, AM, which is Mr. Minsinski, advised ongoing advice fees in some orphan accounts have not been turned off. SC, which is steering committee,
I believe so.
agreed the solution will be to dial back down fees after 3 or 6 months, so long as the client is not serviced by Horizon. So that was the decision that was made.
Yes.
And can I suggest, and we can go back to the detail of this if necessary, that was the solution that had been set out in the paper by Mr. Magellan.
I just can't quite recall back to Mr. Magellan's paper.
All right, but we'll go back to that shortly. Can we... And then you'll see the next point is SH asked to investigate who has not actioned to policy in regards to the previous point. And SH is Mr. Helmich.
Helmich, yes.
Helmich, I'm sorry.
Mm.
And what was Mr. Helmich's position?
At that time, he would have been head of the financial planning business. I can't recall the exact title.
All right. And then if we go to page 5 of that document, which is .8674, and you'll see this is a memorandum from Mr. Himmelhock to the other members of the Practice Proposition Steering Committee.
Yes.
And if we go to page 6.8675, blow up section 7, which deals with orphans. And you'll see what he's recording. He seems to have not quite understood what is recorded in the minutes, which is, as agreed at the last steering committee, we are turning off any OFAs, that's ongoing fee arrangements, in the orphan registers that are older than 6 months. We are also working to build a process whereby AMP can issue an FDS for registers purchased, assuming we adopt a 6-month rule going forward for the turning off of advice fees. Then we will have to produce FDSs for roughly half the number of clients that we purchase. Can I just pause on that? Do you understand, or can you explain to the Commissioner why it would only be necessary to produce FDSs for half the number of clients that AMP purchases if they adopt a 6-month rule?
Presumably because I'm not entirely clear on that.
All right.
I should be able to give you a better answer, but I just can't quite bring it to mind at the moment.
And then can we go to page 13 of that document? And you'll see at the top of the page, it's explaining an issue in relation to grandfathered commissions, which is when a practice changes licensees or an advisor with a book of business changes licensees after 1 July 2013, there is a break in the relationship that pays the commission and grandfathering is lost. You see that statement?
Where is it on the page, Mr.
At the very top of the page.
Thank you.
And you understand... Sorry, I should go back a step. You've obviously read this document because you've exhibited it to your statement.
Yes.
And in your statement, and we'll come to this, you've made some observations about what you draw from this document. Yes?
Thank you.
And, well, no, I'm asking you, you agree, you make some observations about what you think about this document?
Yes, I believe so. It's in the witness statement.
Yes. And they're your observations, aren't they?
Yes, I just can't quite bring them to mind at the moment.
Okay.
Yep.
I wonder,
We
Mr
have a
Hodge,
break.
whether we might be better off to give the witness 5 or 10 minutes. He's been going, thick end of 2 hours. We might, I think, take a break for 5 or 10 minutes. Is it
10
convenient
minutes.
to do so now?
Yes, Commissioner, it could be
We-
10 minutes.
If we come back at shortly after 12:45.
Thank you, Commissioner.
Yes. Thanks, Mr Regan. Yes, Mr Hodge.
Thank you. Commissioner, we were looking at the document which is tab 34 to Mr Regan's statements. If we can bring that back up. So, Mr Regan, what I was asking you about was a particular issue raised on this page for consideration by the committee. And I'd pointed out to you that at the top of the page it says when a practice changes licensees or an advisor with a book of business changes licensees after 1 July 2013, there is a break in the relationship that pays the commission and grandfathering is lost.
Yes.
And your understanding is that there's commission that continues to be paid to a licensee under grandfathering arrangements under FOFA, so long as there hasn't been a change in licensee before, or I'm sorry, there hasn't been a change after 1 July 2013?
Mr Hodge, I'm not totally familiar with this because it was legislation that and a change that occurred during my time, but from the documents that I've read, that's my understanding.
All right.
Yeah.
You understand that there's still commission, very substantial amounts of commission being received by AMP licensees?
Yes.
And that commission is a consequence of the grandfathering arrangements?
Yeah, that's correct.
And under the grandfathering arrangements, so long as there hasn't been a break in the relevant client licensee relationship after 1 July 2013, the commission can continue to be retained by the licensee?
I understand that to be the case, Mr Hodge.
Okay. And what this paper is identifying as a problem is, for AMP, is that if there is a break in their relationship, then after 1 July 2013, then they will lose the commission?
And which section is that?
Well, you've read the paper, haven't you?
Yes, but I just can't bring the detail to mind at the moment.
All right, well, if we go down to the bottom of the page, the second half of the page, do you recall in reading the paper the issue of the concept of register code?
Yes, I do.
All right, and is the concept of register co that register co will end up being an authorised representative of all of the AMP licensees?
I can't recall that well enough to answer that, Mr Hodge, without picking up the specific reference if it's there. I have read the document, but I haven't retained all of it.
All right, well, you see the second sentence under the heading issue, bowler and register co is the concept of register co is that client registers are held in a central pool so that they can be transitioned between AMP businesses / licensees and maintain grandfathering.
Yes.
And take your time to read it if you wish, but the problem that is being identified is that if you move a book of clients from one licensee to another, which could happen under the bowler arrangements, then you lose grandfathering.
Move licences under the bowler arrangement, but that's within the licence of AMP financial planning.
Oh, I see. You don't think there would be any reason to be concerned about this? That is, if you've got a book of clients and they're sold back to the bowler pool and then sold to somebody else, you don't think there would be any break in the relationship?
If it's within the same licensee, and the only point I'm simply making is that bowler is unique to AMP financial planning, and so any movements between bowler and then through to advisors, I wouldn't have thought was affected by this grandfathering issue.
I see.
That's the only point I'm making.
Okay. And then you see the second issue identified there is orphans that have had commissions withheld will not be able to reactivate commissions after 1 July 2013.
Yes, I do see that.
And the proposed action is turn on commissions.
Yes, it is.
And can I suggest to you that the ideas that are communicated on this page are that AMP is attempting to structure its business in order to maximise the possibility that commissions will be able to continue to be collected after 1 July 2013.
I think that's a fair conclusion.
All right. And then if we bring up your statement, paragraph 227.
Yes?
We blow that up. Thank you. So you're referring there to, as I understand it, that document, and you say these documents demonstrate that there was a program of work overseen by several committees to ensure the compliance of AMP's advice licensees with the FOFA reforms, which would be implemented in the period 1 July 2013 to 1 July 2014. I just want to understand your particular view of these documents, and then we'll extend out to the AMP organisation. As you've agreed with me, what the particular page we were looking at demonstrated was AMP trying to figure out how it could maximise the chances of commissions being grandfathered so it could keep receiving it. In your view, is that equivalent to ensuring compliance of AMP's advice licensees with the FOFA reforms?
Sorry, I just missed the...
Is your view that attempting to maximise the chances that commissions could be grandfathered and therefore kept by AMP is the same as ensuring compliance of AMP's advice licensees with the FOFA reforms?
I obviously wasn't involved in the discussions at the time, so I have no context around it. I expect that there's a technical issue there, but certainly not one that is customer-centric.
I'm sorry, you'll need, I think, to put that into some language that I can better understand. When you say a technical issue but not one that's customer-centric, what does that mean?
Well, I think, if I understand it correctly, and I'm only going on what's in the documents, but it would seem to me that technically there was an entitlement that AMP could claim in relation to those commissions and chose this practice to do it. To the extent that that is or isn't compliant with FOFA is something I'm unclear of, because I think it's a legal question in that regard. That's the only point I'm making.
I understand.
Because I think you're asking me, is that going to be FOFA compliant? I'm not sure, and it would be wrong of me to suggest that I do know, because I don't. But the point I would agree with is that it's certainly not something that is customer-centric. In other words, it's not something that's in the interest of the customer.
No, it's in the interest of AMP.
Yes, it is, without question.
So perhaps if I put my question to you in a different way, do you think that acting in the interests of AMP rather than the interests of customers is the same as ensuring compliance of AMP's advice licensees with the FOFA reforms?
I'm not sure I know the answer to that question.
All
Mr.
right.
Hodge.
Can we bring up ASIC.0019.0001.0003? Now, have you seen this document before, Mr. Regan?
I can't bring it to mind. I don't believe it's in the witness statement.
It's certainly not in your witness statement.
Thank you.
Were you aware that there was a centralised log of decisions made by the Practice Proposition Steering Committee?
I don't believe I was.
Okay. You see at the bottom of the page an email from Mr. Minsinski to Ms. Parra.
Yes, I do.
And you'll recall from the documents we've already looked at, Mr. Minsinski was the owner in relation to issue 5 or item 5, FDS systems. And he's pointing out that there is an error in the log of the decisions made on the 24th of May 2013. You see, he says the steer code decisions log is incorrect for the following entry, and there's a single entry on the 24th of May 2013. He then, over the following page, explains how the log should have read, and I tender that document, Commissioner?
Exhibit 2.33, emails Rakic to Parra and others, 14 June 2013, ASIC 001900010003.
Now, I'm not sure if this attachment is linked as a separate document or not, but can we bring up ASIC.0019.0001.0005? Right, so this is the spreadsheet log, Mr. Regan, and if we go down to the bottom, this is the updated spreadsheet log. We go down to the bottom, and can we zoom in on SC11-D04? I'm not sure if that's readable for you.
Yes, it's fine.
Mr. Regan, great.
Mr. Hodge.
You'll see that what it's recording is a decision made on the 24th of May 2013 in relation to fee disclosure statements, existing orphans policies decisions, and it records the decision that needed to be made in column D. And then if we go over, scroll across, keep going, thank you, and then at the end it records what the decision was, and you'll see the decision being recorded is agreed the solution will be to dial back down fees after 3 or 6 months, so long as the client is not serviced by Horizon, investigate who has not actioned the policy in regards to the previous points.
Yes.
So tying these documents together then, this is the log reflecting the minutes that we've already looked at in relation to this meeting on the 24th of May 2013. Do you want to see the minutes? Let's bring that up. Can we bring up the document which is AMP.6000.0011.8670? And go to page .8672. And you'll see under the discussions, decisions, AM, that's Mr. Minsinski, advised ongoing advice fee in some orphan accounts have not been turned off. SC, that steering committee, agreed the solution will be to dial back down fees after 3 or 6 months, so long as the client is not serviced by Horizon.
Yes, so that's
So
the
this is-
item 5 from the 24 May?
That's the minutes of the 24th of May.
Yeah,
So that's the minutes. There's a centralised log. The log wasn't corrected until June, but the log, when it was corrected, reflected that decision.
thank you.
Commissioner, I didn't tender that earlier ASIC document, which is the spreadsheet. I should do
Exhibit
that.
2.34, decision log spreadsheet concerning meeting 24 May 2013, ASIC 0019 0001 0005.
Now, you raised, I think you raised a query before the break, Mr. Regan, about the proposition that that decision reflected the recommendations that had been set out by Mr. Magellan. So can we bring that document back up? That's Exhibit 2.32, ASIC.0019.0001.0075. And again, if we just go to page 2 first, you'll see, for the purposes of document change control, version 1.2 is dated the 21st of May 2013.
Yes, it is.
And then if we go back to a page we've already looked at, which is page 13, the page ending .0087. So this is that category 1 and 2. I think, to be fair to you, the part we were looking at in this is only concerned with existing orphan policies. That is, policies that are, or clients that are already in the bowler pool and are orphans. You understand that?
Yes.
And you'll see in the middle of the page in slightly smaller text.
Might have to get you to blow that one up too, if that's okay. Thank you.
So this is that category 1, which is,
Yes.
for category
Likely
1,
to
if
be sold.
they're likely to be sold, then issue them with an OFA, and then go down the page, category 2, that's the ones who are unlikely to be sold, and therefore it's recommended to dial down their fees immediately and therefore avoid having an FDS, because otherwise they might cancel it, lodge a complaint, possibly request compensation, and that would be a very negative customer experience. And then if we go over the page to page 14.0085, you'll see this is in relation to new orphan policies. I didn't take you to this, but in fairness, I think I should. So this is dealing with what happens when orphans come into existence after 1 July 2013, so they're not existing orphans.
Thank you.
And you'll see again, what's said is they should be categorised according to whether they are likely or unlikely to be sold.
Yes.
And if they are likely to be sold, then, sold within 3 months, then the recommendation is not to dial down their fees. And you see the asterisk there, 3 months grace period is a pre-existing business rule and is not a legal requirement.
Yes.
And category 1, which is the likely to be sold within 3 months, it is recommended that the ongoing fee be kept active for a maximum of 3 consecutive months for these policies. And if it's not on sold or transferred within the first 3 months, the ongoing fee should be dialed down and the ongoing fee arrangement terminated. And there's an explanation of what the rationale is. The rationale seems to be the ongoing fee can only be kept active for up to 3 months, otherwise a breach of contract has occurred. But as you've already agreed with me, there's no reason why the fees should be kept active for any time, is there? You agree, there's no reason.
So I think the only question that can occur is in the strict definition of the Corporations Act, which refers to in some instances, the intention to supply the service.
I understand.
Yep.
We'll come back to that. And then you see category 2, which is, so this is new orphan policies that are unlikely, And the recommendation with respect to them is that their fees be immediately dialed down for the same very negative customer experience reasons. And then if we go to the very last page of the document, which is risks and issues, what's explained is under the new FOFA fee disclosure statement environment, there are several risks and issues related to not immediately dialing down the ongoing fee on orphan non-service policy and maintaining the ongoing fee for up to 3 months on an orphan policy without providing advice or service in return. They include reputational damage to AMP, legal and compliance issues, possible anti-avoidance issue if AMP doesn't dial down ongoing fees, and then some various things about the administrative inconvenience of this. So that's the paper. And I'll go back to my question. Do you agree that the decision that was ultimately made reflected the recommendation that had been made by Mr. Magellan?
Yes, I believe it does.
All right. Now, can we then bring up the Clayton Utz report, which is AMP.6000.0038.0001? And go to page 15 of that document, paragraph 21. And blow that up and you'll see what's said is, it also appears that is the 90-day rule to have evolved out of discussions at a risk meeting or regular management meeting rather than being evidence-based or the result of any recommendation or consultation prior to its implementation as a business rule or practice. There is no evidence that it was formally documented or formed part of the bowler policy. That statement, and I don't say this in any way critically of Clayton Utz, but that statement is incorrect. Do you agree? Based on the documents we've looked at?
Yes.
And the likely reason it is incorrect is simply that Clayton Utz wasn't provided with these documents.
That's quite possible.
And can we then go to AMP.0001.0025.0913? So this is an internal email or chain of internal emails at AMP, and you'll see the original email is sent by Mr. Magellan attaching a PowerPoint presentation.
Yes, I see the email.
Have you looked at this email and PowerPoint presentation before?
I'd have to see the PowerPoint presentation.
All right, well, let's...
Is that in the... Is that one of the exhibits?
No.
No.
Can we bring up AMP.0001.0025.0917? So this is the PowerPoint presentation that was attached. Do you remember having seen this?
I've seen something that's like this, but I couldn't be certain of this document.
All right, well, can we go to page 0920? The fourth page in.
I can't recall seeing this document.
So can we blow up the sentence, fourth from the top beginning, ongoing fee can be charged? You'll see what's set out in the presentation is ongoing fee can be charged up to 31 January 2014, but if contracts are not being serviced in interim, then this course of action risks ASIC breach and/or customer complaints.
Yes.
I think you agreed with this several times yesterday, but there was no possibility of those contracts being serviced if they're in the bowler pool as at 2013, was there?
I thought what was discussed was that there were various attempts to service at points in time through AMP Direct, but I couldn't be certain of those, or I can't be certain of those attempts and what service was provided at what points in time. Let's
just pause on that. Very recently, in the last year under your watch, there has been an attempt to come up with a capacity to actually provide proper planning services to clients in the bowler pool. Do you agree with that?
That's correct.
And that requires having planners available to conduct things like annual reviews.
That's correct.
Things like that, be actually able to provide personal financial advice.
Absolutely. Mm.
And until that initiative by you in the last year, there was no capacity within AMP to provide annual reviews or personal financial advice to people within the bowler pool.
Mr. Hodge, all I'm saying is that I wasn't in the business at that time, so I just can't be certain of what particular arrangements were there.
All right. Can I suggest to you what this indicates is that it was just accepted as a fact of life within AMP as at September 2013 that they would chance their arm with an ASIC breach or customer complaints.
I mean, I don't think I accept your language, but I'm not in a position to confirm that.
And then if we go to the document which ends .0934, I'm sorry, the page that ends .0934, I apologise. Thank you. So this is explaining what the, at that time, current policies and processes are, and the ongoing fee is retained, or is said to be retained for 3 or 6 months on contracts that are ring-fenced for a pre-arranged on-sale to another planner, or dialed down immediately for contracts that are not ring-fenced. Do you see that?
So which point was that, Mr. Hodge?
Point number 1 at the top of the page, under current policy and process. And then, so that's what's described to be the current process. If you then look at what is now to be recommended...
The date of that was, Mr. Hodge, when you said current process? What was the date on that?
The date of that was the 29th of August 2013.
Thank you.
And then you'll see what's recommended to be the process is that the ongoing fee will be retained for 3 or 6 months for all contracts while AMP attempts to on-sell, after which the ongoing fee is dialed down.
Yes.
And that seems to suggest that what was being proposed was that AMP would go even further than what had originally been recommended by Mr. Magellan, which you'll recall was dial down if unlikely to sell, but leave on if likely to sell, to now just leaving on for everyone.
On the face of it, yes. I don't know what other context is involved in that, but I understand your point.
And have you made any investigation as to whether that's what happened?
No.
Okay. And then if we look at page .0935, this might explain why it is that there's this reference to 3 months and 6 months. You see row 3, if we blow that up. See, activity 3, confirm how long the ongoing fee can remain active on orphan clients sold by AMP, FP, Hillross, Charter and other licensees before dialing down. And the explanation is the pre-existing rule for AMP, FP is 3 months, but for Hillross it's actually 6 months.
Yes.
And hence the reason it would seem why there's these constant references to 3 or 6 months. And you'll see the licensee rep, you'll see that the owners of that are the licensee representatives and Mr. Van Leeuwen.
Yes.
Do you know who Mr. Van Leeuwen was at the time?
Yes, I do.
What was his position?
I think he was involved in register management, was his role at that time.
Was he the head of client registers?
He may well have been. I'm not familiar.
All right. And how does he fit within the advice business?
Back then, I wasn't actually involved with the business at that time.
Is there still a head of client registers?
Yes, there is.
And does the head of client registers report to you?
No.
Who does the head of client registers report to?
Head of client registers reports to Mr. Dayton, who reports to Mr. Ryman.
Reports to who?
Mr. Ryman.
Is Mr. Ryman a different group executive?
Yes, he is.
I see. So this is now crossing out of advice and into another section of the business.
That's correct.
All right. And at the top of the page, you'll see what's set out in the PowerPoint presentation in row 1 is confirm which contracts should have ongoing fee dialed down and which will be serviced. And the first point is recording that decision we've already looked at. Decision was made that contracts which won't be on-sold will have their ongoing fee dialed down. And again, the owner for that are the licensee reps and Mr. Van Leeuwen. On that, can you just explain who would be the licensee reps?
I don't know.
Okay. I tender that document, Commissioner.
Is it just the PowerPoint,
Actually,
Mr.
I
Hodge?
tender both documents, Commissioner, thank you.
Exhibit 2.35 will be emails between Byrne and Marsh and others, 30 August 2013, AMP 0001 00250913. 2.36 will be PowerPoint presentation, client transfer policies and processes. Is it 29 August 2013, I think you said, Mr. Hodge?
29 August 2013 is the date of the email that sends it,
I see.
Commissioner.
Well, I won't include the date in that. AMP 0001 00250917, Exhibit 2.36.
Thank you, Commissioner. Commissioner, can I just indicate there's one other document or set of documents that I need to take the witness to in relation to this line of questioning. However, it's unclear whether the confidentiality claims have been resolved over them. What I propose to do, and I should add some detail to that, they were documents that were only produced to us by AMP either very late on Sunday night or very early on Monday morning. What I propose to do is, as I won't conclude Mr. Regan by lunch, we'll attempt to resolve that issue over lunch so that we can then deal with it immediately after lunch.
Right. How much longer do you expect to be with Mr. Regan, and how are we travelling for time?
We're travelling all right. I expect that I will...
It's deeply informative, Mr. Hodge.
I expect that I'll still be going for some period of time after lunch with Mr. Regan, and then we'll move on to Mr. Keating this afternoon.
Yes.
And I hope to move on to the next witness after that this afternoon, but that may depend on some things.
Yes.
Thank you,
I'll
Commissioner.
stop interrupting you.
Now, Mr. Regan, I want to move to a different topic, which is AMP's approach to fees and commissions. And I'll have your statement brought up. Can we go to paragraph 88 of that statement? You were You were asked a question which was, for each calendar year from 1 January 2008 to date, to identify the total amount of ongoing fees charged to customers of each of the licensees or their authorised representatives. And you explain in answer to that question some of the difficulties that AMP had with that. But one of the explanations in paragraph 88 is that it is not readily possible to differentiate between OSFs, which are ongoing service fees, and commissions. Can you explain to the Commissioner why that is?
I can't give you a particularly good technical explanation. I'm not familiar with the way those operations work at all. The best I can give you is that when we started looking for this information, that was the explanation we were given.
Is the explanation that within the systems of AMP, there's simply no distinction drawn between whether something is a fee for service or a commission?
Mr Hodge, I would be speculating. I just simply don't know enough of the detail to answer that.
And you see in the first sentence of paragraph 88, you say, unless an advisor's files are subject to an audit by the advice licensee in respect of those fees, the advice licensee does not ordinarily know the amount charged by an advisor directly to the customer. Can you explain what you mean by that?
What I mean by that is that I think it requires a physical examination of the relevant file to understand. Again, I'm not close to the detail of this at all, Mr Hodge.
Does this apply only to fees that are being invoiced by the advisor to the client, or does it also apply to fees that are being directly debited from a product or platform?
I can give you a probable answer, if that's satisfactory.
Just do the best you can, Mr Regan.
So the best I can do is I think that's the case. I think it applies to both, but I'm not entirely certain. Again, I'm not particularly close to the detail of this.
All right. And then can we blow up paragraph 89? You'll see it said, from records held in respect of AMP products, by identifying the relevant products and ongoing service fees, it is possible to estimate the total amount of the ongoing service fees charged to customers by advisors.
Yes.
Can you explain how that estimation was done?
No, I can't.
All right. So when we come over to paragraph 92 of your statement, which is on page 22 in the table there, thank you. And what's set out is an estimate of ongoing fees from the period 1 January 2008 to 31 December 2015. You're not sure how that estimate was made by AMP?
No, I'm not, Mr Hodge. I have relied heavily on the work of others to produce that table.
And yesterday you gave some evidence, the effect of which was that for the year 2016, you thought that about 30% of the revenue coming from clients that went into BOLA would be fees for service as distinct from commission. Do you recall that evidence?
Yes, I think I was trying to estimate that figure, and I think I probably drew it from the table because of the number I was giving you. If I looked at 2015, my recollection of the total amount of revenue paid on an ongoing basis, fees and commissions to advisors, is about 600 million, and just a quick back of the envelope tells me that's the approximation.
Sorry, total revenue paid to advisors in what year?
Approximately today,
Right.
as in the current state, we would be paying about $600 million of total ongoing revenue to advisors.
And that would be comprised of both?
Fees and commissions, yes.
I see. And the most up-to-date information in your statement seems to be for 2015, which is
Yes.
saying that 120 $12.7 million for fees was charged to customers.
That's for A&P financial planning.
I
yes,
see.
that 600 million I gave you
Is the total
yeah.
for Charter,
And-
Hill Ross
yes.
and IPAC.
That's correct.
I see.
That number is approximate.
I understand.
As in my estimate is approximate, yeah,
Of 600 million is approximate, or the percentage is?
as a percentage.
Okay.
Yeah. You asked me to give you a number, and so I've done the best I could with that.
I appreciate that.
Yeah.
And that would mean then, even today, it remains the case that the majority of revenue that is being paid to financial planners within the AMP network is derived from grandfathered commissions. Is that right?
I think that would be correct.
Or is the other part of the commission, to be fair, there's a few things that are excluded, so life insurance policies, would that be caught up here?
No, the figure I've given you, I think, is the total for all products,
Yes.
as in the commissions.
Is any commission payable on life insurance included as part of that figure for $600
Yes,
million?
it is.
Okay.
Yes, it
And
is.
so some of that commission is not grandfathered commission?
That's correct. Life insurance is treated differently under the conflicted remuneration rules.
But much of it then presumably is grandfathered commission?
Yes, I think that's correct, yeah.
All right. And you've explained in your statement that there is a policy document that was provided to planners about what fee disclosure statements they needed to provide.
Quality advice fundamental.
That might be the name of the document. We'll bring it up. It's tab 7 to Mr. Regan's statement.
So just to explain that, quality advice fundamental, or QAF, is the general name we give to advisors' notifications.
Yes. So if you have a look on the screen, this is fee disclosure statements, quality, that's the document
That's the
you're thinking
one,
of?
yeah.
And so this explains what disclosure what disclosure a planner or authorised representative should be making to a client.
Yes, that's correct.
And if we go to page 15 of that document,
Now, this is the July 2013 version, isn't it?
yes, has it been updated?
I believe it has.
Okay.
I believe there's a... I'll get it wrong, but I thought there was later versions.
Oh, I'm sorry.
And I thought there was, in the witness statement, an exhibit for a later version, a 2015 version.
I understand. If we go to tab 8 then, which is amp.6000.0020.5191. This is the later version that you're thinking of.
Yes.
And if we go to page 8 of that document, .5198, what this is explaining to advisors is that and you'll see this under the heading ongoing advice fees, an advisor is only required to give a client a fee disclosure statement or an opt-in renewal notice where the advisor is charging the client an ongoing advice fee for more than 12 months.
Yes.
And then you'll see there's 2 sections at the bottom of the page. One is describing what is an ongoing advice fee, and the other is describing what is not an ongoing advice fee.
Yes.
And then if you go over the page to page 9, you'll see at the bottom of the page there's an explanation to the planners of the grandfathering arrangements.
Yes.
And I want to understand AMP's attitude to grandfathering commissions. It is possible, isn't it, for an AMP authorised representative or financial planner to rebate to the client the entire amount of a commission received.
Yes, they can.
And one possible arrangement that some financial planners would or have entered into with clients is that they rebate the entire amount of the commission and then charge a separate ongoing advice fee for whatever the ongoing advice is that they're providing.
Yes.
You're familiar with that type of arrangement?
Yes, I've read of it. Yes. Yes.
Is that not an arrangement that's encouraged within AMP?
couldn't comment, to be honest, Mr Hodge.
Well, you are the group executive for the advice business. You are ultimately responsible, I assume, for the 2,800 planners that sit within the AMP network of planners. Is it really your position that you cannot comment on AMP's attitude as to the idea of dialing down commissions?
So all I was getting at was that I'm not sure of what direction has been given to our advisors. I'm simply not close enough to the detail in that regard.
If we continue through with the nature of this arrangement that I'm talking about, if you dial down the entire commission, or possibly by changing it with the product issuer, or alternatively by rebating the entire commission to the client, and then you charge the client an ongoing service fee, that means that all of the legislative arrangements under FOFA apply to that ongoing service fee. You agree?
Yes.
If the only fee that a planner is charging to a client is an ongoing fee, then they need to provide a fee disclosure statement to the client.
That's correct.
For the entire amount that they're charging to the client.
That's correct.
And similarly, they need to provide opt-in notices to the client.
That's correct.
And the client needs to opt in.
That's correct.
Does AMP, in respect of its advice business of which you are the head, have an attitude as to whether it would be appropriate for financial planners to not charge or take commissions and to instead only charge fees for advice, service fees for advice?
So we leave that at the contract level, or the negotiated level with the client and the advisor, is my understanding of it.
So AMP has no view as to whether its planners should or should not cease retaining commissions and only charge for services provided?
I haven't seen any specific communications in that regard. If you're...
No, Mr Regan, you're the group executive in charge of advice. Ultimately, the decision must be yours, made in consultation with the GLT, I assume. You're responsible for it. You might discuss it with the GLT. Do you agree?
I haven't had discussions in that regard with the GLT.
Have you turned your mind at all to the question of whether it is appropriate for planners to continue to take commissions in respect of their clients?
My preference would be for fee arrangements, but the arrangements that exist between the clients and their advisors are the arrangements that exist between the clients and the advisors.
Is there anything that would stop AMP from adopting that as a position, an official position, that its planners should not be taking commissions from products and should only be receiving fees for service?
Could you just...
Is there anything that would stop or impede AMP from taking as its official position that its planners should only be receiving fees for service and not taking commissions?
So it's able to be done, if that's the question?
Yes.
Yes, we could adopt that position, yes.
And why don't you?
I'll be honest and say, Mr Hodge, I haven't turned my mind to it. The arrangements that we have in place are to allow the planners to negotiate their own arrangements with their clients, and we're working through the overall grandfathering period as things currently stand.
I'm sorry, when you say working through the overall grandfathering period, what does that mean?
So progressively the commissions are dropping away and the fees are taking over. So as clients, for example, negotiated into new arrangements, the commissions fall away, as we've noted, or alternatively, customers complete their arrangements, new customers come on. But as you could tell from that table, the proportion of fees as a function of the total, if you accept the percentage I gave you before, if you go back to the start of the period, you know, it's gone from something like 10% being fees to now something like 40% being fees.
I think you said 30% yesterday.
Yes, 30 or 40%, yeah. I'm approximating for the sake of the discussion. But the point I'm making is that that the commissions are phasing out over time, which, as I understand it, was the approach that was a function of FOFA.
And that's over a period of what, almost 5 years?
Yes.
Does AMP have any estimate as to how long it will take for commissions to phase out entirely?
I don't have that estimate, Mr Hodge.
Do you, as the head of advice, as the group executive in charge of advice, have a view about whether the taking or continued taking of commissions is compatible with the purported professionalisation of financial planners?
Well, as I said before, my preference would be for fee arrangements expressly.
And is that because you don't think that it is compatible with the idea of financial planners being a profession, that they continue to receive commissions?
I think fees are much more consistent with a professional environment, yes.
I want to move to another topic, Mr. Regan, and this is concerned with the triggers within AMP for a potential investigation in relation to the 90-day rule. Can we bring up AMP.6000.0051.1982? So this is the pack for the Group Risk and Compliance Committee meeting on the 10th of November 2015.
Yes, it is.
And if we go to the I should just check one thing. As I understand it, this committee meets 4 times a year, is that right?
I think it is a quarterly forum, yes. I do believe there is a proposal that it become a monthly forum. I'm not sure whether that's been implemented yet.
How long has that proposal been on the table for?
It was suggested, I think, towards the end of 2017. So recent is the answer to the question.
Right. If we go to page 3 of the document, see, that's the agenda for the relevant meeting, and item 6E is regulatory contact.
Yes.
And if we go over the page to page 1985, you can see the list of who comprises the committee and the attendees. It doesn't appear that at the time you were a member of the committee.
No, that would have been during my time in New Zealand.
I see. But Mr. Caprioli, your predecessor as the Group Executive for Advice, was a member of the committee?
Yes.
And Mr. Mellor and Mr. Salter were members of the committee?
Yes, they were.
And Mr. Sainsbury, I think you referred to him before. What is Mr. Sainsbury's role?
I can't recall referring to Mr. Sainsbury, but he's the Chief Customer Officer of AMP.
Oh, I'm sorry, who is the person to whom ultimately Justin Morgan would have been responsible?
Under that structure, Rob Caprioli. But if you're going back to our earlier discussion about the registers,
yes,
that would be Mr. Ryman.
I see. And if we go then to, and I'm sorry, the page number is blocked out on my version, but it's the 6th page of the document. Let's take that down. Commissioner will attempt to resolve whatever the issue is about that over lunch. Mr. Regan, you've exhibited the remediation plan to your statement. You don't recall?
Yes. Which tab is that?
think it's tab 35.
Thank
Mr.
you.
Regan. Just check that.
I don't think it is 35, Mr Hodge.
Sorry, I've misled you. I think it may be
Got it up on
45.
the-
45?
We got it up?
45, thank you.
Ah, yes.
Should
It is
thank
45,
law and
yeah.
order. You've got that there, Mr. Regan?
Yes, I do.
Now, that plan, is that the current investigation and remediation plan?
Now, Mr Hodge, I became aware of this document in the course of preparing for this commission, so I must say that is the first time I'd seen that document. But I do note from the way in which it's represented inside that it has a currency to the middle of 2017.
I see. Well, you are aware, I assume, that the document refers to various call scripts and Q&As and
Yes.
letters that were sent to clients?
Yes, I believe so, yeah.
All right. And can I bring up AMP.6000.0051.2412? Sorry, that's a different document. I hope that's clear. So this is the internal Q&A sheet that's referred to, and if we go to page 2415, this may have been broken up as a separate document. It's been broken up as a separate document, so it should be AMP.6000.0051.2415. You'll see this is the outbound call script,
Yes,
and you understand or are aware that there's a call script for the customer contact centre at AMP to call up clients who need to be remediated in respect of the bowler issues?
I don't have first-hand information about the process, Mr Hodge.
Well, do you know that clients are being called in order to be refunded with money?
Yes, I believe they are.
Okay. Are you aware that there is a script for them to do that?
I'm not familiar with the script, no.
Okay.
I would understand that there would be, but I make the point, there's a level of detail here that I'm simply not familiar with.
Well, can we blow up the middle of the page, the section beginning operator, we want to let you know?
Yes, I can see that.
So you see the script that's being used is operator, we want to let you know about a refund you are receiving from us. Some fees were charged in error to your whatever account type was. This happened due to an administrative error which has now been fixed. We want to apologise for the mistake.
Yes,
You agree, I'm sure, that that statement to a customer would be false if it was charged if the fees were charged because of the 3-month rule or ring fencing?
yes.
And are you aware of any decision by AMP to attempt to revise its call script or contact clients that have already been misled in this way?
No, I'm not.
All right, attend to that document, Commissioner.
Exhibit 2.37, fee remediation outbound call script, January 2016, AMP 6000.00512415.
Now, I'm going to show you some other documents, Mr. Regan. I fear that we're going to find that they are also going to be redacted in some way, and if that happens, I think there'll be a hard copy that I'll show you, and I suspect I can question you adequately without needing to shut this down. So can we bring up AMP.6000.0019.8019? So this is the agenda for the meeting of the Advice, Culture and Compliance Board Committee on the 15th of December 2017.
Yes.
Now, as I understand it, this is a committee of the board, is that right?
It is.
This is the committee where you noted before that the acronym is ACCC,
Yes.
which the actual ACCC would probably not be particularly pleased about. And you're not a member of the committee because you're not a director,
That's correct.
but you are somebody who attends
I
the
am.
committee meetings, although this one you seem to have attended via telephone conference.
That's correct.
All right. Can we go to page 18 of that document ending in .8036? I'll just see, Mr. Regan, if it's possible to have provided to you a copy, a hard copy of that document.
Some point after lunch, I'd be grateful to know, one, when this document was produced, two, why it was produced in this form, if, as the premise for your question appears to be, this is centrally relevant.
Yes.
Those are matters that perhaps can be taken up after lunch.
Commissioner, I think it appears that we don't have a hard copy readily available, so perhaps could I ask you
Well,
to
perhaps
adjourn
those instructing Mr. Crutchfield can supply us with a copy unredacted. Now,
Get instruction, John. I think it looks like it's going to result in some kind of a delay. My friend wants to move on to another topic and see what we can do.
well, it's
on it.
not good enough, Mr. Crutchfield.
Well, I'm not in a position to say whether it's not good enough or not, Commissioner, until I've got some instructions and know what the issue is. But I heard what you said, sir, and we'll address the matter.
Commissioner, could we adjourn? It may be that this hasn't been, it may in fact be my fault. It may be that this hasn't been considered as part of the relevant page spans.
Very well.
I'm grateful to my
2 o'clock.
friend.
Thank you, Commissioner.
2 o'clock. Yes, Mr. Hodge.
Thank you, Commissioner. Can we bring up the document we were looking at immediately before the break, which is AMP.6000.0019.8019?
Mr. Hodge, I recall from you showing that document in relation to your earlier questioning that in fact I have seen customer contact lists as a result of them being included in packs relating to that particular committee, so I was in error.
I see. And can we go to page 8036 of that document? Maybe that we need to do hard copies of this one. We'll just see. All right, we'll hand up a hard copy to you,
Thank you.
Mr. Regan. And one for the Commissioner.
Thanks.
So, Mr. Regan, just to clarify what we're looking at, this is the committee pack for a meeting of the Advice, Culture and Compliance Board Committee held on the 15th of December 2017.
Yes.
And if we go to page 15 of that document, and you'll see that's a memorandum from Pally Bargary, the Chief Risk Officer, to the Advice, Compliance and Culture Committee,
Yes,
dated the 11th of December 2017.
that it is.
And it's dealing with remediation for the ongoing service fees in relation to Bowler and also terminated advisors and also the IPAC breach.
Yes.
Out of curiosity, do you know why that document would have said to be not relevant?
I do not know the answer to that.
And then if we go over to page 19 of that document, you'll see this is another memorandum. I'm sorry, page 19 of that document, you'll see this is the attachment to that document which relates to the letters that are going out to the clients.
Yes.
And you see that as at this date, the letter that is going out to a client still says, "We want to let you know about a service fee mistakenly charged to your account. You were previously told that your service fee would be turned off, but this didn't happen. As a result, AMP received this fee from you in error." You see that?
Yes.
It's at the top of the page.
Yes.
And perhaps out of fairness, I should just explain why this is being attached to Mr. Bargry's memorandum. He says on the first page, on page 18, this paper responds to an action arising at the committee meeting on 1 December 2017, where the committee requested that management provide the committee with examples of customer remediation correspondence, template letter and scripting.
Yes.
So what has happened is there was a meeting of this committee on the 1st of December 2017. One of the things they asked to see was a copy of the correspondence that is being sent out to customers that are to be remediated. Mr. Bargary has provided a memorandum that attaches that correspondence. You agree?
Yes.
And what I read out to you, which referred to an error, that was the correspondence that was being sent out at that time to clients.
I'm just checking, if you don't mind, just the note there in regard to attachment A provides an example of the letter. So that was the original bowler breach. So I'm not sure that it's the current letter is my only question, Mr. Hodge.
Sorry.
And the reason it's an issue is that there was an error. There were letters that were sent out that were incorrect, and I'm just not quite sure what this particular letter refers to. So whether that is the current letter.
Well, if you go to page 18,
Yeah.
attachment A provides an example of a letter provided to customers in relation to breach 1, the original bowler breach. Additionally, call scripts
Yes.
that were provided to staff to respond to customer inquiries are also enclosed.
So I believe, I'm aware that one of the letters that went out to customers in relation to the original bowler breach was, I believe, incorrect. And
Because
so
it said it was an administrative error.
That's correct, yeah. And in fact, we had a particular action to go back to ASIC and inform ASIC of that, is my memory of
Yes.
the matter. But I'm not sure whether, it's a very similar letter is all I'm getting at, so I'm just not quite sure whether it's the revised letter or the original error, which we acknowledge was incorrect.
All right, well, we'll return to your point in a moment. If you go to page 21 of that document, see, this is the inbound call, question and answer script.
Yes.
And if you go to page 22, you see one of the questions is, why did this happen? So this is a question that a customer might ask if they call up AMP's customer call centre.
The only point
agree?
I'd make, Mr Hodge, is that that's dated January 2016.
Yes.
And so, again, I make the point, I'm not sure whether that was the current script at the time or whether Mr Bargary was providing the historical letter and script.
Well, go back to page 18 of the document, Mr Regan. What the committee asked for was examples of customer remediation correspondence, template letter and scripting. And Mr Bargary has provided this template letter and scripting as at the 10th of December 2017.
So I think it says the purpose. Attachment A provides an example of a letter provided to customers in relation to
Breach 1, the original bowler breach. Yes.
That's why I thought it might have related to the previous iteration of the letter that we acknowledge was not correct.
Do you think there's some further iteration of the letter?
There could be.
Have you seen a further iteration
I can't
of the
recall,
letter?
Mr Hodge, I'm sorry.
All right. Well, in any event, can we at least agree on this, that there is the Q&A script that was provided by Mr Bargary to the committee on the 10th of December 2017, which begins at page 21,
Yes.
has a question on page 22 where the question is, why did this happen? And the answer that the call centre staffer is to give is, the customer-advisor relationship will usually stop when the advisor retires or when the customer chooses to deal directly with AMP. In some instances, when this has occurred, an administrative error has led to the fees not being switched off and subsequently continuing to be charged to the customer.
Yes.
And insofar as that was being said to, we've got the document now, insofar as that was being said to people that were being remediated in respect of the bowler breach, that was untrue, at least insofar as it related to people that had been subjected to the 90-day exception and ring fencing. Do you agree?
Yes, I do. I just make the point that, again, that's dated January 2016, so I'm not sure it's the up-to-date script. But your point is correct.
I'll ask you again, have you seen any later script than this?
I may have, I can't recall.
All right. And can I ask, quite apart from the bowler breach, is it AMP's position that the customer-advisor relationship will usually stop when the advisor retires or when the customer chooses to deal directly with AMP?
I don't know if I understand. Could you just repeat the question?
Well, the sentence, which is a bit confusing, is the customer-advisor relationship will usually stop when the advisor retires or when the customer chooses to deal directly with AMP. Now, insofar as that means that advisor is not, the specific advisor is no longer providing services, that must be true. That is, there's no relationship with a particular advisor if that advisor has retired. You agree?
So just take me to the actual sentence, if you don't
Yes.
mind. Sir.
Page 22 at the
Yes,
top. The customer-advisor relationship will usually stop when the advisor retires or when the customer chooses to deal directly with AMP.
I don't know whether this is directed towards a particular circumstance, but most relationships, I would think, are transferred between advisors. So I'm not sure whether the meaning is intended to be the incumbent advisor
Yes.
or an advised relationship generally, but it follows that if the advisor retires, then that relationship comes to an end. But the reality is that many of them go on to other relationships with other advisors.
And indeed, that is the premise on which AMP's advice business model operates, isn't it?
Substantially, yes.
That it is possible to sell a client as a stream of revenue.
That's correct.
Now, if we go to page 28 of that document, You'll see this is the outbound call script that was provided to the committee on the 10th of December 2017. And you'll see, you got that there, Mr. Regan?
Yes, I do. I was just trying to go back to understand the context for the document as well. But page 23, was it?
28, Mr. Regan.
28, I beg your pardon.
And you see in the middle of the page, what the operator is to say is, we want to let you know about a refund you're receiving from us. Some fees were charged in error. This happened due to an administrative error which has now been fixed. We want to apologise for the mistake. And I take it you make the same point, which is, this is dated January 2016. It would be incorrect insofar as it was said to anybody who had been subjected to the 90-day rule or ring fencing, but you don't know whether there was an updated script or not.
That's correct.
Now, can I show you AMP.6000.0019.8252? So this is the next meeting of the Advice, Culture and Compliance Board Committee.
Have
And you
we
see,
dealt with the earlier one
I'm
as
sorry,
an exhibit? I don't think we
No, we haven't.
have we?
no, Commissioner.
Exhibit 2.38, Agenda Advice, Culture and Compliance Board Committee, 15 December 17, AMP 600000198019, Exhibit 2.38.
Thank you, Commissioner. So now this next document is the meeting pack for the next meeting of the Advice, Culture and Compliance Board Committee. You see it's the 23rd of January 2018.
Just to clarify, that's only on the screen.
That's
it's
only
not in
on the
this
screen.
pack.
Yes.
Thank you.
That's right. You see that on the screen
Yes,
there?
I do. Could we make it a little larger if that's okay?
Yes. So you'll see this sets out the agenda for the meeting. If we go to page 2 of that document, .8253, these are the minutes of the preceding meeting on the 15th of December 2017 that have been approved by the chairman. You see that at the top?
Yes.
And it's the meeting of the 15th of December 2017.
Yes.
And then if we go to page 3 of the document, which is .8254, and you'll see, if we can blow up section 2 at the top, 2. Thank you. You'll see what's minuted is the committee noted the memorandum from Pally Balgry titled Advice Licence Management dated 10 December 2017, and that was the memorandum we've looked at. The committee requested that in cases where fees continued to be charged to clients under the 90-day exception, the language in future client remediation letters be amended to more accurately characterise the error.
Yes.
Do you remember the discussion about this item?
And I think that's what I was referring to earlier, where I think the letter was incorrect and that the letter was to be corrected, and then we were to revert to ASIC to inform them about the nature of that being so.
Right, well, let's just break it down. Do you have any recollection of the meeting of the committee on the 15th of December 2017?
I do. I did telephone into that meeting.
Do you recall a discussion about the content of the letter?
I can't specifically recall it, Mr. Hodge.
Do you recall why the committee decided that the language in future client remediation letters would be amended, but clients that had already received the incorrect letters would not be updated?
It's, as I indicated earlier, I believe that was to be a matter clarified with ASIC.
I think I understand, but let me just see if this is accurate. The committee recognised, as far as you can recall, that there was something not quite right about those templates and call scripts,
That's correct.
because insofar as they were being used in relation to clients under the 90-day exception, they were incorrect
That's my recollection.
and they were misleading your clients.
That's correct, yeah.
And the committee thought that for future client remediation letters, the language should be changed. Is that right?
That's correct.
And have you seen any updated draft of those?
I can't recall, Mr Hodge.
All right. And you think there was also an issue about dealing with ASIC about what had already been said to clients. Is that right?
That's my recollection, yes.
And do you recall what the position of the committee was about dealing with clients that had already been contacted using these templates and scripts?
I can't recall.
All right. I tender that document, Commissioner.
Meeting pack Advice Culture and Compliance Board Committee 23 January 2018, AMP 600000198252, Exhibit 2.39.
And now can we bring up AMP.6000.0019.8480? So you see, this is the agenda or pack for the next meeting of that same committee on the 16th of February 2018.
Yes.
And if we go to page 29 of that document, which is .8508, you'll see this is a memorandum from Mr. Bargary about customer remediation.
Yes.
And if we go over to page 30, which is .8509, and we blow up the section under the heading Client Letters to ASIC 90-day exception. Now, I'll read that out for you, Mr. Regan. It says, at the last meeting, Advice Compliance undertook to reach out to ASIC to advise that with respect to a limited cohort of clients, the fee refund letters had used the words mistaken or error to describe the fees paid, whereas having subsequently completed our investigations, we are now aware that those clients were subject to the practice referred to as the 90-day exception. In discussions with ASIC, it was emphasised that the letters reflected our understanding of the root cause at the time and that the wording used does not change the outcome to clients, which is that they have been remediated in line with AMP's remediation framework. ASIC have been provided with copies of the letters to review to enable them to determine if any further action is required. Now, does that assist you to recall what the position was of the committee with respect to clients that had been misled by the earlier communications?
I can't really recall, Mr Hodge, I'm sorry.
You see the part which says, in discussions with ASIC, it was emphasised that the letters reflected our understanding of the root cause at the time and that the wording used does not change the outcome to clients,
Yes.
which is that they have been remediated in line with AMP's remediation framework. That seems to suggest that the position that AMP was adopting with ASIC was to say the letters were okay because they reflected what we said at the time, what we thought at the time, and anyway, no harm, no foul with respect to the clients.
I would agree with you.
And that the position of AMP was that it didn't want to have to contact clients that it had already contacted to correct its misleading of them. Was that the position of AMP?
I'm unclear. My sense is, and I'd be going to speculation to go any further, so I'll resist doing that.
All right. I'll move back to a different topic. I attend to that document, yes, Commissioner.
Meeting pack Advice Culture and Compliance Board Committee 16 February 18, AMP 600000198480 will be Exhibit 2.40.
Now, the other document we attempted to look at earlier was AMP.6000.0051.1982, which was the Group Risk and Compliance Committee meeting on the 10th of November 2015. Can we bring that up?
Could I have the number again?
I'm sorry, yes, it's AMP.6000.0051.1982.
Thank you.
You recall we started to look at this document, Mr. Regan?
Yes, Mr Hodge.
And then we looked already at page 3, we'll just briefly go to that, which shows the agenda.
We don't have page 5.
And you'll see 6E is regulatory contact.
Yes.
And then if we go to page 228, and can we blow up row C? So this is setting out the reporting to the Group Risk and Compliance Committee as at the end of 2015 in relation to the bowler breaches. You see that, Mr. Regan?
Yes, I do.
Now, obviously this is in error or misleading in the sense that it says in relation to administrative failure to turn off ongoing fees for clients. Well, that is what had been reported to ASIC, so in that sense it's not in error, but it's not an accurate reflection of the reason that fees had continued to be charged. What I'm interested in is this. You'll recall we looked at the 2015 external audit report of PwC, who emphasised that there was no process for root cause analysis within AMP. You recall that? And as far as you are aware, the notification of this breach to the Group Risk and Compliance Committee did not cause them to commission any investigation into the root cause of this failure?
I'm not aware, Mr Hodge.
Well, you're not aware of any such analysis or investigation having been done? And if such a breach was now reported to the Group Risk and Compliance Committee, would a different attitude be taken?
It would be different in that since that time there's been a Risk and Compliance Committee formed that I chair, and that's referred to in my witness statement. So it would review such incidents before they're passed on to the Group Risk and Compliance Committee. So I do believe there would be more rigour today.
Well, I'm not sure you're quite answering my question. What I'm trying to get at, Mr. Regan, is that no investigation into the root cause of the breach was commissioned in 2015. You agree?
As far as, yes, I think that's correct.
And is this a case where there would now be a root cause analysis done if such a breach was brought up to the Group Risk and Compliance Committee?
I believe it would.
All right. Now then, the next document that I want to go to is AMP.6. I'm sorry, I tendered that document, Commissioner.
Group Risk and Compliance Committee meeting pack, meeting 4 of 2015, AMP 6000-0051, 1982, exhibit 2.41.
And the next document I'll go to is AMP.6000.0007.4466. Now you see this is a year later, the papers for the Group Risk and Compliance Committee meeting of the 14th of November 2016.
Yes.
And if we go to page 39 of that document, you'll see this is a quarterly update to the committee in relation to advisor monitoring.
Yes.
And I think I'd understood from what you said yesterday that when it comes to advisors failing to provide services in exchange for fees, the only way that AMP has to detect that is to conduct an audit of the advisor's practice. Is that right? Other than complaints.
Yes, I think that's correct.
Can you think of any other way that they can detect it?
I'm just having a mental blank, I'm sorry.
That's right.
I do think there might be, but I just can't bring it to mind at the moment.
All right. We see about two-thirds of the way down the page, it says 526 advisor audits have been deferred for various reasons. 47.5% of these relate to advisors who have informed us they have no intention to write any business.
Yes.
And as I understand it, that means that, oh, I'm sorry, actually we should go over the page to see this more clearly. So over to page 41. Sorry, 41. Yes, there we go. You see, this explains it in more detail. In the second paragraph, there are 526 audits which are currently deferred. 47.5% of these relate to advisors who have informed us that they have not provided advice during the relevant period leading up to the scheduled audit date and have no intention to do so. You see that there?
Yes, I do.
What I'm trying to understand is, given that one of the problems faced by AMP is that it has advisors charging for services that they are not providing, why would it refrain from auditing advisors simply because they say they're not going to provide any advice during the relevant period?
I wasn't involved, obviously, in the operation at that time, but I think we would also acknowledge that the audit process requires remediation. I think it would be acknowledged that the audit process was not as effective as it should have been, which is why we've embarked on a complete review of that program under what's referred to in my witness statement as Audit 2.0.
All right. I tender that document, Commissioner.
Group Risk and Compliance Committee meeting, papers 14 November 2016, AMP 6000007 4466 will be Exhibit 2.42.
Thank you. Now, Mr. Regan, I want to now move to the topic of why, from the perspective of AMP, these issues of not switching off fees for service occurred. And you've given some evidence about that in your statement. If we can go first to paragraph 164 of your statement. Should be coming, I'm sorry, it's page 33 of the statement.
Yes, I have it open.
Thank you. And what you repeat here is something that was said in the AMP group's submission to the Commission. I just want to understand some of the things you say about this. Can we start with subparagraph B, that one of the reasons is complex and manual systems for switching off ongoing service fees?
Yes.
And can you explain to us, at least when it comes to AMP's own internal products, that is its own platforms, is it difficult for AMP to switch off the charging of fees?
I don't have the detail of it, Mr. Hodge. I've relied on what I've been provided with.
Okay. Do you not know why it is that the complexity or the manual systems presents a difficulty to switching off fees?
I don't have first-hand knowledge, I'm sorry.
Okay. And then the second point, the third point is subparagraph C, that there's no end-to-end accountability for the process of switching off ongoing service fees. Do you know what that means?
I understand it means that it's a distributed process across a number of functional areas, but beyond that I can't help you.
No one is responsible for checking that it goes through at every stage. Is that the point?
I think there's implicit in that a verification issue.
And then the fourth point is poor understanding of the policies and processes for switching off ongoing service fees. Do you know what that means?
I think that means that it has become evident that people involved in the business haven't been sufficiently well trained to have such an understanding.
And then the fifth point is loss of corporate knowledge in relation to the processes and requirements in relation to the bowler system, which was exacerbated by corporate restructurings. Do you know what that means?
Again, I wasn't in the business at that time, but my understanding would be that the restructure that's being referred to there was the transfer of the relevant function referred to, I think, as register management generally, was shifted within the company, both in terms of operation but also in terms of geographic location, from Sydney to Melbourne. So that caused, I believe, an exodus of some staff, which I think is part of the problem.
And then the sixth point is failure to escalate matters of concern. Can you explain what that means?
That touches on the culture discussion that we had earlier, Mr. Hodge, and I think it's evident that there was inadequate escalation.
That is, that employees that are further down the chain have not escalated it or reported the issues all the way up the chain.
Yes, I think that's correct.
And does that mean reported up to the GLT?
It could mean that, yes.
And then the seventh point is an inadequate control environment. What does that mean?
So again, if we go to that discussion this morning, I think I mentioned 6 issues that drive the way in which the business operates, controls being a critical one, and I think we acknowledge that the control environment wasn't as strong as it should have been.
And then point A is insufficiently clear policy guidance in relation to the requirements for switching off ongoing service fees, and paragraph 165 seems to provide an explanation of what that's said to mean, which is that an aspect of the insufficiency of clear policy and guidance was the business practice which developed whereby exceptions to the bowler policy were granted to allow ongoing service fees to remain on when customers were transferred into the bowler pool. This business practice is known as the 90-day exception. I just want to understand what it is that you are saying here in your evidence in these paragraphs. Why is the fact of a business rule an example of insufficiently clear policy or guidance?
I believe that refers to the fact that the document, the bowler policy, wasn't explicit in that regard.
It didn't explicitly say what? That you should leave fees on for 90 days or that you shouldn't leave fees on at all?
That's correct. The latter.
The latter. Does, as you understand it, to any extent, does the group leadership team take responsibility for any of the failures in relation to bowler?
Yes.
If you go to paragraph 225 of your statement, which is on page 44. You note that it appears that no GLT member received any of the internal legal advices. And you say Mr. Caprioli was not provided with a copy of the relevant advice.
That's based on the findings of the Clayton Utz report.
I understand. Was there a particular reason that you wanted to emphasise that point?
As I recall, there was a suggestion at one point that Mr. Caprioli had been provided with that legal advice. I think that was in one of the versions of the Clayton Utz report. And then I think there was, as has been the case with other issues, an attempt to source whether or not that was the case.
Well, we'll come to that in a moment, but What does it matter whether Mr. Caprioli received a legal advice telling him that it wasn't lawful to continue to charge clients when you weren't going to provide them with any services?
Well, I think as far as Mr. Caprioli's understanding of the issue, I can't speak to that.
But you've emphasised that point at paragraph 225. That was one of the facts you've picked out from the Clayton Utz report. Why is that a point that, for the purposes of your evidence, is significant?
The point I think I'm making simply is that, as far as we can understand, Mr. Caprioli wasn't given that particular legal advice.
In fact, you say no GLT member received any of the internal legal advices.
That's as I understand it.
But you agreed with me it's obvious that this isn't something that you can lawfully do.
Yes, I agree.
So what does it matter whether any GLT member received a specific internal legal advice telling them that this wasn't lawful?
Can I just check back to the question? So it's responding to the question 12C, isn't it? So I presume you thought that it was necessary to complete the question.
Page 28.
28, is it? Thank you.
So 12C is when and how did officers or employees of AMP Limited first become aware of these matters?
Yes. I can't really add anything further to the answer I've given you, Mr. Hodge.
All right. Can we go to paragraph 34 of your statement? And a paragraph, I'm sorry, we'll just wait for that to come up. And in paragraph 34, you explain that once the board was alerted to these things, Clayton Utz was appointed to undertake an external and independent investigation of the matters set out in the letter of appointment.
Yes.
And there was a meeting that occurred after that report was completed that you attended with the chairman, Ms. Brenner, Mr. Meller, Mr. Salter, and Mr. Medcraft and Mr. Kell of ASIC. Do you recall that? You refer to it in paragraph 30 of your statement. So, I'm sorry, 36 of your statement.
Yes.
You recall attending that meeting?
Yes.
And at that meeting, ASIC were provided with a copy of the Clayton Utz report?
Yes, they were.
And they were also provided with a copy of the instructions to ASIC?
The instructions to ASIC?
I'm sorry, the instructions to Clayton Utz.
I can't recall.
Do you remember a discussion at that meeting about what Clayton Utz had been asked to do?
No,
Do you remember that meeting at all?
I remember the meeting, but I can't recall specifically that discussion.
Do you remember that it was, or do you remember whether it was explained to ASIC that Clayton Utz had been instructed to undertake an independent investigation of what had occurred?
Yes.
Can we bring up ASIC.0018.0001.3383? So see, this is an email from Ms. Baker-Cook of AMP to Ms. Zhang of ASIC, and there's two emails. If you look at the email at the bottom of the page, you'll see that it's an email dated the 17th of October 2017, and it says, please find attached soft copies of the following hard copy documents which were produced to ASIC during the meeting between ASIC and AMP yesterday afternoon. And the first document is the letter of instructions from AMP Chairman to Clayton Utz dated 5 June 2017, and the second is the Clayton Utz report.
Yes.
All right. You don't suggest that that's incorrect, that the
No.
instructions weren't provided? Thank you. I tender that document.
Exhibit 2.43, emails, 17 October 17 between Baker, Cook and Zhang, ASIC 0018 0001 3383.
And then can we bring up tab 2 of Mr. Regan's statement, which is the instructions to Clayton Utz? And if we go to page 2 of that document and blow up paragraph 2.1, you'll see it says, on behalf of the AMP board, the CEO and I wish to appoint and instruct Clayton Utz to undertake an external and independent investigation of the above matters. This investigation will be entirely independent of the business and is commissioned exclusively by the board through me and the CEO. You see that there?
Yes.
And in 2.2a, it explains that day-to-day interactions are to be between you and Mr. Salter for AMP with Clayton Utz.
Yes.
And also that any issue of concern arising regarding a GLT or AMP board member, if any issue of concern arises with respect to a GLT or AMP board member, Clayton Utz is to deal directly with Ms. Brenner.
Yes.
Now, you made a reference before to a draft report of Clayton Utz. It doesn't appear as if these instructions refer to the provision of draft reports. Is that the case?
Without reading the document, I couldn't be sure, but I believe that that would be the case, that it wouldn't be referring to draft reports.
To the provision of draft reports?
Yes.
For review by AMP?
Yes.
Because it's supposed to be an entirely independent investigation.
Well, except that there's a process that was undertaken to review various elements for thoroughness and the like.
Do you know how many draft reports were provided by Clayton Utz to AMP?
No, I don't believe I do.
Can we bring up RCD.0002.0001.1170? You'll see this is a notice to produce that was issued by the Commissioner to AMP. If we go to page 2, subparagraph C required any draft version of the Clayton Utz report provided to AMP Limited. Commissioner, I tender that document.
The date of the notice, or the number of the notice to produce, please.
NP 160.
NP.
160.
Notice to produce AMP Limited NP 160 RCD 0002 0001 1170 will be Exhibit 2.44.
Now, can I then show you document RCD.999 ASIC.0013.001. This is a spreadsheet that sets out documents that have been coded as being responsive to various notice to produce categories, and you'll see if we just scroll down a little bit that there is a list of documents starting at row 25 that are documents responsive to NP 160 subparagraph C. Can I suggest to you that Clayton Utz provided 25 drafts of their report to AMP?
I'm not aware of all of those, but that would appear to be the case, yes.
That would what, sorry?
That would appear to be the case, yes, based on what you're saying there.
And can we then bring up RCD? I'm sorry, I should tender that spreadsheet, Commissioner. That's
How
actually
should
an
I
extract.
describe the spreadsheet?
I think an extract of the records from Law and Order of the production of documents in response to notices to produce.
Exhibit 2.45 will be spreadsheet extract recording production in response to notices to produce RCD 999900130001.
Thank you, Commissioner. And then can we bring up RCD.0002.0001.1314? This is a further notice to produce issued by the Commission to AMP, and you'll see there's only one category of documents required by this notice, which is any documents comprising or recording communications between AMP Limited and Clayton Utz in the period 5 June 2017 to 16 October 2017 concerning any draft versions of the Clayton Utz report or the contents of the Clayton Utz report.
Yes.
Have you seen this notice before?
I don't believe so.
I tender that document, Commissioner.
Notice produced to AMP Limited, NP 216 RCD 0002 0001 1314 will be exhibit 2.46.
And then can we bring up RCD.999.0012.0002? Can I explain, Mr. Regan, you may not be aware, that AMP produced its response to this notice to produce in 4 tranches. Are you aware of that?
No.
And so this is just the spreadsheet setting out the response to tranche 1. Commissioner, rather than bringing them up on the screen, they're just going to look like this. Can I just read out what the relevant document numbers are, and I'll tender them as a group for these spreadsheets?
Yes.
The next one is RCD.999.0012.0002. Tranche 3 is RCD.999.0012.0003. And tranche 4 is RCD.999.0012.0004. And I tender those extracts.
The first one is 0001, is it?
Yes.
And they are what? Spreadsheets recording response to notice to produce.
NP 216 subparagraph A, although there is only a subparagraph A of that document.
Exhibit 2.47 will be 4 spreadsheets recording tranches 1 to 4 of production by AMP Limited in response to notice to produce NP 216 being documents RCD 99990012, respectively 0001, 0002, 0003 and 0004.
Thank you,
Exhibit
Commissioner.
2.47.
Now, what those 4 spreadsheets record, I will summarise, Mr. Regan, which is that AMP had located at the time that it finished production in response to Tranche 4, which was very late Sunday night or early Monday morning, 741 documents falling within that category, of which AMP withheld 109 on the basis of legal professional privilege. Were you aware that there was that volume of communication between AMP and Clayton Utz about the contents of the draft report?
No, I don't believe so.
Now, can I then have brought up AMP.6000.0054.6198? So you'll see just as an example of us moving through here that on the 18th of September 2017, Clayton Utz had provided a draft report to Mr. Salter, the General Counsel of AMP, and Mr. Salter had then marked it up with some comments and sent it back. Is that consistent with what you had understood had happened in relation to the draft report?
As I understood it, there was a process between Clayton Utz and AMP to effectively review the document through draft versions to a final.
What does that mean? What was the process aimed at doing?
Well, I think as I indicated before, I believe it's to ensure the thoroughness of the document.
Sorry, ensure the
Thoroughness of the document.
thoroughness.
Yep.
Attend to that document, Commissioner.
Emails between Salter and Mavrakis of 18 September 17, AMP 6000.0054.6198 will be Exhibit 2.48.
Sorry, Commissioner, I just need one moment to get my bundle. Commissioner, I apologise. Could I have... Oh. Commissioner, Could I ask the indulgence of adjourning for 2 minutes while we find
Yes.
the correct document? Thank you.
Let me know when you're ready to go. Yes, Mr. Hodge.
I apologise, Commissioner. Can we bring up document AMP.6000.0054.6294? So you'll see, if we blow up the email at the bottom of the page, this is an email sent on the 19th of September 2017 from Clayton Utz to Mr. Salter, which says attached is a copy of our draft bowler investigation report for provision to the CEO and Group Executive Advice, Australia and New Zealand.
Yes,
So the CEO is Mr. Meller,
that's correct.
and the Group Executive Advice is you.
That's correct.
And do you remember reviewing the draft of that report?
Yes, I believe I do.
And do you remember having marked up any changes yourself to the document?
Yes, I would have.
Do you remember what those changes were?
Oh, no.
Were they substantive changes?
Not substantive changes, but comments. But no, I don't believe substantive changes.
All right. Were you aware of what comments Mr. Meller made on the draft report?
No, I don't think I saw a copy of Mr. Miller's comments.
Okay. And can we then bring up, go to the email at the top of the page and blow that up? You'll see Mr. Salter's reply is, enjoy your break and we'll be in contact on Thursday if there is feedback from Craig and Jack requiring any amendments to the report.
Yes.
Do you recall having participated in a telephone conference with the solicitors from Clayton Utz?
Yes.
And was Mr. Meller also on that call?
He was on the call, yes.
And did that occur on the 21st of September 2017?
It would be about that time.
All right. And what do you recall being discussed during that call about the content of the report?
The content of the report, really not a great deal. I do recall, and it was a teleconference that included, if I remember correctly, Mr. Mavrakis on the telephone and also Ms. Baker-Cook on the call as well. So I think there were 5 people on the call.
Do you recall a discussion during that telephone call about Mr. Meller's name appearing in the report?
Yes, I do.
And what do you recall about that?
I recall, and I think Craig made a comment to the effect that he was declaring a personal conflict in relation to his comment because he was part of a group of people that had been interviewed as part of the investigation about which there was no findings made and or that they were incidental, and these are my words, I can't recall exactly what was said at the time, and asked the question, is it appropriate to include all of those people?
Did he ask for his name to be removed from the report?
No. No, he asked the question as to whether or not it was, well, whether it was necessary for all of those people, of which he was one, to be included in the report.
Do you recall him raising an issue about addressing individuals' culpability?
No.
All right. I tender that document, Commissioner.
Emails between Mavrakis and Salter, 19 September 17, AMP 600-0054-6294, Exhibit 2.49.
Thank you. Can we now bring up AMP.6000.0054.6318? And it's a bit confusing, but this is an email sent on the 24th of September by Mr. Mavrakis of Clayton Utz to Mr. Salter, attaching a revised version of the Bowler report. So this is, I'd suggest, about 3 days after the telephone conference between you and Mr. Mellor and Mr. Salter and Ms. Baker-Cook. You're not certain about the date? Sorry?
And Mr. Mavrakis.
And Mr. Mavrakis. But you're not... Did you agree with me that the date of the call was the 21st of September, or you're not sure?
I wasn't disagreeing.
Okay.
Yep.
Well, perhaps if I... Just to make good that proposition... No, first I'll note, so another version of the report was sent on the 24th of September 2017. You see that?
Yes.
And I tender that document, Commissioner.
Exhibit 2.50 will be email 24 September 17, Mavrakis to Salter, AMP 600000546318.
And can we bring up AMP.6000.0054.6312? This is just to establish the timing. You'll see this is an email sent on the 21st of September saying
Yes.
Craig is running 10 minutes late. I tender that document, Commissioner.
Email Salter to Baker Cook 21 September 17, AMP 6000 00546312 will be exhibit 2.51.
And then can we bring up AMP.6000.0052.0924? So you see this is a draft of the report. This is the track changes version that was sent in response by Mr. Mavrakis to Mr. Mellor. And can we go, I'm sorry, Mr. Mavrakis to Mr. Salter. And can we go to page 6 of that document? I'm sorry, page 6, it's .0932. And you'll see in the earlier version of the document, can we pop out that centre section where the tracking is? The earlier version of the report had said we identified the following additional personnel involved in either the bowler decision-making and or the internal process to report to ASIC following the 2015 breach report. And there had been 4 additional people, the first of whom was Mr. Mellor. Mr. Mellor is the only person who is struck through and removed from the document. Do you know why Mr. Mellor's name was the only one removed from the document?
No, I don't. But what I would add is that in the discussion that was referred to previously, when it ensued, as we went through whether or not other people's names would come out, there was a particular discussion regarding Mr. Mellor being separately advised to the board as having been part of the investigation.
I'm sorry, can you say that again?
So that to the extent that there was a discussion about Mr. Mellor's name being amongst that cohort of people that I referred to earlier, and that's my recollection of the question that was asked, that if his name was not to be in the report, it would only be on the basis that it would be separately advised to the board as to any findings or the nature of the interview with Mr. Mellor.
And so why would Mr. Mellor's name not appear in this report and be separately advised to the board?
I'm sorry, speak up, Mr Hodge, I
What-
lost it.
I apologise, Commissioner. Why would Mr. Mellor's name not appear in this report but be separately advised about to the board?
It was in the context of the question that he asked previously that I discussed with you, and that is where people weren't seen as being central to that investigation, that they would consider taking those names out of the report. But in Mr. Mellor's case, because of the role that he had, that if his name wasn't to stay in the report, then it would be separately referred to the board.
Well, his name was the only name to come out of the report.
So it would seem from that, yes.
I tender that document, Commissioner.
Have we got a date on the mark-up version of the report, Mr Hodge, or some other?
The date is, as I understand it, the 24th of September 2017.
Draft Clayton Utz report 24 September 17 marked up. AMP 6000-0052-0924 will be exhibit 2.52.
Thank you, Commissioner. And then can we bring up AMP.6000.0054.6392? And you'll see what this chain of emails is first an email from Mr. Salter to you and to Mr. Regan. That's the first email in time on the 19th of September 2017. And in that email, Mr. Salter refers to the fact that Clayton Utz are preparing a further advice which will be separate from the report and what will not be disclosed to ASIC. This will deal with whether they believe our conduct involved any breaches of the Corporations Act. And then, now is that the advice that you're referring to? That was to refer to Mr. Mellor?
No.
Okay. And then you'll see that's then being forwarded on by Mr. Mavrakis by Mr. Salter to Mr. Mavrakis so that he can see what had been sent by Mr. Salter to Mr. Mellor and Mr. Regan, and so that Mr. Mavrakis could then deal with providing an email of the draft report to the chairman, Ms. Brenner.
Yes.
I tender that, Commissioner.
Emails between Salter, Mellor, Regan and Mavrakis, 24 September 17, AMP 6000-0054-6392, exhibit 2.53.
Then can we bring up AMP.6000.0054.6489? So this is a chain of emails between Mr. Mavrakis and Ms. Brenner, where Mr. Mavrakis sends a copy of the draft report on the 25th of September 2017 to Ms. Brenner. You see that?
Yes.
And then Ms. Brenner indicates that she's going to speak to Mr. Mavrakis. You
Yes,
see
I
that?
understood that there would be a discussion between Mr. Mavrakis and Ms. Brenner to settle the report when it was eventually so.
I tender that document, Commissioner.
Emails between Mavrakis and Brenner, 25 September 17, AMP 6000-0054-6489, exhibit 2.54.
We bring up AMP.6000.0054.6500. So this is then an email chain between Mr. Mavrakis and Mr. Salter. We're starting at the bottom. Mr. Salter says, Nick, hi, can you please let me know the outcome of your call with Catherine? Also, are we now to assume your report is in final form? Then Mr. Mavrakis says, Catherine and I spoke about several aspects of the Bowler report. That's on the 4th of October 2017. And then later that day, Mr. Salter says to Mr. Mavrakis, I spoke to Catherine earlier today. She said that she relayed a number of comments to you over the phone last week and confirmed that she has no more. Can you please let us have the next draft with amendments marked up today?
Yes.
I tender that document.
Emails between Mavrakis and Salter for October 17, AMP 600000546500, Exhibit 2.55.
And could we then, I'm sorry, just before we do that, can I ask, is this all consistent with what you expected to occur in relation to Clayton Utz's independent report?
So the report was for the benefit of the board, but I think as the letter of instruction refers, there was to be a degree of interplay between business and Mr. Mavrakis. What was clear, though, is that Mr. Mavrakis would settle the report with the board.
I must say I don't understand that at all. Let's go to tab 2 of the exhibits to your document. This is the instructions to Clayton Utz. Can you point us to the part of the instructions which you say envisaged interaction between, I think you used the word business, and Clayton Utz, and that Clayton Utz would settle the report?
Well, I'm just referring to instructions and communications, day-to-day interactions between, and this is at 2.2a.
Let's pop it out, 2.2a. Yes.
And so just very much as it's reflected in that paragraph.
I see. Instructions and other specific communications are to occur between you and Mr. Salter. And this, as you understand it, this is just ordinary instructions and other specific communications.
Yes, yes, that's correct.
Right.
As well as, obviously, then, I think if you go to, at C, the timetable, on page 3, indicative timetable, Clayton Utz will provide regular updates.
On the progress of the investigation.
Yep.
And your understanding is that it envisages the exchanging of drafts with comments and suggestions from AMP?
Well, it certainly evolved into that. I'm not sure really what I expected in terms of the actual process. It was a review that was essentially being conducted by Clayton Utz, and the fact that they were engaging with the business presumably was consistent with their instructions.
You engage, or you're aware of AMP engaging independent auditors to audit the business?
To audit?
To audit. You engage auditors, external auditors, to audit the business?
Yes.
And is it the practice of AMP, when dealing with the reports of external auditors, to get drafts and make comments and changes to those reports?
Well, there is a process that occurs with draft audit reports where they get put to management respond to those. So yes, there is workups involved in the production of external audit reports, internal audit reports. In the case of this particular matter, I think Mr. Mavrakis was seeking to check in and understand whether or not there are any issues that were being missed, and generally speaking, progress the report.
All right. Can we bring up the original Clayton Utz report? I'm sorry, the final Clayton Utz report, which is 6000.0038.0001, or tab 3 to Mr. Regan's statement. And go to paragraph 83 of that document. Now, you see in the final version of the report that there's a sentence that appears there, which is, there is no evidence to suggest that Mr. Caprioli was separately sent this version of the memorandum, even though it was addressed to him.
Yes.
All right. Can we take that down? Can we bring up the document which is AMP.6000.0054.6508? You'll see on the 5th of October 2017 that Mr. Salter sent an email to Mr. Mavrakis, and what he's attached is a version that he has marked up some comments and changes on.
Right.
Do you see that there? See, the last sentence is, can you please consider the attached and the foregoing and now issue your final so that we can distribute it internally?
Yes.
And you see there's an attachment at the top, AMP Bowler Report -4 October.pdf.
Yes.
I tender that email, Commissioner.
Exhibit 2.56, emails between Salter and Mavrakis, 4 October 2017, AMP 600000546508, exhibit 2.56.
And then can we bring up the attachment to that email, which is AMP.6000.0054.6510? And can we go to page .6545 of that version? Thank you. Can we zoom in on paragraph 83 and the comments around paragraph 83? So you see, this is an earlier version of that paragraph we looked at a moment ago, and you'll see that what had originally been said was, it is likely that Mr. Caprioli was shown or provided the information contained in Mr. Morgan's email of 19 May 2015 in the memorandum. And Mr. Salter's markup is to delete likely and say is likely too strong, rather is, open inverted commas, possible, close inverted commas. And you'll see he's added another comment over to the side, which is possible the better term. Do we need to add that there is no direct evidence that Rob saw this information? You see that?
Yes.
Were you aware that Mr. Salter had a particular emphasis on what was said about the knowledge of Mr. Caprioli?
Yes, in the sense that it was the issue we touched on before, where there was a suggestion that Mr. Caprioli was given a copy of the legal advice, and I think that had come through in one of the versions from Clayton Utz, which was, as I understood it, incorrect. So it was a matter of seeking to correct the record.
Then if we go to .6550, you'll see there was a paragraph that read, Mr. Caprioli does not appear to have received any of the internal legal advices. However, he was provided with Mr. Morgan's summary of the Turner 19 May advice email as explained in paragraph 83 to 85 above. And his comment is, are we sure of this? See my earlier comment.
Yes.
Again, you say that's just consistent with Mr. Salter checking the facts?
The only conversation I can remember about the issue involving Mr. Caprioli was related to correcting the issue of whether or not he got the legal advice.
I tender that document, Commissioner.
Exhibit 2.57 will be draft Clayton Utz report with annotations apparently by Salter, AMP 600000546510.
And then can we bring up AMP.6000.0052.1590? and you'll see Mr. Mavrakis. I'm sorry, we've jumped to the wrong date. Can we bring up instead of that AMP.6000.0054.6596? So you'll see a version gets sent back. You can see this in the email at the bottom from Mr. Mavrakis back to Mr. Salter. And Mr. Salter responds and says, "Thanks, Nick. I've marked up a couple more changes on the attached. I'm still not sure we have nailed 83 and 91E. Can you please consider my changes, or am I factually wrong? Can you please reconsider these paragraphs?" And then I tender that document, Commissioner.
Emails between Salter and Mavrakis, 5 October 2017, AMP 600000546596 will be Exhibit 2.58.
Thank you. And then can we bring up AMP.6000.0054.6600, which is the attachment to that email? So this is a further version of the report. If we go to page .6635, you see again, Mr. Salter returns to paragraph 83, and Clayton Utz have already made the change to change likely to possible, and Mr. Salter is suggesting that they further add the words, "though we have no direct evidence on this point." You see that?
Yes.
And then if we go to page .6640, you'll see Clayton Utz had made some changes already, which were to say, Mr. Caprioli does not appear to have received any of the internal legal advices and he cannot recollect receiving them. And then they've deleted the words, and he was provided with Mr. Morgan's summary of the Turner 19 May advice email. And then over the page, .6641, you'll see Clayton Utz had added some attempted qualifications to these changes, which were to say it is possible that Mr. Caprioli was shown or provided the information contained in both Mr. Morgan's email of 19 May 2015 and the memorandum attached to it. He received an email from Mr. Morgan on 20 May and a memorandum attached to it, both of which set out Mr. Morgan's summary of the Turner 19 May advice email. And as is apparent from the comments, Mr. Salter had some changes he wanted to make to those. You see that?
Yes, only from what I know from your document.
He wanted to remove the second subparagraph and again add the qualification, though there is no direct evidence confirming this, to the first subparagraph. You see that?
Yes.
And again, just so I understand, this is interaction consistent with your understanding of how an independent report would be prepared?
Well, I think it turns on what Mr. Mavrakis is comfortable with, but I wasn't aware of this degree of interaction between Mr. Salter and Mr. Mavrakis on this particular point.
And are you comfortable with this, now that you know about it?
I think the key thing is that the report needed to be correct. I think Mr. Salter and Mr. Mavrakis were looking to ensure that it was thorough, but at the end of the day, the judgment about the independence of it, I think, rests with Mr Mavrakis and the board.
Well, nobody could be in any doubt. No reasonable person could be in any doubt that Mr Salter was seeking to minimise the extent to which it was said that Mr Caprioli had knowledge of the legal advices. Agreed?
That's the tenor of those comments, yes.
I tender that document, Commissioner.
Draft Clayton Utz report with annotations apparently by Salter, 5 October 17, AMP 600000546600 will be Exhibit 2.59.
And then can we bring up AMP.6000.0054.6687? So you'll see what's happened in response to those earlier emails is that Mr Mavrakis has sent through a marked up and clean version of the relevant pages. You see that's the email of the 5th of October 2017.
Yes.
And Mr Salter's response is, thanks Nick, I'm not sure all this extra detail helps with the proposition I want to get across, that there is no evidence that Rob saw the relevant memorandum from Justin Morgan. In any event, please see the attached comments and suggested amendments. You see that?
Yes.
And then I tender that document, Commissioner.
The 2.60 emails between Salter and Mavrakis of 5 and 6 October 17, 600000546687.
Can we bring up the document that is AMP.6000.0054.6692? You'll see these are the track changes pages that have been sent through by Mr Mavrakis and then have had comments placed on them by Mr Salter, and that was the attachment to the last email, or this is the attachment to the last email we looked at. So if we go to page .6694, so you can see from the tracking, this is all this extra detail that has been added by Clayton Utz, and you'll see that what Mr Salter asked be put in there is no evidence to suggest that Mr Caprioli was separately sent the memorandum even though it was addressed to him. And you know, don't you, that that's the language that's used in the final report?
I can't recall the words of the final report, but I'll accept what you're saying.
Right, we'll come back to that. And then if we go over to page .6696, you'll see again there's the sentence had been, when the opening statements in both of these emails are read together, it is possible that Mr Caprioli was shown the information contained in Mr Morgan's 10:42 PM email of 19 May 2015, or the substance of that information was discussed with him. And Mr Salter has suggested a change, which is to delete when the opening statements in both of these emails are read together, and instead put the words at the end of the sentence, there is no direct evidence on this point. I'm sorry, though there is no direct evidence on this point. You see that?
Yes.
Now I tender that document, Commissioner.
Drafts sent by Salter to Mavrakis attached to Exhibit 2.60, AMP 600000546692 will be Exhibit 2.61. Now, I'll ask you again, you obviously hadn't seen this document earlier. And again, is this consistent with your understanding of how an independent report would be prepared?
I agree there's a lot of exchanges there. Again, it would be up to Mr Mavrakis to decide on the degree of independence.
Does it seem unusual to you to have the General Counsel saying to the external solicitors for their independent report, I'm not sure all this extra detail helps with the proposition I want to get across that there is no evidence that Rob saw the relevant memorandum from Justin Morgan? Does that seem unusual to you?
Well, there was clearly a dialogue on this issue going on between the General Counsel and Mr Mavrakis. I can't really account for what's exchanged between them other than what you're showing me on those documents.
All right. And then those emails were the 6th of October. Clayton Utz think that they have sent the final version of, or send the final version of the report on the 6th of October. Are you aware of that?
I can't recall the dates.
Right, I'll show you those documents. Can we bring up AMP.6000.0062.7501? So you see this is an email from Clayton Utz to Ms Brenner, which says, Dear Catherine, we refer to your letter of instructions to undertake an independent investigation. We enclose our letter and final AMP Bowler investigation report dated 6 October 2017. And I tender, what I might do, Commissioner, is there's 3 documents I'm going to bring up. I'll tender them as one exhibit. The second document is AMP.6000.0062.7502. So you'll see this is the signed letter on the 6th of October saying we enclose our final report, which sets out our findings arising from the investigation.
Yes.
And then the third part of the document is AMP.6000.0062.7503, which is the actual report.
Yes.
So that is, or thought to be by Clayton Utz, the final report. I tender that, Commissioner, as an exhibit.
Bundle of documents relating to final report comprising email Mavrakis to Brenner submitting final Bowler report 6 October 17, AMP 6000.0062.7501, letter Clayton Utz to Brenner AMP 6000.0062.7502, and report AMP 6000.0062.7503. Together those are Exhibit 2.62.
Now, on that last document that we looked at, which is .7503, can we bring up page .7557? Right. So you'll see, no, zoom out, please. You'll see what paragraph 145 is there. It begins, further Mr Guggenheimer's conduct as highlighted above at paragraph 143. Can we now bring up on the other side of the page AMP.6000.0038.0001? Sorry, it's tab 3 to Mr Regan's statement. Page 55 again. So you see this change, which is the paragraph numbering next to the paragraph further Mr. Guggenheimer's conduct as highlighted. That paragraph number has disappeared and there's now a new paragraph 145 which says, for completeness, Mr. Craig Miller, CEO, confirmed to us that he was not aware of the 90-day exception and ring fencing and that he did not receive nor was he aware of any of the legal advices referred to above either before or after the 2015 breach report. This is supported by our investigation and we come to the same conclusion.
Yes.
See that? Were you aware that an earlier final report had been submitted that did not contain that paragraph?
Yes.
And are you aware of how it is? I'm sorry, were you aware at the time? At the time, when the reports were finalised in October 2017, were you aware?
So I'm missing
The
the
fact
question.
that there was a final version of the report that was submitted that did not contain this paragraph.
Yes.
All right?
That was the version I got initially.
I see. And are you aware of how it is that that paragraph came to be included?
Not entirely, other than to say that at the board meeting and the board pack of, I think it's the 16th of October, there were a number of changes, as I recall, that were submitted as part of the version that the board finally approved.
And can we, well, I'm sorry, are you saying the board met and approved changes to the report?
I believe there was a paper submitted to the board on the 16th of October, I think that's the correct date, where they approved a final round of changes, which I believe includes that paragraph. But there were, if memory serves me, I believe there were other changes as well.
Why would the board be approving changes to an independent report?
Because it was a report being accepted by the board.
All right. Can we bring up AMP.6000.0054.6720? So this is an email sent by Mr. Salter to Mr. Mavrakis on the 11th of October 2017 after receipt of the apparently final report, and you'll see Ms. Brenner has made a number of comments that she would like to see incorporated into the report to be handed to ASIC on Monday. And the second point is include a statement to the effect that Craig Miller was unaware of the practices or their illegality. You see that?
Yes.
Were you aware that Ms. Brenner had asked Mr. Salter to make a request to Clayton Utz to change the final version of their independent report? You weren't aware of that?
I don't believe so, no.
Is that behaviour consistent with your understanding of how an independent report would be prepared?
Well, again, I think it's a matter for Mr. Mavrakis and the board to settle.
I tender that document, Commissioner.
Number 2.63, email Salter to Mavrakis, 11 October 17, AMP 600000546720.
And then can we bring up AMP.6000.0054.6765? You'll see this is an email from Ms. Brenner to Mr. Salter and copied to Mr. Mellor. It asks for draft script talking points for the meeting with ASIC, and it says, has Clayton Utz now included in their report that we will give to ASIC their findings on Craig?
Yes.
Do you know why you weren't copied to that email?
No.
Does it seem unusual to you, given that you were, according to the instructions, one of the two people to have day-to-day dealings with Clayton Utz?
The report was substantially settled via the board and the General Counsel and Clayton Utz in the weeks leading up to that final report.
And you'll see then Mr Salter forwards that request on to Mr Mavrakis.
Yes.
All right, attend to that document, Commissioner.
Emails between Brenner, Salter, Mavrakis, 15 October 17, AMP 600054 6765 will be Exhibit 2.64.
Can we bring up AMP.600054.6503? So at this stage, so this is an email sent about a week before the emails we're now looking at. Mr Salter sends an email to Mr Medcraft and Mr Kell. You weren't copied to that email, but were you aware of it being sent?
I couldn't recall,
Okay.
Mr Hodge. I
And
believe so.
but what is said is you'll recall that Catherine and I mentioned to you earlier in the year that the AMP Limited Board had instructed Clayton Utz to undertake an independent investigation of, in brief, the circumstances behind the continued charging of ongoing service fees to certain of our advice customers while they were in what is known as our buyer of last resort or bowler pool. Obviously, you can see that there now.
Yes.
And that message, which is we've retained or instructed Clayton Utz to conduct an independent report, that's consistent with what you recall being said at the later meeting to ASIC on the 17th of October.
Yes.
Attend to that document, Commissioner.
Email Salter to Medcraft, Brenner and others, 4 October 17, AMP 600054 6503, Exhibit 2.65.
Can we bring up AMP.6000.0054.6587? All right, let's try AMP.6000.0054.6711. Now we can skip over that. Can we go to AMP.6000.0054.6720? We've looked at that already. AMP.6000.0062.7767.
Recipe as before, I think.
Yes. Can we bring up just want to get the numbers right, Commissioner, rather than, as it's now being suggested by Mr Crutchfield, just guessing.
Previously said I won't call bingo.
Sorry, Commissioner, I'll just need one moment. All right. Can we bring up AMP.6000.0052.1590? So you see what Mr. Mavrakis sent back as this discussion goes on about Mr. Mellor is, on including Craig in the report, we had previously removed his reference in the interview list to interviewing him on the basis that it would attract unnecessary attention to him by ASIC, given that we found he was not aware of the 90-day exceptional ring fencing and he was not involved in the communications with ASIC after the breach report. We instead included it in the summary of the legal advice. You see that there, Mr. Regan?
Yes.
Now, as I understand it, that doesn't quite reflect your recollection. You didn't realise that his name was being excised so as to avoid attention from ASIC.
There was a discussion regarding the sensitivity of the name during that meeting that I referred to.
Sorry, is this the telephone conference?
Yes. That was part of the consideration.
So part of the... Go on.
That's not my recollection, though, of why it was being taken out. So I have a different recollection.
All right, I tender that document, Commissioner.
Email Mavrakis to Salter, 15 October 17, AMP 600000521590, Exhibit 2.66.
I should indicate, Commissioner, I expect in due course there'll be the standard non-publication direction made with respect to that email to redact the actual email addresses.
Yes. The personal contact details, the email addresses in particular, will be redacted. I'm sure the press have no great interest in publishing those, but can I just indicate that there will be a non-publication direction about those things?
And then can we bring up AMP.6000.0062.8488? So you'll see there's then an email sent back by Mr. Mavrakis to Mr. Salter later that afternoon, which says he proposes to add an additional subparagraph 92J as set out below, and at that stage Mr. Mavrakis's proposed wording is, for completeness, Mr. Craig Mellor, CEO, confirmed to us that he was not aware of the 90-day exception and ring fencing and that he did not receive any of the legal advices referred to above either before or after the 2015 breach report. This was supported by our documentary review. You see that there?
Yes.
Now, you know that's not the words that appear in the final report. Would you like to see that again? Let's bring up tab 3 to Mr. Regan's statement and go to paragraph 145. It's page 55. You see, rather than it stopping at this was supported by our documentary review, it's made even stronger. This is supported by our investigation and we come to the same conclusion.
Yes.
And do you know how that change happened?
No.
Can I show you AMP.6000.0054.6768? So you'll see Mr. Salter responded to that earlier email from Mr. Mavrakis and said, I'm not sure this is the right section. Of course, Mr. Mavrakis had suggested 92J. And Mr. Salter says, I suggest you combine 144 and 145 into a single paragraph and add a new 145. I've made some changes below. And if we look down in the text of the email, we see that Mr. Salter has now revised the words so that Clayton Utz's conclusion is to be, this is supported by our investigation and we come to the same conclusion. Can we put that up on one side of the page and on the other side of the page bring up the Clayton Utz report, tab 3 to Mr. Regan's statement? And you see then it's Mr. Salter's words that go in as paragraph 145 of the Clayton Utz report.
Yes.
I tender that email.
Just before you leave that, you say there, Mr. Salter's words. Why do I conclude that from the document on the left?
You'll see, Commissioner, on the left he says, I suggest you combine 144 and 145 into a single paragraph 144 and add a new 145. I've made some changes below, and in the way of the forwarding of emails, he's changed the text of the email in that is subparagraph J, and we can also, if it's helpful, I can bring up the preceding document where we can see that.
Emails between Mavrakis and Salter, 15 October 17, AMP 600000546768, and the earlier one too, Mr. Hodge.
Yes, I'm sorry,
AMP
Commissioner.
600000628488.
Yes, Commissioner.
Together
Thank you.
become Exhibit 2.67.
Thank you, Commissioner. Now, having seen these emails, Mr. Regan, is this consistent with how you would understand or how you understand an independent report should be prepared?
Again, I think it's Mr. Mavrakis' decision in relation to that, along with the board.
I'm not sure I quite understand that proposition. Why is it the decision of the board as to what goes into an independent report?
From what I can see and from what I can understand from the documents, that's the way the report was settled.
But you understand the board gets to settle the report.
Well, Mr. Mavrakis is having to agree with that, of course.
And do you maintain here today that you still regard this as an independent report?
Well, so far as Mr. Mavrakis is declaring it to be his independent report, yes.
I see.
I
And
think it's for me to determine the independence of the report.
And do you feel any discomfort at having met with ASIC and said to them this is an independent report in light of what you've now seen?
There is a level of discomfort, yes.
And that's because, from your perspective looking at it, the report appears far less than independent of the company. Do you agree?
There is a significant amount of interchange between the company and Mr. Mavrakis in relation to the report.
And a significant interchange between the most senior people within AMP and Mr. Mavrakis,
That's correct.
where, can I suggest objectively, Mr. Mavrakis could not have been in any doubt whatsoever as to the outcomes that were desired by those most senior people in the report.
That's up to Mr. Mavrakis to determine.
And are you aware of the conclusions of the report having been relied upon by Mr. Salter in communications with ASIC?
I'm not sure I can speak to the communications between Mr. Salter and ASIC.
All right. Commissioner, I don't have any further questions for this witness.
Does any party other than AMP seek leave to cross-examine Mr Regan? No? Mr Crutchfield?
Just a couple of short questions, if the Commissioner pleases. Mr Regan, yesterday you were asked some questions about, and Commissioner, this is at transcript 1076, line 10, you were asked, all right, so are you acknowledging, is AMP acknowledging that it has failed to act honestly, fairly and efficiently in relation to the charging of fees for no service? And you said, yes, we have. Then we're asked, sorry, when you say yes, we have, are you aware of ever having done it before now, this very moment when you've done it? And you answered, yes, I'm uncertain. Do you recall saying that, Mr Regan? Could I ask Mr Regan to be provided with, please, tab 24 of Mr Regan's exhibits?
Well, he has those in the box, yes.
Do you have? Could you
have
go
your
to tab
exhibits in the box,
24?
don't you? Tab 24 to your statement.
Yes, I do, Commissioner.
Could you go to that, please? Tab 24.
I have that tab.
You have that? That's a breach notice that AMP gave to ASIC on the 27th of May 2015, is that correct?
Yes.
If you go to page 3, and under the heading legislation breached,
Yes.
do you see, yes, someone's, thank you for helpfully putting it up on the screen so we can see it. You see AMP Life Limited and its subsidiary NMLA as administrators admitted to a breach of section 912 capital A, 1A of the Corporations Act. Do you see that in the second paragraph?
On the screen, Mr.
On the
Crutchfield?
screen, yes.
Yes.
And you see the first paragraph by the advice licensee, section 12D subsection 3.
Yes.
And by ASL and NM Super, section 912A1A of the Corporations Act, and a provision of the SIS legislation, and then separately MMT of 912A1A of the Corporations Act. Do you see that?
Yes.
Does that refresh your memory about AMP having previously acknowledged that it had contravened, amongst other things, section 912 capital A 1A of the Corporations Act?
Yes.
If you go, please, to a few tabs on, tab 29. That should be another breach notice that AMP Financial Planning Proprietary Limited gave to ASIC on the 5th of December 2016.
Yes.
And you see in the first paragraph we set out below information regarding a breach of section 912 capital A 1A of the Corporations Act and a provision of the ASIC Act as well. If we go forward to the next tab, sorry, one more tab, tab 31, Mr Regan.
Yes.
Again, a similar acknowledgement by AMP in the first paragraph of the letter to ASIC of the 3rd of May 2017.
Yes.
Do you see that?
Yes.
And finally, tab 32, a similar acknowledgement in the breach notice given to ASIC on the 8th of June 2017. Do you see that?
Sorry.
That's on.
Yes.
I'm sorry, I'm going too quickly.
That's
probably. Tab 32.
Yes.
These notices refresh your memory about AMP having previously acknowledged that it had contravened relevant provisions of the Corporations Act and the ASIC Act in relation to the 90-day exception and
Yes.
other matters we've been talking about. Now, separately, can I ask you, you were asked a lot of questions about the Clayton Utz report, do you recall after the board received the Clayton Utz report that the board constituted a board committee to work with a subcommittee of the general leadership team to oversee and implement a program of work to address the issues arising from the Clayton Utz report?
Yes, the group leadership team.
Yes, group lead, thank you. Now, was that program of work supervised by anybody?
Are you referring to the fact that we've appointed an external independent to be involved in that work?
You have done that, have you?
Yes, we have.
And who is that?
Mr. Alan Cameron.
And are you able to tell His Honour what other work?
No more, Mr.
Apologise.
No more.
Tell the Commissioner what other work is ongoing after the board subcommittee received the Clayton Utz report. What else has AMP done in response to that report?
With permission, as far as the program of work is concerned, that's the Advice Business Review program that I alluded to earlier.
Yes.
In summary, we've compiled approximately 18 independent reviews from relevant experts to assist us in ensuring that we've got a fit-for-purpose business going forward.
Okay, thank you. Now, moving to another topic, Mr Hodge took you to many communications with ASIC where AMP described the administrative error that had led to charging fees for no service. Do you recall
Yes.
that? Can you tell the Commissioner whether or not an administrative error or administrative errors were the cause of some of those cases where fees were charged for no service?
I understand that to be the case.
If you've got your statement there, Mr Regan, could you go to paragraph 170? Do you have that there, Mr Regan?
Yes, I do.
Now, are you able to say how many instances of the 90-day exception there were?
I understand there were 39.
Out of how many bowler transactions?
2,417.
Are you able to say roughly what proportion of customers were charged fees as a result of the 90-day exception?
13%, I believe.
And as a result of ring fencing, you able to say?
No, I just can't bring that number to mind at the moment, but it's a much reduced number. I think as a percentage, I think there's about 1,000 to 1,500 customers that were affected by the ring fencing practice.
Could you go to paragraph 335 of your statement, which is page 61?
Yes.
Now, that figure in 335A, just read that to yourself. The failure of AMP advice licensees to terminate OSFs in the context of relevant buyback arrangements to date, approximately 14,095 customers have been identified.
Yes.
Now, are you saying that figure, you think that figure is correct or not correct?
Well, you're inviting your witness, are you, Mr. Crutchfield, to go back on his adoption of his statement earlier? Is that what you're inviting him to do? Because if you are, you need to tell him that that's exactly what you're having him do. He's pledged his oath to this. Do you want him to go back on it now, do you?
Well, Commissioner, in light of the witness's previous answer and the corrections that he made to this section yesterday, I just want to make sure that you, Commissioner, have the evidence.
Matter to you, Mr. Crutchfield. I raised it with you, and it's a witness for whom I think AMP has primary responsibility. Yeah, go on.
Mr Regan?
So could you just help me out, Mr. Crutchfield?
Yes, look at 335 A.
A, yes.
Do you think the figure in A is correct? Number of customers.
The 14,095. Without having the other document in front of me, it's just a little difficult to tell, but I think that's the correct number.
Yep. Okay. Now, you were asked some questions about the Clayton Utz report, and you were taken to emails where Clayton Utz have referred to a summary of the legal advice as opposed to the Clayton Utz report itself. Are you aware of the distinction between those two documents?
These are the two documents prepared by Clayton Utz?
Yes. What were those two documents?
So there was the Clayton Utz report, and then there was a separate confidential or privileged advice in relation to the implications of the findings?
Yes. All right. Thank you. Thank you, Mr. Regan. Commissioner, please.
Is there anything arising out of that, Mr. Hodge?
No, Commissioner.
Thank you, Mr. Regan. You may leave the witness box.
Thank you, Commissioner.
In view of the evidence given by Mr. Regan, there may be some question about what conclusions, if any, I may reach about the extent to which senior management or others associated with AMP sought to influence or did influence the content of the report by Clayton Utz, apparently submitted to ASIC as an independent report. It is a matter for AMP and its advisors whether it seeks to have some opportunity to provide any material which goes beyond the evidence given by Mr. Regan about that matter and the documents that were tendered in relation to it. Very well.
Commissioner, I know the time. Could I just correct one matter from yesterday before we rise? Yesterday there was a statement tendered by us as counsel assisting, provided by Mr. Bradley Green, who is the Director of Advice and Research at AMP. And in summarising that statement, we referred to a spreadsheet setting out the proportion of in-house products on the approved product lists of AMP's licensees and the proportion of funds of new customers invested in those products. We said yesterday that AMP had not provided the spreadsheet until after 9:30 p.m. on Sunday night. In fact, AMP had first provided a copy of the spreadsheet to the Commission by email after 5 p.m. on Wednesday the 11th of April and provided a further copy of the spreadsheet after 9:30 p.m. on Sunday night. We have now reviewed the further copy of the spreadsheet. It contains information about 4 of AMP's licensees: AMP Financial Planning, Charter, Hillross and IPAC. We won't summarise the position for all 4 licensees. However, in relation to the largest licensee, AMP Financial Planning, it shows that in each year since 2013, between 35 and 40% of the investment options on the approved product list were in-house products. More than 90% of new customers invested funds in or paid insurance premiums in respect of one or more of AMP's in-house products, and the proportion of funds invested in or insurance premiums paid in respect of AMP's in-house products as opposed to external products by new customers was more than 70%. In summarising the statement of Mr. Green yesterday, we also referred to 5 particular incidents of prohibited conflicted remuneration that were disclosed in Mr. Green's statement, and we had selected those 5 incidents as examples of 13 incidents of prohibited conflicted remuneration disclosed in Mr. Green's statement. We said that AMP had not disclosed any of the 5 incidents in its submissions to the Commission earlier this year. AMP has drawn our attention to one part of its schedule containing further details of misconduct or possibly misconduct still under investigation, which AMP provided to the Commission in February of this year to supplement the matters that it had already disclosed. And AMP included 2 entries in that table which they believe disclosed in general terms 3 of the 5 incidents that we referred to. In both entries in the schedule, AMP identified that there had been issues relating to the possible failure of licensees to take reasonable steps to ensure that representatives did not accept conflicted remuneration. Both entries stated that these issues related to circumstances where practices had been provided with the offer of a waiver of paraplanning costs, and that the issue had been identified in July 2015. No reference was made in either entry to the number of customers affected or the quantum of prohibited conflicted remuneration provided. AMP therefore did disclose in general terms 3 of the 5 examples of the 13 incidents of prohibited conflicted remuneration identified in the statement of Mr. Green.
Thank you for making that correction.
Thank you, Commissioner.
Yes. 9:45 tomorrow, I think.
Thank you,
Mr.
Commissioner.
Hodge, or is there a point starting now?
I'm happy to start at 9:45 tomorrow.
9:45 tomorrow?
Thank you.
9:45 it is.